Your Lord, inclusion, please mention next week. Too many matters we have already included.
Like yesterday mentioned, this was the order passed by the Honorable Chief Justice.
Keep it with you. When you
Your
take up,
Lordship,
when you take up the matter, we'll see it.
No.
Call on the list.
Well,
Lordship.
Your Lordship wanted to see the order.
We have to be.
Well, Your Lordship.
Mr. Chari, what is the urgency?
It's party order. They've thrown us out, and now they have started construction.
Mr. Chatterjee, wait for a few days. Wait for a few days.
Your Lordship,
This not right now.
The list.
No, it's in the list.
Yes.
Upgradation, please mention next week, please.
Lordship, the urgency is that the House.
Well, this was the order.
This was the urgency.
Call on the list. No.
I'm not mentioning.
One we are passing the order. Accordingly, WPLT 54 of 2026 is allowed on contest, thereby modifying the impugned order dated November such and such, passed by the fourth bench WPLT, to the extent that the respondent authorities shall remain restrained by an order of injunction from giving effect to the order dated September 12, 2025, passed by the respondent to the DLLRO, as well as the order dated such and such, passed by the block land and land forms officer, and or from disturbing the peaceful possession and enjoyment of the petitioners in respect of the subject plots till disposal of OA 2870 of 2025 LRTT. It is made clear that the above observations are tentative in nature and shall not unnecessarily influence the final adjudication of the original application. It will be open to all parties to argue all questions involved in the original application, including the effect of the orders passed in connection with the public interest litigations and the connected matters on merits. No orders to cause urgency required cause. পরে ফাইলটা রেডি দেখো ভুলভাল ফাইল দেবেন
My lord, I am appearing on behalf of the appellant, my lord.
Yes.
My lord, I am praying for 7 days, my lord, leave.
On the prayer of learned counsel for the appellant,
Grateful.
the time for filing depositing deficit court fees is extended for a week from date. Full stop. In default, the matter be listed under the heading Laws for final orders.
Grateful, my lord.
Next.
That's preferred.
Number 3, my lord, I am for the appellant.
I appear for the respondent number 3, man.
Right. Yes. What is the matter? Yes. Move your matter.
My lord, in this matter, primarily the writ petition was filed challenging the actions of the respondent authorities in demolishing the structures where I am residing without giving me any notice, without giving me any hearing.
Has been demolished.
No, my lord, it has not been demolished, but they were demolishing, my lord, and partly some of the structures has been demolished. There are 52 petitioners in this matter, in this writ petition, my lord. Where
Proceeding was drawn up under the Public Premises Eviction Act, 1971 Act.
My lord,
Was there any proceeding under the 71 Act?
I say, my lord, there has to be a proceeding under Public Premises Act.
Was it dealt with by the learned single judge?
My lord, may kindly comes to the impugned order, my lord.
So what was your prayer in the writ petition?
Well, my prayer was that
no eviction without due process of law.
They may not demolish the structures, and they may first the estate officer before the estate, and they may evict or demolish the structure.
According to you, there is no proceeding under the
proceeding, no notice.
How is it dealt with? Yes.
Lord, may kindly comes from paragraph number 13, page number 4 of the impugned order, from where the observation of the learned.
Right.
So judge starts.
Mr. Nag, you are for the port. And you are for the. How are you, port? Yes. Right.
Paragraph number 13. But this court has meticulously gone through the entire materials as placed before this court. This court
Public Premises Unauthorized Eviction Act, 1971. Eviction of Unauthorized Eviction Act.
Yes. I have 2 copies.
Yes. If necessary, if you don't find, then we'll take from you. Yes, please continue.
So this court has meticulously gone through the entire materials as placed before this court. This court has given due consideration over the submissions of the learned advocates for the contending parties.
The sections are quoted also here.
Yes, my lord. For the effective adjudication of the instant lease, this court at the very outset proposes to look over to the provisions of sections 2G of the 1971 Act. My lord, I may not go into that. My lord.
Yes.
Then, my lord, section 4 and 5 is quoted.
Right.
My lord, I will be coming to this latter words, my lord. Keeping in mind, my lord, paragraph number 15. Keeping in mind the aforesaid legislative provisions, if I look into the factual matrix as involved in the instant writ petitions, it appears to this court that in paragraph numbers 2, 4, and 5 of the instant writ petition, it has specifically been contended on behalf of the writ petitioners that the present writ petitioners are occupying various residential quarters, dwelling units, and structures wherein the respondent authorities made an endeavor to carry out a demolition proceeding. From annexes to the instant writ petition, it reveals that a bunch of photocopies, Aadhaar cards have been filed to show that writ petitioners' addresses are at these headquarters residential units. As this juncture, if I look to the supplementary affidavit as filed today on behalf of the writ petitioners, it would reveal that in such supplementary affidavit, the writ petitioners have indicated the respective portions of the building in which they were residing. On perusal of the second paragraph of the order dated 15/6/2026 as passed by the coordinate bench of this court, in connection with the instant writ petition, it reveals that the said coordinate bench directed the writ petitioners to indicate in the supplementary affidavit with regard to their authority also to occupy the said premises. In course of the hearing,
Apart from the, we have seen, apart from the Aadhaar cards, what did you produce to show your position?
nothing. Only
Only
Aadhaar
Aadhaar cards, no electricity bill, nothing.
Why electricity bill was not there? Because it was a bus area, there was block meters. I have inquired from my client.
So that you would have produced, the block meter papers or whatever.
The block meters.
You must have paid something and got a receipt for the block
50,
meters.
there was a conjoined bill of 50,000. I have that, but since that was
If you reside in a particular portion, you said it's a residential area, so you must have something to show you have transactions from that, your bank account in that address. Nothing you have produced, disbelieved on fact by the learned single judge.
They have may only.
We agree with you. There are two categories envisaged in the definition of unauthorized document. One is they had a judicial relationship which was severed, and one who is entirely unauthorized. You may fall within the second category. But you have to show something regarding possession. Only Aadhaar cards anybody can get.
May only one thing, the Aadhaar cards can also be a valid proof because on authentication.
Aadhaar card, we are not saying you are not citizens of India or something.
I'm not,
not something so high.
The Aadhaar
See, Aadhaar card is on the basis of a unilateral statement before the authorities that I reside here and no verification is done for Aadhaar card.
Denied my occupation, They was not denied my occupation,
Was any
there was no affidavit from their
no opposition
no
file.
opposition file from there.
That stage was not reached. See, first you have to cross the first hurdle. The burden is on you. You have to discharge your owners by showing that there is something to show you're in occupation. Then the burden shifts on them, right? So you produce only your Aadhaar cards, which has been held by the learned trial judge. That is not sufficient proof. If I reside in an area, I have some transaction, electricity, bank account, whatever.
I may point out, all of them do not have bank accounts, All of them do not have bank
How
accounts.
many of you?
Of them are there.
So one or two could have been produced.
I have
bank accounts you may not have. You may have something else. Block meter if you are enjoying.
Meter,
block meter you also have to pay.
I have electricity bill, but since that was not produced with the read code, I did not annex it before your lordship.
You have annexed here.
No, I have not annexed since that was not produced with the read code. But my records and submission, I have the electricity bill, meter bill.
At this stage, in the appellate stage, it was not before the read code. How can we look at it? You have not even annexed in your. You could have annexed and said that no, these were not produced in the read code, and you could have pointed out that these are there.
It is there,
on submission from the bar, how can you? It is not before us also.
And may kindly seize one thing,
Why should we look into those? Your position itself, the foundational fact is your position. If that is not proved by you prima facie, only Aadhaar cards won't do. And that is one of the plausible findings.
The Aadhaar cards are issued after due verification of the addresses, I have the Aadhaar Act, Aadhaar Act says that Aadhaar cards are issued, may kindly seize one.
What was the act?
I have only.
I
have only one copy.
Which act? Which section?
Aadhaar card.
Which section?
May kindly come.
Verification.
Section 2K first, 2K. May kindly 2K,
2K, yes.
The definition of demographic information is there, Demographic information includes information relating to the name, date of birth, address, and other relevant information of an individual as may be specified.
Let us see how the process of issuing.
Now, may kindly comes to one more definition, 2V.
Yes.
Resident means an individual who has resided in India for a period amounting in all to 182 days or more in the 12 months immediately preceding the date of application for enrollment. Now, may kindly comes to 3.
Resident in India is different.
No,
not in a particular address.
No, I decide on
demographic information includes address.
Includes address.
Let us see now.
Kindly comes to section 3, Aadhaar number.
Yes.
3.1. Every resident shall be entitled to obtain an Aadhaar number by submitting his demographic information and biometric information by undergoing the process of enrollment. Provided that the central government may from time to time notify such category of individuals who may be entitled to obtain an Aadhaar number. Now, may kindly comes to subclause 3, directly. Yes. On receipt of the demographic information and biometric information under subsection 1, the authority shall, after verifying the information in such manner as may be provided by the regulations, issue an Aadhaar number to such an individual. So, my lord, there is a rule also, my lord, for authentication of the demographic information. So, after verification of my demographic information, only the Aadhaar number has
You
been
see, a
issued.
presumption is raised about your address.
My lord, and my lord, they have first of all, my lord, and secondly, my lord, they have not issued any kind of notice, my lord. They being the statutory landlords, in fact, my
No,
lord,
provided if you are in possession,
my lord,
then the rest follows.
my lord, so my lord, my address after verifying
But
my
if your address, if your residence is not proved, then no notice is required, nothing is
no,
required
my
to
lord,
you.
I received, my lord, demographic information, the address comes within demographic
Understood.
after
So
verifying.
this is your best case basically now.
My lord,
Let us hear Mr. Nag. Yes, Mr. Nag.
Now, my lord, here, even from the cost title, it will
Yes.
appear. My lord,
Yes.
I kindly have a look at the cost title. My lord, the background is, my lord, this was the quarters which were given to, my lord, Calcutta Dock Labor Board. The workers of they used to reside there. My lord, thereafter, the property was handed back to Port Trust. Now, my lord, the situation of the building is that even Deputy Commissioner of Police asked me to demolish that because anybody, any day, anything can happen. Normally, in these circumstances, when my lord, the process of demolition and miking was going on, this writ petition came. Now, my lord, from the cost title, it will appear that, my lord, the cost title lordship sees 20 or 25 showed Aadhaar card in respect of that address. Even others are not there. Lordship sees from the beginning. First is CPT quarter, Garden Reach.
What
Second,
is this address? The
it is CDLB quarter. That is the petition number 3.
3, 4, yes.
Yes. So, my lord, will find 1, 2 not there. My lord, 3, 4 there, 5 there. Then again, lordship will find 6 CPT quarter. Is it Port Trust quarter? Is a different thing. Then, my lord,
Yours is CDLB quarters. This is
CDLB. Now, my lord, lordship says now, if lordship scrutinize, my lord, as far as my recollection goes, only in respect of 20 to 22 is even issued the submitted the Aadhaar card before the writ court. Now, my lord, lordship is absolutely correct. Now, my lord, kindly come to the reasoning and where the definition is there. That minute. Thereafter, my lord, kindly have a look at impugned order, page 5. My lord, the unauthorized, his point is that I have to initiate a proceeding. But, my lord, the unauthorized definition is included in the order. Unauthorized occupant in relation to any public means the occupation.
yes, is obviously.
So,
Actually,
this
the
is the thing.
occupation.
Now, my lord, he said I have not taken the point. Now, kindly come to page 136. This is the specific point I have taken. 11.6 is at page 136. The first order. When, my lord, an interim order was initially passed in his favor, it's not that protection was not given. Yes, a minute.
136, yes.
Yes. The petitioner alleged that without initiating a proceeding under 130 1970 Act, authorities have started demolishing the property wherein petitioner Mr. Nag, learned advocate appearing from the Port Trust, seriously disputes, drawing attention court to the address as mentioned in the writ petition. Mr. Nag submits that most of the writ petitioner are not residing in the premises. This question submits that since the building in his suggestion crumble down any point of as well as such and such. So, in support also places upon building inspection report, let a copy of such and such. Now, my lord, interim order. Then, my lord, next order 138 is very important. The first paragraph there is a
Yes.
appearing for the Port Trust authority submits in question 30 blocks remaining such and such on query of the court specific portions where the petitioner are deciding and their authority to occupy the said premises, the learned advocate seeks to file supplementary affidavit and interim order. Then, my lord, the supplementary affidavit came, the option was given to him.
Supplementary affidavit was filed containing the other cards.
Fine. Well, no documents was disclosed. It is at page 98. And thereafter, this order impugned was passed.
No authority disclosed.
Well, lordship sees here. Well, he had the option to disclose all the.
Jena, there was some oh, sorry to hear that. Yes.
Page
sorry.
98.
Page 98, yes.
98. Now, lordship sees the supplementary affidavit.
Yes.
In paragraph 3,
See.
he has indicated, alleged the portion they are occupying.
Yes.
Now, my lord, it goes on. Thereafter, my lord, the legal submission and my lord, the supplementary affidavit ends with 4 photographs. So the option was given to
No,
him.
no, Aadhaar card was not annexed here also.
No,
Aadhaar card was annexed as a
yeah, annexed to the writ petition. Now, thereafter, the option was given. What is the authority? He can say, I have the bank accounts, I am receiving their proof, they are. He failed, and thereafter they seem to
Mr.
not.
Nag, what is your answer to this, the Aadhaar card argument? Because the Aadhaar card argument apparently is, I mean, it is seen from section 3 that prima facie there is some proof because the enrolling agency has to undertake a biometric information has to be verification. A verification has to be undertaken. Section 3.3 says on receipt of the demographic information and biometric information, the authority shall, after verifying the information. So there is some prima facie proof
One thing,
should have been
well,
considered.
law is well settled, my lord. If, my lord, I have to, my lord, follow a due process of law. But they have to show, my lord, even the
This is sufficient.
no, this
Biometric information, if that
this
is that
is-
contains address and
well,
that has been
they are
verified,
two things, my lord. They have to show,
there is a presumption of correctness to Aadhaar cards because that's official act. That presumption is attached unless rebutted. It's very well rebuttable, but it's a presumption nonetheless. Official act duly done.
now,
So
my
duly
lord,
done means this verification was
that
done.
then, my lord, I have to address the issue point of law here before your lordship. But, my lord, the law as settled, my lord, there has to be a settled position. My lordship knows, my lord, the special bench judgment in respect of electricity connection. They say there has to be a settled position. So the settled position has to be proved. They are in position now, my lord.
Now with full respect to your argument, settled position is not contemplated. Electricity, yes, settled position. There are several judgments. 3 judge bench is also there.
Yes.
But for attracting 1971 Act, occupation is the word used in the statute. We cannot read something into that.
Lordship.
Today, if somebody is in occupation, then it's applicable.
My lord, Aadhaar
Due
card,
process. That's the meaning of due process of law.
lordship. My lord, the Aadhaar card, my lord,
We may feel wronged. Somebody comes into my property. Yes, very well. Port is entitled to do that. But still, port has to follow the due process of law. And it's a summary procedure, 1971 Act. Your estate officer, your notice,
my lord,
give the notice, give them few weeks time and get them
I
evicted.
tell you, lordship, my lord, Aadhaar card, my lord, I want to come back, my lord. I want to satisfy.
Why
your
do you want
lordship.
to come? You
My lord, because
go back before the writ court.
No,
We'll
my lord,
direct you to file affidavits and do whatever.
I tell you, lordship, my lord, the Aadhaar card.
Rebut the presumption. There's a
But I
presumption
tell
of
you,
correct.
lordship, my lord, even the Aadhaar card, they have not disclosed all the Aadhaar cards of the address. My lord, I tell you, lordship, my lord, take your.
Very
my
well.
lord,
Only in respect of those persons whose Aadhaar cards were, the writ court is to look into this, Mr. Nag. Writ court is to look into which are the persons whose Aadhaar cards were produced, and in respect of them, you have to answer. We agree with you. We fully agree with you. All of them even do not disclose the address. So those people are excluded by default. But if you demolish the premises, even if one person has an Aadhaar card, he is also affected.
lordship, can I come back tomorrow to answer the issue of on the Aadhaar card? Because I think, my lord, the prima facie that has been diluted in the SIR process, my lord.
Very well.
somehow.
Go.
I want to come back because that needs, my lord. I was not prepared, my lord. To be honest,
When should you?
any day comments to
You
convenient.
tell us a day because we'll have to stay the order for a limited. I mean, grant an injunction for a limited period.
Tomorrow, my lord. Tomorrow, my lord.
Tomorrow you can come back.
No, my lord, may kindly ask. Records is undertaking, my lord, they will demolish, my lord.
No, we'll grant an injunction till the end of this week. This is on an ad hoc basis. We will make that clear.
My lord, may I give a short reply to Mr. Nag, my lord? One short reply.
He has not even answered. How can you reply? He had not even, Mr. Nag has not satisfactorily, to our satisfaction, he has not answered Aadhaar card question. Let him first satisfy us, then you satisfy.
CPT courts are also.
This court cannot.
In the present appeal, an order passed by the learned single judge dismissing the writ petition of the appellants has been assailed. Full stop. The appellants argue that they are residents of the subject premises which are being attempted to be demolished by the respondent authorities. Full stop. The appellants rely on purported Aadhaar cards issued to some of the appellants indicating their residence to be the subject premises. Full stop. Next para. The learned single judge proceeded to disbelieve such Aadhaar cards as a proof of possession and came to the conclusion that the rigors of the 1971 Act, West Bengal eviction, public premises within bracket eviction of unauthorized occupants bracket closed Act, 1971, are not attracted. Full stop. Next para. However, learned counsel for the appellants argues that in terms of the definition of demographic information given in section 2 within bracket small k of the Aadhaar
সেটা কি বলবো? কারণ তো উত্তর দেবো তো, কালকে শেষ হয়ে যাবে।
Millard, we finally find it to the cover page, Millard, the entire.
Yes, thank you. The Aadhaar within brackets, Aadhaar double A. The Aadhaar within bracket targeted delivery of financial and other subsidies, comma benefits and services bracket closed Act, comma 2016, which includes the address of the applicant for an Aadhaar card as one of the components of double inverted demographic information. Full stop again, comma, in subsection 1 of section 3 of the said act, comma, the entitlement of a resident to obtain an Aadhaar card number is subjected to submission of his demographic information and biometric information by undergoing the process of enrollment. Full stop. Again, comma, subsection 3 of section 3 provides that on receipt of the demographic information and biometric information under subsection 1, comma, the authority A capital, authority shall, comma, তারপর italics এ after verifying the information, italics শেষ, comma, in such manner as may be prescribed by regulations, comma, issue an Aadhaar card number to such individual. Full stop. Thus, comma, it is argued that the very issuance of Aadhaar cards presupposes a verification by the authorities as to the demographic information, comma, including the address of the applicant. Full stop. Hence, comma, it is argued that production of Aadhaar cards is sufficient prima facie, comma, although rebuttable, comma, evidence of occupation of a person of the property shown as his address. Full stop. Next para. In reply, comma, learned counsel appearing for the port authorities seeks a day apostrophe S accommodation to meet such argument. Full stop. Accordingly, let the matter stand adjourned for the day and be listed tomorrow under the heading specially fixed matters. Full stop. Next para. The respondents shall remain restrained by an order of injunction from disturbing the peaceful possession and enjoyment of the Achana, eta corona. The respondents shall maintain status quo. We are not holding that they're in possession.
Some building are already demolished and somebody has
The
also.
respondents shall maintain status quo as of today in respect of the subject properties till July 17, 2026 or until further order, whichever is earlier. Full stop. It is made clear that the merits of the case have not been merits of the appeal have not been gone into as yet, and the above protection is merely on an ad hoc basis.
Lordship, grateful.
Only I just one thing, Millard. Millard, instead of tomorrow, it can be day after tomorrow, Millard.
Day after tomorrow, Mr. Nag, ask Mr. Nag.
Day after tomorrow to করবেন কারণ
না না কালকেই করো কালকে
না না না, পড়ো না, যা কেন
আরে
বলবো?
আমার পার্সোনাল
If Mr. Jena says kalki koro, then it will be day after tomorrow. Day after tomorrow. তাহলে ওটা
No,
ওটা day listed adjourn for the day না করে adjourn till
মানে Thursday, মানে Thursday it's possible, মানে Lordship style.
Thursday is day after tomorrow.
Yes, yes, Thursday.
You're
Thursday.
losing.
Thursday.
July 15, 2026. আর প্রথমে একটা করে দিই affidavit charge file to be kept on.
থার্সডে ঠিক আছে থার্সডে
ওইটা।
Thursday is 16, মানে
Thursday 16.
16.
Sorry, our mistake. 16. বই ফেরত কিছু দরকার নেই, নেটে দেখে নেবে শুভ্র।
Grateful. Much
নামটা একটা যদি প্রবলেম থাকে নেটে দেখে, আমি তো পুরো বলে দিন। নেক্সট। Yes.
Some for the applicants, but regarding to railway hawkers, Lordship. Last occasion,
Lordship, we are led by the ASG, Your Lordship. He's
On the,
on,
yesterday also you granted the time.
he's on legs in court number 1, Your Lordship.
Every day we cannot grant time. Sorry, when you start. You have argued other matters before us, so you are sufficiently competent. So you argue. When is the next date fixed in the writ court?
tomorrow is 15 July, but tomorrow is a date fixed, Lordship, and in Tirimata till end of July. And lead matter will be taken up at today 12 p.m.
We
Lordship.
can extend this order, whatever order we have passed, we can dispose of the appeal subject to what you say by maintaining this order till end of July or until further order passed by the writ court.
Grateful.
Yes,
That
very
will
well.
protect them also, and it will be subject to the outcome of the writ petition.
Very well.
Can we record that we take up the appeal on consent? The order will not pass on consent. That may put you in difficulty. So, very well. On consent of the parties, comma, the appeal itself is taken up for hearing along with the application in view of the short question involved. Full stop. Next para. The learned single judge, comma, by the impugned order, comma, has granted interim protection to the writ petitioner stroke appellants, comma, who are hawkers in the who claim to be hawkers in the railway stations at Halishohor, Barakpur and Noihati. Full stop. Next para. The contention of the appellants is that the appellants filed the writ petition in representative capacity as well as on their own behalf. Full stop. Although no specific leave was granted within the contemplation of Order 2, Rule 2 of the Code of Civil Procedure, comma, it is submitted that the other hawkers similarly placed as the appellants stand on an equal footing and accordingly ought to have been given the benefit of the said interim order. Full stop. Next para. The railway authorities, the learned counsel appearing for the railway authorities controverts such arguments and submits that no leave was granted to proceed with the writ petition in representative capacity and, comma, in the absence of such leave, comma, the interim order cannot be extended to all others or other similarly placed persons. Full stop. Next para. However, comma, upon consideration of the arguments of the parties, comma, we find that since the notices do not name any particular person but pertain to unauthorized constructions on the aforementioned railway stations, comma, the effect of the same would be equal insofar as not only the writ petitioner stroke appellants but all other similarly placed persons are concerned. Full stop. Accordingly, comma, by applying Article 14 of the Constitution of India, comma, there cannot be any conceivable reason as to why the other similarly placed persons ought not to be granted the benefit of the said interim protection. Full stop. Next para. While observing so, comma, we take into consideration the fact that even if the writ petitioner stroke appellants have not yet obtained leave from the writ court to proceed in representative capacity, comma, the impugned notices themselves unify the affected persons by operating equally to all of them. Full stop. Thus, comma, the moment an interim protection was granted, comma, the same ought to have been extended to all affected persons, since the writ court was prima facie satisfied of an arguable case having been made out vis-a-vis the said notices, comma, which is not restricted to the appellants only. Full stop. Next para. In such view of the matter, comma, MAT, সবকটা MAT number দিয়ে, along with can 1 of 2026 in all the said appeals are disposed of by extending the ad interim order, that is stay of operation of the impugned notices dated June 12, 2026, comma, June 5, 2026 and June 8, 2026, annexed to the respective applications filed in connection with MAT 1100 of 2026, comma, MAT 1101 of 2026 and MAT 1103 of 2026 respectively, till July 15.
No, end of this.
Till July 31, 2026, or until further orders passed by the writ court, comma, whichever is earlier. Full stop. It is made clear that the above observations are only tentative in nature and shall not be binding on the parties and stroke or the writ court at any further stage of the writ petition, and it will be open to the learned single judge taking up the writ petition to decide the writ petition on its own merits without being influenced in any manner by the said observations. Full stop. Next para. the interim protection hereby granted shall be subject to the outcome of the writ petition. No address to cause urgency.
Great.
Please don't give the name of Mr. Trivedi. He'll be in jeopardy because it's live streamed. That's why I've said learned counsel, not you also have a designation. What's your designation?
Senior counsel.
Learned senior standing counsel or what is
No, senior counsel
for the
for the
railways?
Union of India. Yes.
For the Union of India. আচ্ছা তাহলে যেখানটা বললাম learned counsel for the railway authority সেখানে learned senior counsel for the Union of India, comma representing the railway authorities. Learned senior counsel for the Union of India representing the railway authorities. যেখানে বললাম learned counsel. Thank you.
Very well.
7.
I am for the
Yes, Mr. Bhattacharya, what is the matter? Order 41 আছে.
my lord, there is a defect, my lord.
Yes, several defects,
Deficit
deficit.
court fees, my lord, I have paid, my lord.
You have paid.
Yes, yes, my lord. My lord, on my lord,
Certified copy
certified copy of my lord, the
of appellate court decree.
Decree. You know, subsequently, we have obtained it is with me. If your lord
File it. And preamble is bereft of name of trial judge.
preamble, my lord.
Just check these things, Mr. Bhattacharya. You are too seasoned a campaigner in the civil side, so not to do it. See, in the preamble, the unnecessary things have been. Name of learned trial judge is not there, and you have given the date of decree. Under Order 20, date of judgment is the date of decree. So you said judgment and decree dated the date of the judgment.
Yes, my lord. Actually,
You have stated judgment dated such and such and decree dated such and decree date. There is no separate date given. So rectify these things. We are giving you leave. Leave is granted to the learned advocate and record for the appellant to rectify the memorandum of appeal in terms of the report of the assistant registrar within bracket SR section dated July 10, 2026, full stop, from the information slip filed by the learned advocate for the appellant, comma, it is seen that the deficit court fees have been paid through ePay Vide GRN number 192023240149369188 dated July 31, 2023. Full stop. The certified copy of the decree of the first appellate court is also filed in court and is kept on record. Full stop. Thus, comma, the defects in those counts stand cured. Full stop. However, comma, the office shall furnish a further report with regard to the same. Full stop. Affidavit of service you are filing today.
affidavit of service, my lord.
Previously filed. Affidavit of service is not necessary.
With me, my lord.
যে পর্যন্ত বললাম ওই পর্যন্ত. Yes, what is the matter? The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil. Yes.
My lord, decree, my lord, your lordship, my lord, stated the decree 110/2019. It has been stated as because of, my lord, the decree. If your lordship find that decree, my lord, it has been signed on, my lord, 110/2019 itself, my lord. That's why, my lord, in the preamble I have stated the judgment dated and decree.
Date of judgment
Is the date.
is the date of decree as per Order 20. Decree is signed on a particular date. That's not the date of the decree.
That is my mistake.
So in the preamble, you will just write judgment and decree dated, date of the judgment comes in and put in the name of the learned
Yes.
presiding officer. Yes, you lost in both courts.
No, my lord. In the trial court, my lord, I have won.
Don't be so happy. I mean, just because you have
No.
won in one court.
My lord, this was a suit for, my lord, declaration and, my lord, recovery of possessions, my lord.
Right.
My lord, the petitioner, the appellant before your lordship, my lord, purchased this property. My lord, one part of the property, my lord, he has inherited, and the rest, my lord, he has by way of a, my lord, registered deed. My lord, subsequently, my lord, when the plot was, my lord, divided into 3 plots in LR record of rights, my lord, initially the plots was RS 877 in favor of, my lord, 3 brothers. Thereafter, the plot was divided as per the amicable settlement between the 3 brothers into 3 LR plot of lands. One is the father of the, my lord, the appellant, and 2, my lord, other, my lord, the uncle. My lord, they, my lord, given the property in favor of the, my lord, the petitioner by way of a registered deed. My lord.
All of them.
All of them. So therefore, when the petitioner got, my lord, 16 anna share in respect of the entire plot of land in question.
Those 3 plots.
Yes. My lord, the defendant tried to disturb the peaceful possession of the petitioner. That's why, my lord, the suit was filed.
You produce your title deed and
Yes,
everything.
everything has been produced.
Why was it reversed? Sorry,
My lord,
please.
it has been reversed. If your lordship kindly takes pen to the, my lord, judgment of the appellate court. my lord.
Yes.
my lord, kindly comes to, my lord, page 15 of the judgment,
Give us the internal page 15.
internal page 15 of the appellate court judgment.
Yes, yes.
Well, the appellate court has, my lord, introduced a third case. My lord, it has been specified that it
Hmm.
has to be a partition suit for, my lord, declaration of the entire plot of land, since the part and parcel of the land in questions belongs to, my lord, three brothers.
But all of them have sold to you.
Yes, it has been recorded by the trial court itself, and the appellate court also, my lord, held it. If you also kindly take me to the page 14 itself. My lord, I am reading the page 14 with the appellate court judgment here. LR plot number 1085 having an area of 6 cents exclusively belongs to plaintiff. As such, construction made in Kho schedule property described as schedule Kho is nothing but encroachment of property by
Were
defendant.
there any other co-sharers apart from these three brothers?
No, there is no case at all.
This appeal will be heard on the following substantial question of law: whether the learned first appellate court substantially erred in law in reversing the decision of the learned trial judge on the premise that there was no partition in between the vendors of the appellant, comma, in the teeth of the appellant having produced title deeds to indicate that all the said three brothers stroke owners had transferred the property in favor of the plaintiff stroke appellant, comma, thus ruling out any necessity of partition between the said vendors. Any interim application?
Yes, my lord. Can one?
What is it? What relief have you asked for? Injunction?
Yes, my lord.
Stay of operation means
My lord,
the trial court degree.
Trial.
Very well. There shall be stay of operation of the impugned judgment and decree dated.
I am paying for stay of the, my lord, appellate court judgment pending.
Yes, yes. August 31.
No, September, my lord.
Acha, yes, September 30, 2022. Passed by the learned additional district judge at Bankura in title appeal number 01 of 2020 till disposal of can 1 of 2023. Full sub next para, the appellant shall serve copies of can 1 of 2023 on the respondents, indicating that the application shall next be listed before the appropriate learned single judge having determination after the timeline for filing of affidavits is over. Full stop. The respondent shall file their affidavit in opposition to can 1 of 2023 within 3 weeks from date. Stop. Reply thereto, comma, if any, comma, shall be filed within a week thereafter. The appellant shall file an affidavit of service to that effect at the time of hearing of the stay application.
My lord, your lordship asked me to file an affidavit of service in terms of the earlier order. My lord, this is also there, my lord.
We are
Right.
directed to file
My lord, Justice I.P. Mukherjee Daden was, my lord, probably direct.
without admission. There cannot be any.
Very
Self-affluence. How can we direct without?
Grateful.
Thank you. Substantial question. Direction হয় না আর সেকেন্ড অ্যাক্টিভিটি অ্যাডমিশন রিমুভ করতে পারবো না কারণ সাবস্টিটিউশন
My lord,
Yes,
I have not
yes.
picked up the scam reporter. My lord, the
You have not
defective.
checked that?
I have not checked.
You're so proud of it. Several defects. Does not tally with the certificate copy in trial court. Mr. Should you check up the defect? There's serious first name of respondent number 10 does not tally. You may have to correct the memorandum, but you have to seek a leave for that. Check up, we'll take it up on the next day. There are several defects in the appeal. Full stop. The learned advocate for the appellant is requested to check up such defects and apprise the court in that regard. On the returnable date, full stop, the matter be listed under the same heading on July 20, 2026, Monday.
Give you.
Because tomorrow and day after tomorrow, we will
Tomorrow
be taking up hearing
Original sergeant.
and hearing us. But please check up and on the next occasion, apprise us and seek necessary leave. No, don't make the corrections. Don't make the corrections.
No,
We're not
no, this is not my responsibility.
You know. Yes. Next. 9 years. Mr. Mahato, defect.
My lord, there are two defects, I think, my lord. One is, my lord, some parties have been left out who are in the defendant, but since the decree was not with me, my lord,
Certified copy of the trial court decree has.
yes, that has been, today I have got it in course of day, I shall file.
Lord, memo stay not supplied to me.
You lodged a caveat.
Yes. Earlier occasion appeared, my lord.
No, no.
Section
no,
5,
no caveat has
Memo
been
need not
lodged.
be served.
No caveat has been lodged, but since the section 5 application was there,
Yes, my lord,
but I
caveat
have-
number is here.
Keep it with you.
all right,
Okay, it's not
I
denied.
have, my lord, served all the copies. If affidavit to service is with me,
I personally requested 2 weeks
Yeah,
ago.
তুমি
He
এখনই-
assured me that supplied.
এখনই
I did not serve.
No,
না, না, না,
So
এখনই
Mahato is becoming unfair day by day.
Lord, I appeared in the
no.
section 5 hearing.
Section 5 was allowed.
Yes,
Hello.
section 5 are in his presence.
My lord, after
Let us see, Mr.
After-
Chattopadhyay, don't take a risk if he dismisses the
my lord,
appeal. then-
after refusal, my lord, the first appeal, the appellant filed a revisional application. He submitted before this court. which
You have
is
no
pending.
right of hearing. Please take
I
your
do
seat. You have a right to, you don't even have a right to get a copy before it is admitted. So please take your seat, Mr. Chattopadhyay, we will consider. Yes, yes, Mr. Mahato. You should have given him a copy of the stay. Now give it to him.
Man, I said, after submitting the facts, man, I said, man, this is the affidavit of service, I served him.
Oh, acha.
Everything I have served.
Well, what is the matter? Let us see whether we can admit the appeal or not.
Man, so far application for addition of party, that may be taken up first. The persons who have been left out.
Oh, acha, acha, acha.
এটা পেয়েছো তো?
Outer page, additional party page. Additional party section.
So if you add them, then you have to serve them also.
I have served. No, all the others.
No, added parties. If
Added
you add.
parties. Man, after admission,
Yes, yes.
yes,
No, why after admission?
they have not filed the.
Oh, right, you're right. So who have been left out? These
The opposite parties number 5 to 8 are the defendants in the suit. But since the copy of the decree was not with me, my lord, I missed it. Anyhow, my lord, by bona fide mistake, I missed it. I made the application, my lord, for their addition.
very well. Since, comma, due to bona fide inadvertence, comma, the respondent numbers 5, the opposite party numbers 5 to 8 in Can 1 of 2026 were omitted to be added in the appeal, comma, Can 1 of 2026 is allowed, comma, thereby directing the said omitted parties to be added as respondents in the appeal. Full stop. Necessary consequential corrections to the cause title of the memorandum of appeal and the connected stay application shall be carried out by the learned advocate on record by for the appellants during the course of the day. Full stop. On the prayer of learned counsel for the appellants, comma, leave is granted to the appellants to on the prayer of learned counsel for the appellants, comma, the appellants are directed to file the certified copy of the trial court's decree in the department, comma, also during the course of the day. Which was subject to the above directions, comma, the appeal is taken up for hearing under Order of Order Rule 11 of the Code of Civil Procedure. Affidavit of service filed to be kept under. Yes. Yes, Mr. Mahato, what is it?
My lord, suit is for partition. Initially, it was dismissed. Another suit was for eviction.
You are the
That-
plaintiff.
I am the plaintiff. Another suit for, my lord, eviction, that was also dismissed. 2 appeals were filed, my lord, by the plaintiffs of irrespective. My appeal relating to partition, dismissal of partition has been decreed, and their suit for eviction has been also been dismissed.
They are sued for eviction.
Therefore, my lord, ultimately, partition suit has been decreed by the trial court, and I applied for final decree. In final decree proceeding, my lord, the commissioner submitted his report. My lord, the commissioner's report has been accepted. Challenging that, my lord, and my lord, decree was also consequently passed. My lord, I preferred title appeal. My lord, here, my lord, dates are required. My lord, if you lordship,
Title appeal against what? Oh, against the final degree.
yes, against the final decree.
Acha.
Title appeal against the final decree. Acceptance of commissioner's report and the final decree.
Huh.
If your lordships kindly come to page 7,
Of the
as
Stay.
my lord, stay application.
Can 2.
Yes. Paragraph 24.
No, it is can, which Can 3. Is 7, paragraph 27. Yes.
24.
24, right?
On January 16, 2024, learned civil judge, first court, accepted the commissioner report and decreed title suit number in final form. My lord, next paragraph, I have stated the dates. My lord, on 22nd January, I applied for the certified copy. On 16th January, my lord, that was the decree. On March 27, requisite was, my lord, notified. I put in the requisites on April 2.
The appeal was dismissed on the ground of limitation.
No, non-filing of the decree.
Dismissed for that.
Yes. Non-filing of the decree in spite of, my lord, on the date when it was dismissed, before that I filed the decree before the court. And my lord, it was within limitation.
What are you saying?
Yes, my lord,
Let's see the appeal court judge.
appeal court's order. My lord, first order, my lord, 19th of April, I have filed the appeal.
Uh,
Next, my lord, order 2. It appears that the appeal was preferred on 19th of April without certified copy of the impugned judgment and decree. No specific leave was granted. Appeal is dismissed. And my lord, return the certified copy of the judgment and decree.
when did you file the certified copy?
My lord, I have filed it.
Uh,
My lord, on I filed
10th
an
May,
application for, and my lord, on May. Date is not given.
10th May,
Yes,
paragraph 29.
yes, 10th May.
So 10th, that was not, that was within limitation.
Yes,
Within limitation by excluding the period for obtaining the
yes,
certificate.
yes.
Yes, Mr. Chattopadhyay, give him a copy of the memo and the application will dispose of the appeal itself. Why keep it pending? That will affect you only.
No, no, I don't know, I don't know. Order
Very
copy
well.
will not finance, my lord.
We are admitting the appeal. We are,
Thereafter, he file a revisional application. We will
Mr.
talk about it.
Chattopadhyay, try to understand what
Yes.
you are saying. If we dispose of the appeal at this stage, then it will save you time. Otherwise, we'll have to admit this appeal, grant stay, it will be pending for eternity. So, at the time of hearing under Order 41 Rule 11, we find that an extremely short point is involved in the appeal. Full stop. Accordingly, this court intends to dispose of the appeal along with the admission hearing, subject to hearing the respondent. Full stop. Next para. We intend to adopt such procedure in order to save the respondents time and unnecessary prolongation of litigation before this court. Full stop. Accordingly, the learned advocate for the appellant is requested to serve copies of the memorandum of appeal as well as a further copy of the stay application on the learned advocate appearing for the respondents during the course of the day. Full stop. The matter.
Already handed.
It may be noted that pursuant to the above directions, such copies are handed over here and now. Full stop. In order to enable learned counsel for the respondents to prepare himself, let the matter be listed next on July 20, 2026 under the same heading.
No annexure, my lord, in the application. Stay application, my lord.
তো annexure আছে কি? Annexure নেই তো আমি তোমাকে কি করে annexure দেব?
Order copy গুলো থাকবে।
You want them to annex something?
No, no, no. No, I
আমি
think
কোনো annexure
Next.
করিনি।
order copy.
I'm good.
Can one? Okay.
Should appear, my lord.
Very well. Next. Yes.
At item number 10, I beg to appear for the plaintiff appellant. I gone through the defects. There are several defects and the decree ought to be sent down in the court below. Your lordship kindly sees.
That we can do, but subject to hearing you, we can also.
Your lordship kindly see the defects because some of the parties have been left out.
Oh.
We need to, because during the appellate proceeding, one of the defendant died. His legal heirs ought to be
So,
substituted.
Mr. Shamul, we can do this. We can send down the decree, certified copy of the decree to the trial court for correction, and you can take out your and give you liberty to take steps. Learned counsel for the appellants, in his usual fairness, points out to the several defects as pointed out by the stamp reporter. Full stop. On the prayer of the appellants, leave is granted to the appellants to take appropriate steps to correct the first defects as to parties. Full stop. Next para. Insofar as the other defect is concerned, the certified copy of the trial court's decree, certified copy of the first appellate court's decree be sent down for necessary rectifications. Full stop. Next para. Liberty to the parties to liberty to the appellants to mention the appeal for inclusion in the list as and when such steps are taken. Next. The matter to go out of the list for the present. We find from the report of the stamp reporter that dated July 9, 2026, that there are several defects in the appeal, full stop. Leave is granted to the learned advocate for the appellants to uh, to rectify such defects, comma, by incorporating the necessary corrections to the memorandum of the appeal if necessary. Full stop. Next para, since none appears to move the appeal, comma, let the same go out of the list. Next. ঝুলিয়ে রাখবো না, যদি না ইন্টারেস্টেড থাকে। Yes.
11, 13, I appear for the appellants, my lord. At number 13, there is a section 5 application that for that, my lord directed me to serve on 18th of
Substituted
May.
service has been affected.
Yes,
Yes. What is the delay?
delay was of 57 days.
Item 13, what is the appeal number?
FMAT 118
18.
of 2026.
Give us half a minute's time. Yes.
Delay was on the ground to obtain the
Sorry,
cost
delay of
papers.
how many days?
57 days, 57.
On what ground?
On the ground of obtaining the cost papers, and we had already we had filed a prior suit for obtaining the injunction.
You have blamed
That-
any advocate?
No. Delay. Delay
Uh,
was taken.
Since substituted service has already been effected, but none appears for the respondents, comma, the condonation application is taken up for hearing ex parte, full stop. Upon perusal of the averments made in the application, comma, we find sufficient reason for the delay having been made out. Accordingly, can 2 of 2026 is allowed, thereby condoning the delay in preferring FMAT 118 of 2026, no address to cost. Yes, what are the appeals above?
Yes, my lord. Before I start, my lord, can I take this list of days? My lord had directed me to prepare a list of days for.
Yes.
But the case was, the appellant is the father. In the item number 12, appellant is the father and the respondent is the daughter.
So 12 we are taking up first.
Yes, I'm relying on the 12. I've
These
given.
arise from the same suit or why two appeals?
No, item number 12 is my suit whereby I filed an injunction application that was rejected. And item number 13 is the suit filed by a third party, obtained an injunction against me.
That third party is not a party to the first.
To the first suit, not a
Not a
party.
party. Your suit is for declaration of title and injunction.
My suit is for the cancellation of a gift deed given to my daughter.
You have executed that deed
Yes, in
purportedly.
2024. That is item number 9 of the list of dates.
Induced to means?
But what has happened? The appellant father left a will in the name of the appellant's mother in 2000. Thereafter, the brothers, sisters, all have died. Only one sister is alive. She lives in abroad, in USA. She is still alive. So the property is not completely with the appellant. But what has happened? The respondent was of the idea that the property is completely with the appellant and directed him to give a gift deed. So the appellant complied with it and gave a gift
That
deed
is
to the
binding on you insofar as your share is concerned.
Yes.
Then
So far as my share is concerned, I
how can you
give
get the gift deed cancelled? You voluntarily
No,
execute.
my lord, the Supreme Court says that if the son or the daughter does not take care of the parents, that gift deed can be cancelled.
Was it under the Senior Citizens Act?
No, my lord, the Senior Citizens Act, I have not filed a suit there.
Then it is within the trappings of that act only that this can be done.
But
Not under by a general suit.
not under a general suit, but
When
section
the Supreme
20.
Court says something, it is in a definite context.
Yes. I would kindly take
There is a particular statute for that.
Yes, I under section 23.
Yes. By filing a general suit, that is not a good ground for cancellation.
But the gift deed itself is defective because I did not have the 100% of the right to give it to the daughter.
Injunction refused to you.
Injunction was refused.
Ad interim.
Stage.
Rightly refused.
But thereafter, it was.
To execute a gift deed to your daughter,
Yes.
you did not know that you were you did not have title in the entire property.
But,
You yourself are seeking cancellation of that on that ground. You cannot take advantage of your.
but what had happened, I'd say. And first of all, on 20th December 2025, I received an order from the court, that is the item number 13's appeal of the suit, whereby the daughter has sold this property to Modern Sara Projects. That is the respondent in the item number 13 appeal.
That suit is for?
That suit is for injuncting me by execution of
of
that
that
sale deed. The daughter has given us given the property to Modern Sara Projects
That Modern has filed the suit for what? Against the daughter?
against against us.
Against you.
For
Saying that you were
removing.
disturbing possession.
Yes.
And also seeking declaration of the title.
Yes. Thereafter,
Right.
they got the injunction. Thereafter, I filed a suit for a cancellation of the gift deed and injunction. That was rejected.
Right.
But kindly take once the Supreme Court judgment which says.
Absolutely. Please. Fraud hole ebar. Two judges,
Yes,
one
ma'am.
copy.
I'm good.
That is your own copy.
I have. Kindly grant me a moment. Para 20.
See the caption even so
Yes.
it's under that act. Para 20 very well, yes.
Para 20 I rely.
Yes.
In Sudesh Chikra, this court refused to grant the benefit of Section 23 in the absence of an averment that the transfer in question was subject to a condition of for maintenance. It was observed when a senior citizen parts with his or her property by executing a gift or a release or otherwise in favor of his or her near or dear ones, a condition of looking after the senior citizen is not necessarily attached to it. On the contrary, very often such transfers are made out of love and affection without any exception in return. Therefore, when it is alleged that the conditions mentioned in this are attached to a transfer established before the tribunal, but thereafter this court, the Supreme Court holds Para 25. Another observation of the High Court that must be clarified is Section 23 being a standalone provision of the Act. In our considered view, the relief available to senior citizens under Section 23 is intrinsically linked with the statement of objects and reasons of the Act. That elderly citizens of a country in some cases are not being looked after. It is directly in furtherance of the objectives of the Act and empowers senior citizens to secure their rights promptly when they transfer a property subject to the condition of being maintained by the transfer. In the above manner, the impugned order was reversed and the gift deed was cancelled. But what I say, I had filed a suit for cancellation of the gift deed because the daughter had not taken care of me, completely removed me from the premises. I am now living in a rented property outside of my own property. I did not know that when I gifted the property, she was of
What
the
sort of
idea.
injunction did you want?
I wanted not to remove me from position.
You have admittedly been removed.
I was removed. I was on 20th December 2025. That order was given to me. Thereafter, a police help application was taken out by them. Then they removed me on 13th of January 2026. I filed a suit thereafter and prayed for injunction before the same learned judge.
When the suit was filed,
Yes.
you were already removed from the property.
When the suit was filed in no, that time I was still in possession. Thereafter, they filed an
Now there is a
application for
scope of
police help.
grant of injunction to you also, because you are already removed.
They had already forged my signatures. They had obtained the
Whatever may be your
effective
allegation, you
notice.
amend your plaint and get an appropriate relief there.
But I have filed a suit against
You have
the
not filed an application for status quo ante.
no.
You have filed a suit, an application for injunction.
Yes.
Now that has been rendered infructuous in any event. Your allegation is that after filing of the suit and filing of the injunction application, you were removed from the property. We appreciate that.
Yes.
But then you have to file an appropriate application. You know what before the trial.
But I have filed an application. This suit is against the daughter.
So therefore, this
Modern
refusal
Sara
of
Projects has not
injunction
been
now,
made party.
even if you admit the appeal, we cannot grant you injunction now.
Yes.
You're already out of position. So how can you?
But this is regarding the item number 12. Now, item number 13, I have challenged the order of 20th December.
They have a valid title deed. There is a valid gift deed till it is set aside by any court of law.
That I understand, my lord, but
what is the injunction that you cannot disturb their possession or what?
no, I cannot. I have been removed from the property.
What is their injunction?
I am showing the order.
What is the injunction they got?
Yes, my lord, I am showing the order.
Forgotten?
But I have been removed. My lord.
Yes.
That is at page 102 of the item number 12 appeal. Page 102.
Title number 321 is your suit. You are Devkumar Sarkar.
Yes.
Right? Acha.
This 2929 of 2025 is the suit filed by Modern Sarah Projects. Defendants are hereby restraining from entering into the suit premises. I have been removed. That was the injunction order. And creating any sort of obstructions in respect of peaceful living and possession and exclusive. But the operative portion is at page 104. Further restrain the defendants from ousting the plaintiff from his lawful possession and occupation in suit premises for a limited period, that is till the next.
Go and contest it to their injunction application. But you don't have an injunction in your suit. Within the trappings of a regular suit, it's doubtful.
At the very next page, the order that was passed in my suit, that is there. 105 it starts.
These are ad interim refusals, both.
Yes,
In your suit, it has become infructuous. No,
it has been refused.
we're not admitting, we are permitting you to contest the suit. We'll say these will not be binding on any of the parties that differ.
But I will kindly direct them to
Do what? Tell us.
at the
To restore possession, how can we at this stage?
the electric connection has already been changed. They are changed already.
No,
Without
this will be subject to the outcome of the suit. If you win your suit, if they lose their suit, then you get back possession. But you know what to do in your suit. Please amend the plaint accordingly.
Right.
The two appeals are connected in view of certain common issues being involved. So, next para. FMAT 87 of 2026 arises out of the refusal of an ad interim injunction to the plaintiff stroke appellant in a suit for cancellation of a purported gift deed executed by the appellant in favor of the respondent.
that order was obtained by Modern Sarah Projects, 28 December 2025. I have challenged the item number 12.
No, in your suit.
Yes.
87?
87 order is dated 24. That is TS 321.
Your injunction is refused.
Yes, my injunction is
Why are you
refused.
disturbing the court? Please let us pass the
That
order.
order is not dated 28 December 2025. madam.
Who said 28 December? We did not say 28 December.
I have
কি
refused.
বলে মাথা খারাপ হয়ে গেছে তুই কি বললাম সেন্টেন্স comma the latter being the appellant's daughter. For the next para, learned counsel for the appellant argues that as per the plaint case, comma, the defendant respondent double inverted very cunningly and with malafide intention and with the intention to cheat her father, double inverted close, exercised undue influence on him and coerced the plaintiff stroke appellant to execute the impugned gift deed dated November 4, 2024. For sub next para, it is submitted that the appellant has also pleaded in the plaint that the defendant respondent intentionally, comma, deliberately and with malafide intention told her parents that she will arrange for an accommodation in Newtown and arrange for the rent, but refused to do so. Full stop. In view of the respondent daughter not taking care of her parents, comma, including the appellant father, comma, the gift deed ought to be cancelled on such ground alone. Full stop. However, comma, it is argued that despite such circumstances, comma, the learned trial judge refused to grant ad interim injunction. Full stop. Next para, learned counsel also relies on Urmila Dikshit versus Sunil Sharan Dikshit and others, reported at 2025 2 SCC 787. Full stop. Next para, insofar as FMAT 118 of 2026 is concerned, comma, the self-same appellant and your wife
Yes.
and his wife have challenged an order of injunction granted at the behest of the respondent, comma, an alleged transferee of the daughter of the appellants, comma, restraining the defendant stroke appellants from entering into the suit, self-same suit premises and creating any sort of obstruction in respect of the peaceful living, comma, possession and exclusive usage and enjoyment of the suit premises, and further from ousting the plaintiff stroke respondent from its lawful possession and occupation in the suit premises. Full stop. Next para. Learned counsel argues that in view of the gift deed, comma, on the strength of which the transfer was effected in favor of the respondent in FMAT 118 of 2026 being challenged in the latter suit, comma, the learned trial judge erred in law and in fact in granting such injunction. For the next para, learned counsel argues that the appellant's, comma, being the father of the vendor of the respondent in FMAT 118 of 2026 and the respondent in FMAT 87 of 2026, comma, have been thrown out from their own premises on the strength of the gift deed, comma, thereby violating the provisions of the Maintenance and Welfare of Parents and Senior Citizens Act, comma, 2007. Full stop. Next para. We find from the impugned orders, now we find from the cited judgment that the Honorable Supreme Court was considering a case under the 2007 Act. Full stop. Within the contemplation of such statute, comma, the Honorable Supreme Court was pleased to observe that for attracting the application of section 23 within bracket 1 of the 2007 Act, comma, the transfer must have to be made subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and that the transferee refuses or fails to provide such amenities and physical needs to the transferor. Full stop. Next para. The first aspect of the matter which catches the eye is that the present suit has been filed as a regular title suit under section 9 of the Code of Civil Procedure, comma, read with section 5 of the Specific Relief Act 1963 and not under the 2007 Act. Full stop. The 2007 Act specifically enumerates authorities who will deal with such matters. Full stop. Hence, comma, there would be a confusion of jurisdiction in the event a civil court exercises the power conferred specifically by the legislature on a particular authority under the 2007 Act. Full stop. Next para. We also find also from the plain pleadings, comma, we find allegations of undue influence and coercion having been leveled by the plaintiff stroke appellant. Full stop. Next para. Thus, comma, the paradigm of the suit is different from those of the 2007 Act. Full stop. As such, comma, the ratio laid down in Urmila Dixit Supra is not squarely applicable. Full stop. Next para. At this juncture, comma, learned counsel for the appellant also submits that the appellant has been ousted from the suit premises. Full stop. As such, comma, in any event, comma, the prayer for injunction sought in the appellant suit has been rendered infructuous. Full stop. Next para. Thus, comma, there is no scope of interference with the impugned order in FMAT 87 of 2026. Full stop. Hence, FMAT 87 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, the connected stay application bearing connect to the is also dismissed. Full stop. Next para. Since now, insofar as the other appeal is concerned, comma, since a valid title deed has been produced by the plaintiff stroke respondents on the strength of a gift deed which is yet to be declared to be invalid or cancelled by any competent court, comma, a prima facie case for grant of injunction was made out by the respondents. Full stop. Hence, comma, the learned trial judge was justified in granting the ad interim order of injunction. Full stop. Accordingly, FMAT 118 of 2026 is also dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Can 2 of 2026 also stands consequentially disposed of. Section. Full stop. Next para. Needless to say, the none of the above observations shall be binding on the learned trial judge in either of the suits at any further stage of the suit or the injunction application, and it will be open to the parties to contest the injunction application and the suit on its own merits. No address to cause urgency.
Very well.
একবার ডেকে নিন, একবার
Declaration.
We are taking that break a little bit early today. এটা একটু ঢুকে দিন।
There is a delay of
You are for the respondent?
Yes, my lord. I'm
right.
Delay of?
Delay of 190 days.
What is your
On the
explanation?
ground, revision, initially revisional application was filed, they withdrawn. Then page 6, the order.
What is the impugned order? I mean,
Impugned order 26 of the Hindu Marriage Act, custody of the child, daughter of the appellant.
final order has been passed.
26, that.
So
order,
division was dismissed or you withdrew?
No, only allow to
Revision,
video calling.
Previous revision.
Withdraw,
My lord, the impugned order passed 11th June 2025. So, my lord, delay is not for 190 days, delay is for 365 days. 190 days for revisional application from this appeal, my lord. But from the impugned order, this is more than 365.
The revision was also filed much after the limitation period.
Yes, ma'am. And my lord, not only video calling, my lord, there is a with video calling as well as
So on the merits will go later if you, subject to the section 5 being allowed. Even June 25 orderটা হচ্ছে family court. What is the limitation from there?
The regular appeal, this is 90 days.
90 days. Are you sure?
90 days, that order was passed on June 11th.
No, 90 days under which provision? Family Courts Act. What is the
Family Courts Act?
There's a time given. Please check up. This is Kolkata. So if it was city civil court, it would be less. Although Hindu Marriage Act is 90 days.
My lord, any appeal against a judgment and order of a family court must be filed in the High Court within 30 days.
Within 30 days.
30 days.
By 11th June, that the order was passed. File,
When did you file the revision?
Revision file.
Month of February, my lord, February 2026.
And this
no
appeal
expression.
file, March.
No. When was the revision filed? You have not even stated in your section 5.
My lord.
Have you stated in your section 5?
No. This is a revision application withdrawn, that only.
No.
My lord,
If the revision, please, ma'am, let us complete. We are not inviting you right now. Revisional application, you have to explain the delay in filing there. That was even filed much after the appeal period. File a supplementary affidavit, Mr. Mukherjee.
Yes.
Give a copy to them. We will give you a chance. Particularly since this relates to custody, we are lenient regarding section 5. But if you can't satisfy the delay, then whatever order has been passed remains. Anyway, the primary ground for the delay is based on the erroneous preference of a revisional application against the impugned order prior to the present appeal, which was withdrawn later upon wisdom dawning on the appellant. However, from the condonation application, we do not find any explanation for the delay occasioned in filing the revisional application much beyond the appellate period. Even the date of filing of the revisional application is not mentioned in the application. Accordingly, on the prayer of learned counsel for the appellant, leave is granted to the appellant to file a supplementary affidavit to Can 2 of 2026 with an advance copy to the learned advocate for the respondent. Such affidavit shall be filed on the returnable date. The matter within a week. Can you do that? You have to give a copy to her by Friday. Otherwise, she won't be able. On July 20, 2026.
Thank you.
Thank you.
কুড়ি তো? 21 কোনো মামলা কিছু করবে না।
নাম্বারটা একটু দাও।
751?
Yes. Can you come a bit closer to the microphone? Yes.
I'm for the appellant, madam.
For the respondent.
Yes. What is the matter? Mr. Ahmed, you can take your seat. We'll just hear him.
Well, I'm the owner of the property. I have obtained a sanction building plan, and accordingly, I gave it to some promoters for construction of the building. And in the plan itself, sanction plan itself, there is a provision for my lord giving to the giving accommodation to the respondent, my lord. But instead of that, he didn't vacate. All other my lord occupants have vacated the building. So my lord, I applied before the learned junior division for an injunction, my lord. I obtained an injunction.
No, you are the owner.
I'm the owner of the property.
Mr. Ahmed is for the developers.
No, Mr. Tenant, my lord.
Oh,
Only one tenant.
It was an agreement between you and the developer.
Yes, my lord.
But in that there was a provision that who would arrange for vacating, the tenants vacating? The tenants were not parties to the agreement.
No, my lord. But in the sanction plan, it is shown the tenant's name is there, and what accommodation will be provided in the sanction plan, it is there, my lord.
Tenant never signed the document, so they are not parties. It is not binding on the tenants. So what suit did you file? Suit for
declaration and permanent injunction.
Declaration that
I am entitled to construct the building, and I am already ready to provide him after construction his accommodation.
No, you cannot compel. You don't have a legal right to do that. He's your tenant. You can evict him subject to due course of law.
I do not want
your agreement with the developer does not bind him.
No, my lord. That's not.
For a change, Mr. Ahmed has a good case, probably.
No, my lord. What I have stated, my lord, there that I am the owner.
You are the owner.
Yes.
You agreed with the developer, and you housed the tenant.
No, for construction of the building.
For whatever reason.
And I obtained the manual sanction blending. As a owner, I obtained that.
You obtained sanction.
I obtained.
But you cannot house the tenant.
I do not want that, my lord. I do not want that. That's why I am saying that in the sanction plan, I have provided his accommodation in building.
You're not doing a charity to him. He is entitled to his occupation.
That's why I have
present occupation.
Yes, my lord. I have given that, and I am also agreed.
What sort of injunction did you ask for? Let us see.
My lord,
no, this is his suit.
This is his suit, my lord.
He has filed for declaration of his tenancy rights and injunction so that his possession cannot be disturbed.
My lord, this is the subsequent suit. My suit was earlier. My suit was before this.
What injunction exactly did you want in your suit?
In my injunction, my lord, I wanted that I may be allowed to construct in according to the sanctioned building plan. And my lord, after
what happened to that injunction application or the suit? Your suit?
In my suit, that was allowed, my lord.
Injunction was granted.
Injunction was granted.
He was a party there.
Yes, my lord.
Okay, let us see that injunction first. That order.
My lord, that order I didn't include, my lord.
Good. So then what happened?
Then my lord, he filed in the senior division this suit.
Whatever.
And obtained an injunction suppressing the fact the earlier injunction, my lord.
You have also suppressed before us the earlier injunction order.
My lord?
You are also suppressing the earlier injunction order before us.
That
is the plinth of your case. You are not ready with that.
Because my lord, I thought, my lord,
you thought what?
Subsequent suit against which the injunction is granted.
Your argument that there is a previous order is your only case. Only case. Otherwise, you don't have any right to resist this injunction. Tenant has a right to seek due process of law for eviction. Your only case is apparently on your prior injunction order where they were parties. You are not ready with that.
My lord,
you have a copy of that.
I may be allowed to file supplementary evidence.
Have you got a copy? We'll look into the copy just.
No, my lord, not
How do you draft your memo? Your client told you have an injunction. Have you quoted that injunction order anywhere in your application? The previous injunction?
I have stated so, my lord.
Where? Have you quoted that ordering portion of that? That was a contested order.
That is the mention in the.
That was a contested order. They were present when that order was passed.
No, my lord. Independent of expertise. That was expertise.
Then we don't find any illegality in this order. You obtain an order ex parte, injuncting them from resisting your construction in the property,
But I have come before your lordship against the second suit, my lord. What they have filed.
So, we find this is a perfectly valid order. Why we are telling you? Because here the court says not to evict him by applying any unlawful means or by force, which is perfectly justified. Due course of law, you evict him. We won't interfere.
Sir, I didn't want to evict him. That's what I stated so, my lord.
No, the trial court also said, honored that wish of yours, that you don't want to
I
evict
don't
him.
want.
That has been granted.
Still, I don't want to evict him.
Then don't challenge, don't press this appeal.
Allow me, my lord, to file my certificate, supplementary appeal.
No, we are not. We are satisfied that this is a perfect order. Again, wonder. Page 37. এটা নিজেই জানেন? Please come to page 37 of your application. Stay application. Put up দিয়ে করেছে আবার।
Yes, my lord. I'm sorry. I just missed it. Yes, it is there.
Thanks to my little brother, I also missed it out.
I'm sorry.
See, it's there. Just see what is there. Defendants, main agents, and associates restrained from causing any obstruction to your ingress and egress, and also restrained from obstructing from doing any lawful work.
Yes, sir.
We are saying we will hold that this injunction does not contravene that order also. If you do any lawful work, we'll read that into this order, that they cannot be evicted without due process of law. So this order is perfect. And this does not contravene that. First of all, that was past expertise. They were not present at the ad interim stage. It is binding on them, but we cannot force them to not to obstruct you first. Secondly, lawful work will read this into lawful work. Lawful means you have to evict your tenant by due process of law.
I do not want to evict them. I'm still saying I do not want to evict.
How will you construct then? They'll be sitting there.
No, my lord.
And around them, there will be demolition.
Alternate accommodation. We agreed to provide him alternate accommodation during the period of construction.
You will be constructing the new building in a day.
No, my lord.
Then what will they do in the meantime if they don't go out of these premises?
That's why we propose.
If they go out of the premises, what is that called in law? If you send somebody out of premises, what is that called?
Lord,
we generally call it eviction.
My lord, we agree to provide them alternative accommodation.
Don't be so condescending, Mr. Islam. Nobody wants your agreement. They have a legal right. Nobody wants your agreement. You go and agree whatever you like with your developer. You cannot oust a tenant.
Lord,
just like that, so easy.
Not that, my lord. Your lordship
there is still rule of law in our country.
My lord,
still,
your
you
lordship,
don't know how long it will be there, but till date there is rule of law.
Your lordship can direct me, my lord, to provide them,
what?
To provide them alternative accommodation during the period of
construction. If it was possible for us, we would set aside the earlier order also. No, Mrs. Sorry. The present challenge has been preferred by the plaintiff in a suit for declaration, the defendant in a suit filed by the respondents for declaration of their tenancy rights and for permanent injunction protecting their possession. Office of Learned Counsel for the appellant argues that the appellant stroke owner of the property entered into an agreement for development of the property with a developer. Office of next para, in terms of the same comma, the present respondents, comma, who are tenants in respect of the suit property, comma, would be given accommodation commensurate with their present rights in the new building, comma, to be constructed after development. Who's of next para? It is submitted that in a prior suit filed by the appellants for declaration of their right title and interest and for permanent injunction, comma, an ex parte ad interim injunction was passed against the present respondents, comma, restraining the latter, comma, their men, agents, and associates from causing any obstruction to the ingress and egress of the present appellants and their men and agents to and from the suit premises and also from obstructing the present appellants from doing any lawful work in connection with the construction of new building at the said premises in accordance with the sanctioned building plan of the KMC. Full stop. Next para. Learned Counsel argues that the present impugned order is contrary to the earlier injunction obtained by the appellants and as such is dehors the law. Full stop. Next para. However, such contention is not tenable in the eye of law. Full stop. In view of the respondents herein being admitted tenants under the appellants in respect of the subject property, the learned trial judge was perfectly justified in protecting such possession in the capacity of tenants, by directing the defendant stroke present appellants to maintain status quo in respect of the present physical possession of the plaintiff stroke respondents over the suit property until the disposal of the suit and not to evict them therefrom by applying any unlawful means or by force. Full stop. By its very nature, the impugned order leaves scope for the appellant stroke owners to obtain eviction of the respondents, if otherwise so entitled in law, by due process of law, that is by filing a regular eviction suit. Full stop. However, the bilateral agreement between the appellant stroke owners and the developer cannot bind the respondents tenants, who are legitimately entitled to continuance of their tenancy rights in respect of the property and were not parties to the development agreement. Full stop. Next para. The ad interim injunction obtained in the earlier suit was ex parte, in the absence of the present respondents and, as such, the respondents did not have the right, did not have the opportunity to indicate their interest as tenants in the said property or to have a say in such injunction. Even otherwise, the earlier ex parte order dated June 16, 2025 specifically enumerates that the present respondents cannot obstruct the construction, cannot obstruct the appellants from doing any within double inverted lawful work, double inverted close, full stop. Such lawfulness of the construction has to be read in conjunction with the existing tenancy rights of the present respondents and cannot be in derogation thereof. Full stop. Thus, we do not find any illegality in the impugned order. Full stop. Accordingly, FMAT 135 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 2 of 2026 is disposed of, is dismissed consequentially. Full stop. No orders to cost. It is made clear that nothing in the present, none of the above observations shall unduly influence the learned trial judge in either of the suits at any further stage of the suit or the injunction application. There was a section 5 here.
Yes, Mr.
Allow kori to. What is the delay? You should have pointed out.
54 page detail.
Allowing that. He'll agree. Upon hearing learned counsel, we find sufficient explanation for the delay having been furnished. Accordingly, can 1 of 2026 is allowed, thereby condoning the delay in preferring FMAT 135 of 2026. Thank you. Grateful. Next. Oh, okay.
But I am appearing on behalf of the caveator respondent.
Yes, he's for the appellant.
I am praying for not this week. In this matter, Kumar Jyoti Tiwari is appearing.
Yes.
Personal difficulty, Lordship. I am praying for only.
He has not come to court.
No, Lordship. Lordship, only you, Lordship.
We are adjourning for the week. On the prayer of the appellant, let the matter stand adjourned for the week. But on the next occasion, we won't grant any further time. If he is absent, then you have to do the matter, or whoever has to do the matter.
Absolutely.
Give your appearances, please. Yes. Next.
17 Lord,
Yes. Yes, Mr. Raman, what is your?
My lord, this is a case we are appealing against the rejection of our appeal under Order 9, Rule 13. there was a decree of divorce, which was totally expired, my lord. And against it, we have come, we filed an appeal under Order 9 Rule 13, which was also rejected. Now, my lord, coming to the order of Order 9 Rule 13, kindly peruse the order, my lord, if you
Yes.
gives me time. It is mentioned in the
No condonation application was filed.
condonation, my lord.
No application for condonation of the delay in filing the Order 9 Rule 13 was filed.
My lord,
There was a three years delay.
my lord, after 3 years, we came to know that there was an expired
Date
divorce.
of knowledge is not the relevant date. Date of the order is the relevant date. Your belated knowledge can be a ground for condonation.
My lord, your lordship accepted this in the first stage. Because
we are not speaking about the present appeal. In the trial court, you filed the Order 9 Rule 13 after 3 years from the date of the order, 2.5 years.
my trial court became convinced about that, and after that, they have passed the order.
No, you did not convince. The trial court held in the first sentence of decision with reasons. The present application has been filed only on such and such with no satisfactory explanation for the delay of more than such and such years.
But thereafter, the trial court dealt with the matter and finally gave a decision which is totally erroneous. They should have rejected, I mean, the trial court, learned judge should have rejected it in the first instance, but they have dealt it.
What is the miscase? The Order 9 Rule 13 itself.
My lord, yeah. Yes, my lord.
No. Please come to the impugn order.
Impugn order.
Page 2 of the impugn order, please.
Yes, my lord.
The last paragraph. Please read that out.
The petitioner's core allegation that she was unaware of the matrimonial proceedings due to incorrect service does not stand the test of scrutiny. It is evident from our own pleadings and cross-examination in Miss Case number 93/2013.
Read it, complete it. Continues in the next.
She had used the same address, Baripur, in the proceedings filed by her under section 125 CRPC. She received judicial communication and legal notices. I object to it. Since she never contended in those proceedings that she was staying elsewhere, the newspaper publication was made in a widely circulated memory daily.
Nothing in your matter, Mr. Rahman.
Milord.
The same address you used for your 125, there it was served there. Newspaper publication was also made. So there is a presumption of service. You admitted in your cross-examination in connection with this case that he had mentioned the pendency of the divorce proceedings in his written objection. So you knew about the
Milord, in the same order, Milord, let me come to this thing.
Yes.
In the same order, defense of the petitioner.
Right.
In the second paragraph.
Mm-hmm.
In the affidavit in chief.
Yes.
And deposition, the opposite party contends that proper service was effected on the petitioner. Initially, the summons were sent by registered post at both the Rajarhat and parental address. Milord, kindly note, both Rajarhat and parental address. Then, learned judge writes that, that she had no scope to know. Milord, the court records and materials placed over it. It is in the second case of the order, Milord. At the last paragraph. Proper attempts were made to serve summons by registered post at Baripur in 2013, and the miss case under section 125 CRPC was filed by the wife at Baripur in 2013, giving her address at Baripur. There is nothing on record to show that the OP had any scope to know that the wife was living in Newtown. Milord, is it not contrary?
Well, substituted service was effected at the last known address. Order 5 Rule 20 was complied with.
Milord, without bailiff service, Milord, or there is actually, I mean, elaborate system of summons of service.
Yes.
How to serve. I mean, bailiff service was not there. And the service, there is no what do you call, yes, my lord.
Court recorded its satisfaction. There is a prima facie presumption of correctness to judicial acts.
My lord, I'm saying that. First of all, my lord, the order is contradictory. Once I say that I have no scope to know that petitioner, the respondent was living in Newtown. Then I say service was made at both sides.
He had no scope to know that you are living in Newtown. Court finds three things. One is that due service was sought to be effected at your last known address. When that was not successful, paper publication was made. This is the first finding. Second finding is that since you had changed you might have changed your address in the meantime, since you had given your address as a particular place at a particular place in Baripur, they served there. They had no way of knowing your Newtown address, even if it was.
Here, my lord,
Yes.
I have an objection. The husband all along knew that wife was residing at Newtown, their matrimonial residence. And there, my lord, if your lordship comes to page 18 of a supplementary affidavit.
Yes, page 18.
Immediately after getting the divorce, eviction notice was served on the petitioner, wife. Immediately. Once this husband and wife separated, both are having residence in Baripur. He knew that wife was staying in Rajarhat, Newtown. And once he got the divorce, ex parte.
This was never placed before the Order 9 Rule 13 court. For the first time,
Actually, my advocate at the time didn't
now
find
you have advised. Now they are producing.
Milord, then I send it on remand. Milord.
Send it on remand.
Milord.
And what about the other?
I have not been able to. I didn't get
Raman,
any
there are
chance.
other findings also in the impugned order. If you come to page 3 of the impugned order, as we pointed out to you, in your cross-examination, you have admitted that he had mentioned the pendency of divorce proceedings in his written objection filed in connection with your miss case.
Milord, they have given a very wrong number, cunningly and very shrewdly.
How?
So that wife never knows. Will kindly comes to
That objection is annexed here.
Objection was given, yeah, in order 9.
Where is
Page
the
30.
objection? Page 13.
Page 30. বলুন বলা যায় না কেন বলুন আমার জল শুকিয়ে গেছে
See, my lord, kindly paragraph 16.
16.
Yes.
Yes.
Wherein intentionally he has given the wrong number. On that basis.
This was not the correct number.
No.
Yes, ma'am.
On that basis, she inquired, and she did not know anything. And the Baripur address, not.
So this they must have been renumbered later, but
on this basis, not the advocate inquired, but no such divorce it is pending. So he should give the actual number.
so therefore in the written objection, wrong number was given. That was not proper. You could not have knowledge. One. Secondly, they knew your Newtown address.
Yes.
Which is evident from the eviction notice given immediately after the decree. But still they did not serve there. But what about presumption of service under Ratified Rule 20? That was the last, you disclosed that address as the last address. You never disclosed any other address.
But my lord, here is
that
the
still remains.
note is that the not claim. But peon has not been examined. Who has not? Who has? Can you
There
see
is
the order?
presumption of service if the address is correct.
Court's order, my lord.
Your own address in the 125 application, you have given an address.
If I am residing there, so why should I refuse it? Because not claim is that the mark is that not claim.
If
But
it is
peon-
attempted to be served at the sent at the correct address, but still not claimed by you, there is a presumption of good service. That is settled. And also this delay you have not explained. The delay is also explained by this lack of knowledge also.
No, petitioner always wants to decide with her husband.
That is a general presumption. There may be several reasons why you...
There before losses, kindly demand the matter so that I can contest the suit.
That will be allowing your appeal. That is not very humble prayer. That's a very bold prayer. Let us hear Mr. Chaturvedi. We'll try to dispose of this appeal if possible right now. Either dismiss it or allow it for Yes, Mr. Chaturvedi, what do you say? You want to add anything? If you want to add anything, finish it because then we'll go on to him.
That is the only point that is I have no knowledge at all.
Yes, Mr.
Because
Chaturvedi.
service was not properly made.
Two things you will have to overcome apart from other things. One is that written objection, wrong number of the suit was given. That is her contention.
Right.
Secondly, that immediately after this decree, although they have never produced this document in the trial court, but they have produced it here, which says immediately after you issued an eviction notice at the Newtown address.
Yes, Milord, I come to that.
And
Lord, first,
evicted.
You have also been evicted.
Yes,
Evicted, every lock, stock, barrel in the street.
because
I mean,
already,
if you cannot fight directly, you just try to fight indirectly and throw me out in the street.
You are
because
sufficiently prejudiced. Let us hear him now. Yes.
that already continued in favor of his son.
Lord, kindly cease.
দিন ওটা আপনি ডায়েরি ফাইরি
এটা
দেখছেন
আরেকটা Lord, kindly seize the number, Lord. I hand up, Lord, another copy. Kindly seize.
2465.
This
And in
is
that-
not the number. And then, Lord, the suit was renumbered.
Yes, yes, this is the correct number.
And this is, Lord, what is mentioned in, Lord, the order. Lord, my Lord's order dated 22nd June 2026 required of them to file my written objection to their Order 9 Rule 13. Lord, wherefrom, Lord, it would be, Lord, evince that in that objection itself, Lord, I have mentioned that in the criminal proceedings under 125, I had mentioned that a suit is pending and this is a number. Now, my Lord wanted to see whether I have stated so in my written objection or not. Lord, I have copies of the written objection if my Lord feels the learned trial judge has held it. If my Lord wants to verify, I have the copy.
No, written objection to this order and Luther.
My Lord.
No,
Then-
you're saying that we take it.
And my Lord, the learned trial judge, my Lord, has recorded that in the miscellaneous proceedings, my Lord, also, my Lord, she has, my Lord, admitted that yes, I have been informed that a suit is pending. Now, my Lord wanted to know, Lord, whether there was, my Lord, any evidence adduced in Order 9 Rule 13. In Order 9 Rule 13 also, my Lord, evidence, my Lord, was adduced. Where, my Lord, she admitted that yes.
Yes, that recording is there in the impugned order itself.
Yes, but my Lord wanted to verify with the records, my Lord directed them to annex these two documents in the supplementary affidavit. The leave was granted precisely for this. And both these documents, my Lord, are missing from the supplementary affidavit because these documents would not inure any benefit to them. Now, my Lord, kindly see, my Lord, what is the scope, my Lord, of Order 9 Rule 13? Either the summons have not been served or that she has been, my Lord, sufficiently precluded. I have knowledge of the suit. When did I have knowledge of the suit? Lord, I have knowledge of the suit on 14th of August 2014. Lord, where do
This objection filing date.
Yes, receiving the copy of it. My Lord would very kindly, my Lord, get that.
Through an advocate, not directly.
Sir, please.
Yes, 28th of August 2014.
My Lord. Now, this is, my Lord, the date, my Lord, on which,
Yes.
my Lord, she comes to know. The suit is, my Lord, decreed sometimes in the month of November or December 2014. So she had knowledge. So, my Lord, the second part of it, my Lord, of Order 9 Rule 13, my Lord, she cannot overcome. But now the first part of it, my Lord, the summons have not been served. My Lord, the court, my Lord, records, my Lord would find, my Lord, in the supplementary affidavit which they have used. Court records, my Lord, there is a satisfaction on page 40, my Lord would see. Prior to that, my Lord, kindly comes to page 39. Lord, application under Order 5 Rule 20 is, my Lord, allowed. My Lord may kindly not strain my Lord's eyes.
To decipher this order, we have to strain our eyes.
No, my Lord, the application is allowed. My Lord, kindly.
What's that?
My Lord, if I can interject, my Lord.
No, not now, not now. We'll get your turn. Take your seat, Mr. Raman. We'll call upon it. Yes. Yes, Mr. Chaturvedi.
Now, my Lord, kindly see, my Lord, the next page. My Lord, this was, my Lord, order number.
No, they have raised the point, Mr. Raman has raised the point that the modalities prior to Order 5 Rule 20 newspaper publication have not been complied with.
My Lord, I come to that. My Lord, I address that. Lord, what is the scope of an appeal, my Lord, from an order passed under Order 9 Rule 13? This is not a regular appeal that all orders can be subject matter.
No.
So this order, my Lord, was accepted. This order, my Lord, was never challenged. And the principles, my Lord, of res judicata, my Lord, would apply at different stages of the self-same proceeding. Now, my Lord, kindly see, my Lord, Order 8, my Lord, allowed my application. And Order number 11, my Lord, records a satisfaction with regard to compliance by paper publication. And thereafter, my Lord, this was, my Lord, fixed for ex parte hearing.
No, we'll just go through that order at page 39 once.
My
sir.
Lord.
So, Faiz Hazira, taken up. Peruse the record from such and such. Lying in the record. Number of occasion.
An envelope are produced
Registered envelope returned,
with the comment
not claimed.
But peon has not been examined. Then my lord, bailiff service must be there.
Yes, let them complete. Wait a minute. Yes, Mr. Dubey, what?
Now, my lord, kindly see the second proviso to Order 9 Rule 13.
Yes.
Provided further that no court shall set aside a decree.
Irregularity, yes. Irregularity in service of someone.
So, Lord, what Lord really has happened is that Lord, there is a Lord direction that I should take recourse to Order 5 Rule 20. I Lord did take recourse to that. I complied with it. The court records the satisfaction. What my learned friend today is pointing out is Lord, there are some irregularities at a stage anterior to Lord Order 5 Rule 20 being allowed. That Lord cannot vitiate. Lord is the second proviso, Lord.
Yes.
And that Lord she had knowledge well before the suit was decreed. Lord, that emanates Lord on an admission, because I have served the copy on 14th of August 2014. She admits that, my lord, in the evidence in the proceeding itself. My lord, may kindly Lord, permit me to show that portion.
But when you had filed that written objection, Mr. Chaudhary, it had already been renumbered. Although they could have still searched.
Yes, yes, my lord.
There are no two numbers before the district judge of the same year. Not two matters cannot be allocated the same number.
If I search for the original number,
that will
I get the connected number.
Yes, definitely.
Because Lord, the original number, it may have a different year, may not have a different year.
No, if it is specified that it is this number of this year before the district judge,
yes,
that can be traced out.
Yes,
the current number can be traced out.
It is not her case that she made an endeavor but could not search it because of wrong number. Milord, I indicated from the certified copy of the order, Milord, both the numbers are Milord mentioned. Both the numbers are mentioned there. She could have got back to my learned advocate saying that you have mentioned a wrong number. I did not find.
Which order mentions both? This,
Lord,
the one we handed over?
Yes, Lord, kindly see, both the numbers are mentioned there.
After obtaining the decree of divorce, any communication is there?
Yes. No, where? This order? The one we handed over, Mr. Chaudhary?
My lord. Lord, it mentions Lord 2-4 at the top, my lord.
Top is 174 of 2013. 2465 is there, yes.
Yes. So this was a number. 2465 is a number that I mentioned.
Yes.
And then it was renumbered as 174. Both the numbers are appearing. She could have searched with either of the numbers. Now, Lord, kindly sees Lord her own evidence in the Order 9 Rule 13 proceeding.
No, in the certified copy that might have been put later on.
No, what I am on is.
No, could have searched. If the district judge number is given, then it could be
I
searched.
say, my lord, let us not assume a situation. I say that I have not mentioned, I have put the number blank and I have served a written objection. Lord, what prevented her, my lord, from seeking a clarification? You have mentioned this. Where is the suit? What is the suit? Give me the details.
Very.
Lord, this is not the evidence, my lord.
Of the Order 9 Rule
13.
The learned trial, the Order 9 Rule 13 judge also mentioned about that admission.
Yes, yes.
You are wanting to show something else also.
No, my lord. My lord.
That admission.
I am only, my lord, trying to comply with my lord's order dated 22nd June 20.
No, if you want to place any particular portion.
Nothing more. Nothing more.
Achha.
Because my lord's desire was, my lord wanted to see.
Yes,
this.
we wanted to actually.
And that is
how
what
we recollect actually.
Lord, the.
Yes, yes, that admission will also be fine.
Lord,
that is all.
And my lord, the decision, one decision, my lord.
Yes, please cite why it is apologetic. Let them complete, then we'll come back to you so that you can comprehensively reply, not piecemeal.
Judgment. So this is 2011 volume 3 Supreme Court cases. page 545.
Second proviso.
This was not relied upon by the learned trial judge also, but I tried to find out lot of better judgment on this, whether this has been relied upon even later, but exhaustively, my lord, this is the one, my lord, hence, my lord, I thought that I should rely on the same judgment. But
Absolutely.
kindly see, my lord, paragraph 12.
12, yes. Right. The language is mandatory.
Yes.
Negative language.
Yes. So, my lord, court, my lord, has to arrive, my lord, at a satisfaction that the prevention was, my lord, under either of the two, my lord, contingencies.
Right.
Then, my lord, paragraph 16. In order to determine the application under Order 9 Rule 13, the test has to be applied is to whether the defendant honestly and sincerely intended to remain present when the suit was called on for hearing and did his best to do so. Sufficient cause is thus a cause which the defendant could not be blamed for his absence. Now, she knew about it. She chose not to attend it. She did no due diligence work. And then, paragraph 22. The High Court held that the presumption suit rebutted by a bold statement made by the respondent by she was living at a different address with her brother, and this was duly supported by her brother, who appeared as a witness in court. The High Court erred in not appreciating the fact in the correct as a substituted service is meant to be resorted to serve the notice as an address known to the parties where the party has been last resided. This sufficiently addresses, my lord, what she is saying. Then, my lord, paragraph 26. When should, my lord, the court, my lord, interfere? My lord knows it, my lord, but
no, please.
Paragraph 26. The first appellate court should not disturb and interfere with the valuable rights of parties which stood crystallized by trial court's judgment without opening the whole case for hearing both on questions of law and facts. Most of the appellate court should not modify the decree of the trial court by a cryptic or without taking note of all relevant aspects. Otherwise, the order of the appellate court would fall short of consideration expected from the first appellate court in view of provisions of Order 41. This is only, my lord, rights, my lord, have crystallized. My lord, today, what is being attempted is, my lord, on a frivolous plea, my lord, which is sought to be, my lord, depicted as make-believe. My lord, my right which has crystallized, my lord, are sought to be upset. Those are my respectful submissions.
Yes.
Lord,
Mr. Chaudhary, please take your seat. We'll just yes.
Can your lordship sustain an order which orders on the basis of a wrong, section? Will not kindly see the decree of divorce, which writes 27V3D, the non-existent section, Lord. Whether it is not a serious infirmity in the order. There is no 3D. It has been repealed.
How can I look into this? Unless you cross the hurdle of Order 9 Rule 13. You cannot look into the veracity of the original decree.
We mentioned it there, but
you have to cross the hurdle of Order 9 Rule 13 first. You cannot look into the original decree. What is your answer to these arguments?
Original rule.
You submitted that this was a wrong number. We find it is the correct number.
Lord, at the date when he submitted this.
Yes, so what? The district judge number is given. You could have easily traced out. Anybody and everybody can go to the court. Even a layman goes to court and gives the number, give the number and the year and the
told that this has been fictitiously done.
No, these are making these up before the court.
Then we not actually. Well, the Order 9 Rule 13 order says that service was done at both Rajarhat and where is service in Rajarhat?
We are not bothered with that. If one address service was given, that is sufficient.
He's wrong.
That was the address you gave in your 125 petition.
But they are serving in Rajarhat. He also knew that
their service is immaterial. If one address, you have given one address in your 125,
that was done.
You have served there. You have admitted that they disclosed in the written objection in 2014. You filed your 913 in 2017.
That was the thing. He has
you waited for it to be an expiry decree to pass to harass him to reopen this again.
Let me finish. He filed the divorce petition in 13 itself.
Maybe.
And in 13, Maxut was there, 93 of something.
Yes, we understand.
Then all along, he all of a sudden, after 4 years of this Maxut going on, and his 8 months was actually, he got the...
Don't make new arguments, Mr. Roman. Answer his questions. And answer his points. He has cited a judgment which says relies on second proviso. What is your answer to that? We have made your arguments on merits. Now, what is your reply to these arguments?
Even considering the fact that I was staying in Baripur, though I was not in Baripur, there was no service. It was said that no claimed. Not claimed means then the examination of this belief or examination of the peer was to be there. This is primarily.
Not only, may point.
Yes, we are passing our judgment. We cannot hear both of you.
Only one thing, my lord. Kindly see the impugned judgment, page 2, my lord.
Yes.
The opposite party's defense. In the affidavit in chief and deposition, the opposite party contends that proper service was effected on the petitioner. Initially, summons were sent by the registered court at both her Rajarhat and parental address. Absolutely wrong. Absolutely wrong statement.
In
Relying
view of
upon the wrong statement, my lord.
we are passing out. In view of sufficient arguable questions having been raised, comma, the appeal is admitted to be heard on the grounds taken in the memorandum of appeal. Full stop. Next para. Since the conspectus of the appeal is short, comma, we take up the appeal itself for adjudication along with the connected application. So next para, the present challenge has been preferred against an order whereby an application filed by the appellant wife under Order 9 Rule 13 of the Code of Civil Procedure, comma, for setting aside an ex parte divorce decree obtained by the respondent husband, comma, was itself dismissed on contest. Full stop. Learned counsel. Next para. Learned counsel for the appellant argues that from the annexures to the stay application filed in connection with the present appeal, annexures to the supplemented affidavit filed in connection with the present appeal, comma, it would be evident. Annexures to the supplementary affidavit as well as the stay application. It will be evident that immediately after obtaining the ex parte matrimonial decree, comma, the husband issued an eviction notice to the Newtown address of the appellant wife where she was residing then, comma, thus proving that the respondent husband all along had knowledge of the wife's residence at the Newtown address. Full stop. Despite the same, comma, no notice was served at the same said address. Full stop. Next para. Learned counsel submits that the recording in the impugned order to the effect that the appellant wife was served at both addresses was erroneous. Full stop. Next para. It is next argued by the appellant that the Order 9 Rule 13 application was filed late due to the appellant wife having no knowledge, comma, nor any summons of the suit being served on her during the relevant period. Full stop. Upon acquiring such knowledge, comma, the appellant wife immediately preferred the application under Order 9 Rule 13 of the Code of Civil Procedure. Full stop. Next para. Learned counsel submits that the learned trial judge erroneously proceeded on the premise that the appellant wife admitted in her evidence in connection with the Order 9 Rule 13 application that her husband had mentioned the pendency of the divorce proceedings in his written objection filed in case number 33 of 2013, comma, which is the maintenance application filed by the appellant wife under section 125 of the Criminal Procedure Code. Full stop. However, comma, despite the matrimonial suit having been renumbered on the said date, comma, the respondent husband had erroneously given the original number of the suit, comma, thereby misleading the appellant wife, comma, which prevented her from taking information regarding the suit. Full stop. Next para. Learned counsel for the appellant next argues that the learned trial judge did not take into consideration that Order 5 Rule 20 of the code was resorted to at the stage of hearing of the suit without prior compliance under the previous provisions of Order 5, comma, which were mandatory prerequisites for resorting to substituted service. Full stop. Next para. It is further argued that the court bailiff stroke process server was not examined at all in order to ascertain whether due service of summons was effected on the appellant wife, comma, thus vitiating the entire alleged service of summons on the appellant. Full stop. In such view of the matter, comma, it is argued that the impugned order ought to be set aside and an opportunity to be given to the wife to contest the suit. Full stop. Next para. Learned senior counsel appearing for the respondent husband places reliance on the second proviso to Order 9 Rule 13 of the Code of Civil Procedure, comma, in conjunction with Porimal versus Veena alias Bharti, reported at 2011 3 SCC 545, where the principle laid down in the second proviso was reiterated, and the Honorable Supreme Court was pleased to observe that the legislature, comma, in its wisdom, comma, made the second proviso mandatory in nature, and thus it is not permissible for the court to allow the application under Order 9 Rule 13 in utter disregard of the terms and conditions incorporated in the second proviso therein. Full stop. Next para. Learned Senior Counsel also cites the self-same judgment for the proposition that in order to determine an application under Order 9 Rule 13, comma, the test that has to be applied is whether the defendant honestly and sincerely intended to remain present when the suit was called on for hearing and did his best to do so. Full stop. In the present case, comma, the appellant wife, comma, despite having knowledge of pendency of the suit, comma, did not make any endeavor to contest the same. Full stop. Thus, comma, the benefit of Order 9 Rule 13 ought not to be granted to her. Full stop. Next para. Learned Senior Counsel further places reliance on the copy of the written objection filed by the respondent husband in the maintenance proceeding of the wife, from which it is evident that the written objection was served on the appellant wife on August 28, 2014, whereas the application under Order 9 Rule 13 was filed only in the year 2017. Full stop. Thus, comma, the delay in filing the application remained unexplained. Full stop. Next para. Learned Senior Counsel argues that the orders of the learned trial judge in connection with the matrimonial proceeding, comma, also annexed to the supplementary affidavit filed by the appellant wife, comma, indicate that video order number 8 dated July 4, 2014, comma, the trial court had recorded its satisfaction that due efforts were made to serve summons on the appellant in due process of law, and that service was required to be made by the mode of substituted service under Order 5 Rule 20 of the Code. Full stop. Next para. In view of the appellant having not preferred any challenge against the said order, comma, the same, comma, it is submitted, comma, has attained finality and cannot be reopened. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find sufficient force in the arguments of the respondent. Full stop. Next para. The premise of the present challenge is that the appellant wife did not have any knowledge of the suit at the relevant juncture. Full stop. However, comma, such stand of the appellant is belied by the copy of the written objection filed by the respondent husband in connection with case number case number M-93 of 2013 before the judicial magistrate at Baripur, comma, that is the application filed by the appellant wife under section 125, comma, Criminal Procedure Code. Full stop. From the very first page thereof, comma, it is clear that a copy thereof was served on the learned advocate for the appellant, comma, from whose custody the said written objection comes, comma, on August 28, 2014, comma, about 2.5 years prior to filing of the application under Order 9 Rule 13. Full stop. In paragraph number 16 of the said written objection, comma, the respondent husband had mentioned in no uncertain terms that one matrimonial suit vide number 2465 of 2013, 2465/2013 was pending before the learned district judge at Alipur against the appellant wife. Full stop. Next para. We find from the orders passed in the suit that the self-same suit, comma, the number of which was given in the written objection, comma, had in the meantime been renumbered as matrimonial suit number 174 of 2013 upon the same being allocated to the learned additional district judge, comma, first court at Alipur for adjudication. Full stop. Next para. However, comma, the argument of the appellant that the previous number was disclosed erroneously even after the suit was renumbered, is specious, SPECIOUS, and cannot be accepted. Full stop. Merely by searching in the Alipur court with the previous number of the suit, comma, anybody and everybody could have obtained an information as to the current number thereof. Full stop. Hence, comma, since the correct original filing number of the suit was disclosed by the respondent husband to the appellant wife as long back as on August 28, 2014, comma, the appellant wife cannot feign ignorance of the pendency of the suit at that juncture itself, and could very well have ascertained the current number of the said suit and contested the same. Full stop. However, comma, despite such opportunity, the appellant wife waited till the suit was decreed ex parte before filing the present application under Order 9, Rule 13 of the Code. Full stop. Next para. The proviso to the second proviso to Order 9, Rule 13, comma, as reiterated in Porimol versus Vina Supra, comma, is couched in mandatory negative language, comma, stipulating that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of summons, comma, if it is satisfied that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. Full stop. Next para. Although the specific knowledge of the defendant stroke appellant about the date of hearing is not found from the materials before us, comma, nonetheless, comma, it has been established beyond doubt that the respondent appellant had knowledge of the pendency of the suit at least in the year 2014 from the written objection filed by the respondent to her maintenance application. Full stop. Next para. Hence, comma, the mere irregularity in compliance of the prerequisites under Order 5, Rule 19 and the prior provisions cannot be resorted to by the appellant to have an order under Order 9, Rule 13 of the Code in view of the second proviso thereto. Full stop. In Porimol versus Vina, comma, the Honorable Supreme Court categorically observed that it is not permissible for the court to allow the application in utter disregard of the terms and conditions incorporated in the second proviso to Order 9, Rule 13. Full stop. Next para. In the said report, comma, the Honorable Supreme Court further took into consideration the presumption of service by registered post and burden of proof, and held that the High Court in the said case erred in not appreciating the facts in the correct perspective, as substituted service is meant to be resorted to serve the notice at the address known to the parties where the party had been residing last. Full stop. Next para. It was further held that it was nobody apostrophe case that the respondent wife in the said case made any attempt to establish that there had been a fraud or collusion between the appellant and the postman, and not a single document had been summoned from the post office, comma, nor was any attempt made by the respondent wife to examine the postman. Full stop. Next para. The factual scenario as discussed in the cited report is similar to the present case, comma, where the appellant wife seeks to take shelter under alleged non-examination of the postal peon. Full stop. However, comma, in view of the appellant not having chosen not to appear in the suit and contest the service of summons by due course, comma, there was no occasion for the court to examine the postal peon. Full stop. Thus, comma, the substituted service under Order 5, Rule 20 of the Code cannot be vitiated merely due to non-examination of the postal peon, comma, for which no occasion had arisen at that juncture. Full stop. Rather, comma, the law of evidence in India attaches a presumption of correctness to judicial acts. Full stop. In the present case, comma, such presumption of correctness of the observations made by the court while accepting due attempts on the part of the plaintiff husband to serve summons and directing substituted service has not been rebutted in any manner whatsoever. Full stop. Next para, even otherwise, comma, such allegations pertain, such allegation is confined within the domain of double inverted irregularities, double inverted clause, in service of summons at best, comma, thus coming within the mischief of the second proviso to Order 9, Rule 13 of the Code. Full stop. Next para, as such, comma, the argument of the appellant regarding no service having been shown to be effected at her Newtown address is neither here nor there, since it was the Baruipur address of the appellant wife which at which service of summons was duly sought to be effected and substituted service was also effected. Full stop. The Baruipur address was disclosed by the appellant wife herself in her application under section 125 of the Code of Criminal Procedure, which was never amended by her. Full stop. Next para, thus, comma, the ratio laid down in Porimal versus Veena squarely applies to the present case. Full stop. In view of the above observations, comma, we do not find any illegality or legal or factual error in the impugned order to justify interference by this court. Full stop. Accordingly, FMA 259 of 2026 is dismissed on contest, comma, thereby affirming the impugned order dated August 26, 2025, passed by the learned additional district judge, first court at Alipur district, South 24 Parganas, in miscellaneous case number 2 of 2017. Full stop. Consequentially, can 1 of 2026 is also dismissed. No orders to cause urgency. Sorry. Thanks. Yes, just remind us.
Defendant in a suit originally filed for eviction under Section 6 of the Premises Tenancy Act. Plaintiff amended to include a ground under Section 2G.
Yes, yes.
No pleading of title, suit gets dismissed.
Just half a second. এই অনিন্দিতা তোমার কাল যেটা অর্ডারটা ওনারটা দিলাম তারপরে যেহেতু ওটা বেরিয়ে গেছে না ওটা আর নেই যেটা দিয়ে কাটতে বললাম ছেড়ে কোথায় আছে খুঁজে বার করতে হবে নতুন করে দিয়ে দিচ্ছি ছেড়ে that order was still there probably. Anyway, so section 6 originally
Section 6 of the Premises Tenancy Act
amended to 2G.
amended to 2G. Amendment not challenged by me. Trial court holds that plaintiff does not have an averment of title or ownership, no document of title produced. If you want to proceed under Section 2G, you have to show your title. You have failed to establish your title, suit dismissed. In the appeal, they file an application under Order 41, Rule 27, seeking to disclose and rely upon their documents of title. Order 41, Rule 27 is allowed by the first appellate court without assigning any reason, and suit is remanded back for fresh trial, giving him liberty to adduce evidence on those documents. That is the order under challenge.
Now, Mr. Bose, one aspect of the matter, because it was dismissed on the ground of this title documents not having been produced and all. So, but why shouldn't we resort to Order 41 Rule 27B probably, the court's power?
Documents were in his custody. He has not made out a case that he is the owner of the suit property. He cannot lead evidence of ownership without a pleading in the plaint. I have the plaint, Manat.
Till date, that after the amendment also there.
No. When they amended it under 2G, in the amended plaint as it stands today,
although
there
the
is no
present
pleading
appeal
of
has
ownership.
despite service, none appears for the caveat respondents. Full stop. This is the second such occasion. Full stop. It was recorded in the order dated July 13, 2026 that a last chance was given to the respondents to contest the matter. Full stop. Despite the same comma, since the caveator stroke respondent chooses not to appear, comma, we take up the matter for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Ex parte, full stop. Next para. Although the present first miscellaneous appeal has been preferred against the judgment of remand, comma, we consciously formulate substantial questions of law in view of the appellant having also challenged the impugned judgment on merits, not limited within the confines of Order 41, Rules 23 to 25 of the Code of Civil Procedure. Full stop. Next para. The present appeal will be heard on the following substantial questions of law. Roman 1. Whether the learned judge of the first appellate court substantially erred in law in overlooking the specific rigors of Order 41, Rule 27, within bracket 1, within bracket AA, small aa of the Code of Civil Procedure, in permitting the plaintiffs stroke respondents to adduce evidence in respect of their alleged ownership in respect of the suit property. Roman 2, whether, in view of the absence of pleadings as to title of the plaintiff's respondents, the learned judge of the first appellate court traveled beyond jurisdiction in permitting evidence to be adduced in support of such purported title beyond the pleadings. Roman 3, whether the you had said that you had not challenged that amendment order.
No.
Whether the learned courts below were justified, whether the learned first appellate court was justified in not interfering with the order passed by the learned trial judge, permitting the plaintiff's respondents to amend their plaint by converting a suit originally filed under Section 6 of the West Bengal Premises Tenancy Act 1997 to a suit for declaration of title and eviction under Section 2 within bracket small g of the said Act, thereby converting the entire paradigm and statutory regime of the suit as originally contemplated. This much. Any interim
application for stay, my lord.
There shall be stay of operation of the impugned judgment. No, sorry. There shall be stay of all further proceedings in
Ejectment suit number 18 of 2013.
Ejectment suit number 18 of 2013 pending before the learned
Court of the Civil Judge Junior Division,
yes,
First
yes, learned Civil Judge Junior Division, First Court at Shialda, District South 24 Parganas. After remand, this is not 24 Parganas.
South.
In your application, we'll give you liberty to correct. This you are sure South. District South 24 Parganas till disposal after remand till disposal of Can 1 of 2026. Full stop. The appellant shall serve copies of Can 1 of 2026 on the respondents, indicating that the application shall be listed for hearing in the monthly list of August 2026, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Next para. On the prayer of learned counsel for the appellant, leave is granted to the learned advocate on record for the appellant to rectify the caption of the memorandum of appeal and the connected application insofar as the district is concerned. During the course of the day.
Police station. Yes, Narkeldanga police station should be South 24 Parganas.
Police station also?
No, Narkeldanga police station should be South.
Should be South.
Not be North.
Should be South. Is concerned. But do that during the course of the day.
Yes, yes.
During the course of the day.
Yes.
Yes. Thank you.
Obliged.
Well, Inspector, occasion to appear in the matter.
I had the occasion. Oh.
At one stage, in connection with the grant of property,
Right.
grant of.
I appeared for your client.
No, with your respondents.
Acha. Very well.
Respondents.
You are for the appellant here. Learned counsel for the appellant hands over a copy of an order dated June 22, 2016.
For the marking.
Passed in CO number 426 of 2016 with CO 527 of 2016, from which it transpires that one of us, bracket our full name, had appeared, while at the bar, for one of the parties in a proceeding between the self-same parties. Full stop. Accordingly, for the sake of judicial propriety, let the matter stand released from our list with liberty to the parties to seek an assignment before a different bench from the Honorable the Acting Chief Justice. A copy of the said order be kept on record. We are giving. Thank you.
It's very unfortunate, but yeah.
No. Thank you very much for pointing out. Otherwise, we'll be embarrassed. And Mr. Basu would be embarrassed also. No, I appeared for your client. Oh, you are appealing with
It doesn't matter. I say that remind it on my lord. It may happen that something is due and not paid. Now it is reminded again.
Thank you. No, that would be barred by limitation.
What is going on barred by limitation?
No, thank you very much for that. Thank you. We appreciate that.
Suit for declaration and injunction.
You are prepared. You vomit your preparation before the other.
Suit for declaration. দাও না।
You are in the next matter.
So early.
Put your finger in every pie, Mr. Basu. You have been commenting so much. We thought you are in that matter.
I have thought my lord is reminding those days. What happened?
You are not reminded of anything. What is your matter?
Suit for declaration.
Nothing in it.
Injunction granted. Injunction extended. Thereafter, my lord, the plaintiff died. The following day, within the time, substitution application filed, and application for the extension was filed. Injunction has been rejected. That substitution not been effected.
So for the other side, it is disposed of the appeal itself.
I am praying for not today, my lord.
No, not granted. Not granted. You have got the taste of blood. So
39-4 pending. Everything is pending.
no,
It's a substitution application, my lord. Which
substitution application is filed within time. That is sufficient.
time, my lord.
Language
we
is that.
are testing the application because they have suppressed, my lord. There are 4 years. Only 2 name of 2 years have been gone in the substitution application.
Injunction could not be refused. Let us come to order 22 once. Even if one of the years is brought on record,
Enough.
so the suit does not abate.
49.
Suit does not abate. Let us come to order 22.
29 May died.
Plaintiff died or defendant?
Plaintiff died.
Here also plaintiff filed the suit. Justice Basu. Justice Basu. Yes.
So many things, my lord. It is when I appear before my lord, is reminded.
Mr. Mukherjee is only laughing me. And Mr.
Or my lord, your lordship can remind also the. Let me see my CPC.
Yes, that also. We actually are comfortable with our own CPCs.
But the plaintiff is the tenant of the property.
That explains it. But you are dealing the matter by asking for time. Your interest should be served if the entire appeal disposed of the injunction directed to be decided. Let us see the language once.
ক্যাবিনেট ফাইল আমি এভিডেন্স সার্ভিস ফাইল করেছি করেছি এভিডেন্স সার্ভিস দিয়েছি
Have you got a copy of the civil procedure code? Either you have to have a copy or you have to have it by heart.
The 29th May 2026 is the death.
Mr. Basu, let her come back tomorrow. She's come back tomorrow. Let her come back tomorrow, but tomorrow we don't take up order for turn.
Only difficulty is
when we are admitting the appeal and yes,
time my lord can protect.
injunction, yes. Then we'll admit the appeal and grant injunction. Then you come back for hearing of the application. Others, because from tomorrow onwards, we will not be taking this week order for turn matters. Injunction has been refused to them.
Not extended.
Not extended. The present appeal has been preferred against an order refusing to extend an order of ad interim injunction initially granted in favor of the plaintiffs stroke appellants. Full stop, next para. Learned senior counsel appearing for the appellants points out that an application for substitution of the heirs and legal representatives of the deceased plaintiff had been filed within the statutory limitation period and was pending on the date when the impugned order was passed. Full stop, despite the same comma, the prayer for extension of ad interim injunction was rejected only on the ground that the original plaintiff was dead and the application for substitution was not yet disposed of. For the next para, it is prima facie a clear case of dereliction of duty by the learned trial judge, comma, who was posted with the substitution application and could readily have allowed the same before taking up the extension prayer. So even otherwise, comma, the law contemplates only an application for substitution to be filed for the records to be correct. Full stop. If in the event such an application is filed within the statutory limitation period, comma, it is for the court and not for the party, comma, to allow such substitution and direct the suit to be proceeded in the name of the substituted heirs. Full stop. Hence, comma, a strong prima facie arguable case has been made out in the appeal. Full stop. Hence, comma, FMAT 812 of 2026 is admitted on the above questions, admitted to be heard on the above questions and the other grounds taken in the memorandum of appeal, full stop. In view of a prima facie case having been made out, comma, there shall the respondents, what was the initial order, Mr.
Initial page
Status
40.
Status quo in respect of the nature, character.
Both parties,
Page
both
46.
parties shall remain restrained by an order of status quo in respect of nature and character of the suit property,
Character and position.
Position and suit property.
nature, character and position. Anything else?
Page 46 is the
Nature, character and position of the suit property till disposal of the application, till disposal of Can 1 of 2026. Full stop. Next para. On the prayer of learned counsel for the respondents, comma, the application is adjourned and shall next be listed on, we are keeping it on Monday, on July 20, 2026. It will appear on July 20. To take instruction whether you concede to the appeal being disposed of. If you have your points, you can argue your points. No difficulty. Great.
এটা আপনার স্যার
21, my lord, I appear.
Yes,
for CRT. But there is a caveat, my lord, of the plaintiff.
Similar. You have served already.
Yes.
Yesterday we
Yesterday,
took.
my lord,
So we'll take up the matter. What can be done?
my lord. Lord, I'm the defendant number 1 and 2 in a suit for a declaration. The declaration pertains to the fact that, my lord, the plaintiff claiming himself to be the trustee, one of the trustee of, my lord, the Mulliks, that is, my lord, the Marble Palace Mulliks, says that I was one of the trustee, but I was not included when a lease was executed by my client, the defendant number 2 and 3, who are, my lord, the co-trustees of a lease in respect of defendant number 3 of a property which is situated, my lord, at 7A Kiran Shankar Rai Road.
Defendant number 3 is a company owned by the trust.
No, it's a third party.
Given to them.
Yes,
Lease given to them.
lease was given to them. So, my lord,
She did not consult them.
no, he says that I, being a trustee, I did not concede or I did not consent or I did not sign the lease deed at the time of its registration.
The trust deed permits you to do that.
Yes.
Which was the
Number,
injunction was refused, granted.
the injunction, my lord, he filed the suit in the year 2015. Initially, my lord, the injunction application was, my lord, dismissed on merit. Thereafter, my lord, there was a recalling application of that order under 151. It was recalled on, my lord, 21st of, my lord, May. In the 21st, May 21st. On the
Which year?
very next day,
This year.
2026.
Huh.
And on the very next day, my lord, it was fixed for injunction hearing, the 22nd of May. On 22nd of May, my lord, the injunction was granted. Now, my lord, the nature of injunction
Injunction
that was
application
granted
was redisposed of.
an injunction application was disposed of. This was, my lord, may I just take it?
Recalled on what ground?
No, recalled, my lord, that the plaintiff was unable to appear on the date when the matter was being heard, and that was, my lord, one.
You have challenged the subsequent injunction order.
Yes, my lord, I did not challenge the recalling, my lord. I should have. I
So
did not.
but
Lord, I am constrained with.
so you on merits.
Lordship.
So what injunction was granted?
Yes, my lord, your lordship will kindly come to the impugner 22nd of May 2026. The nature of interim order, my lord, that was granted. I'll just read out, my lord.
Yes.
In the memo of appeal, my lord.
Creating any further rights and
Yes. And my lord, the only finding considering the facts and circumstances going through the injunction application, that is not the finding of the learned judge.
further rights in respect of the suit property, inducting
Lord, in
further.
2015, my lord, already a lease deed has been, my lord, executed, a registered lease deed. He's challenging, my lord, the propriety of the lease deed, good, bad, indifferent. Prima facie, I can show before your lordship, he did not have any right under, my lord, the trust deed. The trust deed
Defendants are restrained from creating any further rights on the basis of the lease deed. Basically, it affects your lessee.
In fact, so.
You cannot
I have
transfer on the
already
basis
done
of
whatever,
you have already done whatever
is to
mischief
be
you
done.
had to do.
Yes.
So now
that
from
it really, my lord, it
so
is
how
that
how
yesterday
do you
Mr.
have
Rohit Banerjee, my lord, appeared. I told him that ask your client to prefer an appeal and have it tagged together. Because really
they are the affected party.
They are the affected person.
What is your locus standi? You are not even affected.
But not I am affected by the observation that the learned judge has made inside the order. That portions, Lord, I say that, Lord, I can show before your lordship to say that by referring to the trust deed.
Have they preferred an appeal? The lessee?
Not yet. আমার ছেলে গতকালকে বললো করবে, কবে করবে কে জানে। So, because the very premise that Lord he was
Let
inducted.
us see the trust deed whether you could.
Yes. Now your lordship will kindly come to Lord the trust deed, and I'll just Lord be very brief why I say that he did not have any right. Lord, that is at page Lord 15. But the portion Lord that what we are ওটা লেখার টাইপটা হলো 31. Typed is in 31.
Oh.
39.
হ্যাঁ না 31 এ শুরু হচ্ছে, 39 এ ক্লজটা। And thereafter your lordship will kindly come to Lord clause 14.
14 years.
Lord, the gentleman who has filed,
Yes.
his name is Topendro Molli.
Right.
Now, Lord, the Jitendro is the settler trustee. Jitendro had Lord 3 sons at the point when Lord the trust deed was executed. Dhirendro, Robindro, and Purnendro. Dhirendro, Robindro, and Purnendro.
Right.
So Jitendro Milord was a settler and he was also the trustee. Then kindly come to 14. If any one of the said trustee shall die, become illegally disabled, become incapacitated, refuse to act as a trustee, or resign from the trusteeship during the lifetime of the settler, we are not concerned about this portion. After what the settler had died. Then, Lord, the settler shall have the power to appoint a new trustee in his place and stead. If
the
any
settler
one of the-
dies, then the surviving trustees shall have power.
Yes. Then the surviving trustee or the trustee shall have power to appoint a new trustee in place and stead.
So opinion of the majority, you are the majority. Clause 615.
No, I am not. I am not. If there be any disagreement between the trustees under this present, then the opinion of the settler during his lifetime, that is not available.
Not available. Next.
Shall always prevail, and after his demise, the opinion of the majority, and if there be no majority, then the opinion of the senior trustee shall prevail.
You are the senior trustee.
No, Lord.
Neither.
I'll tell your lordship. The Dhirendro has Lord adopted Lord Topendro, who is the plaintiff, and Topendro is Lord my natural son. That is Lord Punnendro's natural son.
You are sufficiently confused, Mr.
Blood,
Mr. Mukherjee will continue after the recess. If possible, at least ask your learned junior to make a just a handwritten at least this genealogy. At least after Jitendro has 3 sons, Dhirendra, Robindra, and Purnendra.
Correct.
At least from then onwards, I mean, because something. I mean, at least.
And Lord, there will be only 2 persons, Lord, which I'll refer.
Dhirendra, whose son?
Dhirendra is the plaintiff Topendra is adopted son of Dhirendra and natural son of Purnendra. And Purnendra has another son, that is Lord Subhendra, who is my client.
So we'll start from here.
Yes, and that is
that's all. We'll continue.
Ajab.
Lordship, under compelling circumstances, Lordship, I'm seeking
In the
leave
middle of
to,
a matter, Miss Sally. You are seeking leave for what?
leave to file an appeal without certified copy
Yes, granted. Granted.
and Lordship,
And?
to move it tomorrow, my lord.
Why? What is that?
The urgency is, my lord, a sum of rupees 2.63 crores had been released in favor of the respondents. And Lordship, although Lordship, we have shown that this sum which has been released, that
So
is part
granting
of
leave
the,
to file without certified copy, Miss Sally, but not tomorrow.
then
Only
the day
leave.
after tomorrow, my lord.
No, no. Only leave granted to file it. Yes.
If they deal with the money, my lord, it is part of the joint family estate.
They
That is
refuse others also. Thank you. Yeah.
very well, my lord.
Kindly excuse, it is handwritten.
No, no, we wanted that only. Whatever. Yes.
But I tender my apology, my lord. I am
No, no,
for the
for-
defendant number 3. I was
This matter, sorry.
Yes, in this matter. And I'm for the defendant number 3, lessee, the one who is actually getting affected.
We're halfway through the matter, so let us complete.
Yes.
Yes, Mr. Mayor.
Now, my lord, kindly come to my lord the clause 14 that your lordship was reading, my lord.
Yes.
Now, my lord, the portion that I was, my lord, trying to impress upon your lordship was that, my lord, if any one of the said trustee shall die, now, my lord, none of the trustees had died.
No.
If any of the trustee dies, then, my lord, the question of induction of another trustee comes in. Then the question of majority comes in. Because, my lord, when the trust deed.
But even if the settler dies, then there is a provision.
No,
Settler has
even
died.
if the settler had died in the year 1962. The settler shall have the power to appoint new trustees. So, my lord, that is not, my lord, what we are concerned about, because the settler only had the reservation, my lord,
Right.
to induct. The
So this
second
entire
portion,
clause 14 is regarding.
if any one of the said trustees shall die,
Yes, yes.
become legally disabled, become incapacitated, refuse to act as trustee, or resign from the trusteeship after the death of the settler. So we are concerned about that second portion. The surviving trustee or the trustee shall have power to appoint a new trustee in his place and stead. Therefore, not the surviving trustee. Here,
That is
all
after the death of the settler.
Yes. So here, Lord, all the 3 trustees were alive.
Yes.
When, Lord, there was
So
an
they could have
induction.
appointed a new trustee.
Yes, it was in the year 1993, 21st of February 1993.
What happened?
Take your lordship to the resolution.
21st of February
1993.
What happened on that date?
The Topendro, the plaintiff, was inducted as a trustee. So that is his basic claim, that I have inducted as a trustee, therefore I should have been.
So all of you inducted.
No, my client did not. The Dhirendra and Lord, the other one, Lord, they inducted. Our contention
clause
is
15 is you are circumscribed by clause 15. If you did not agree,
that will not only be affected when any one of the trustee dies. The 14, the second portion is that if out of
15, we are saying.
No, 15 comes, after the 14 comes into play.
14 says if the settler dies, the prior portion does not apply. Settler, no trustee died. So when the settler dies, then the surviving trustee or trustees shall have power to appoint new trustee.
Your lordship will kindly, after the death of the settler, the surviving trustee shall have the power to appoint a new trustee in his place and stead.
Yes.
Lord, this only acts, Lord, if any one of the said trustee shall die. The previous page. If any one of the said trustees means, Lord, the remaining trustee excepting the settler. During the lifetime of the settler can only take new trustee. Settler dies.
If any of the trustees shall die, such and such,
become legally disabled, become incapacitated, refuse to act as trustee, or resign after the death of the settler.
If any
the
of the
surviving trustee or the trustee shall have the power to appoint a new trustee in his place and stead. So there he's talking about the other 3 trustees.
No, the second portion of clause 14, starting at page 39 says, if any one of the said trustees die, etc.
Yes. So none of the trustees died.
After the death of the settler.
The settler had died in the year 1962.
So therefore, one of the
there are 3 trustees.
So the trustees were never died. I mean,
because the debt of the death I have given before your lordship.
And so does shall. So shall die. Trustee shall die has to precede any of these things happen.
If any one of the trustee out
then
of the
only
3
the
remaining trustee, then they have a power to induct. Then the question of majority comes in.
Yes, yes.
Now, your lordship will kindly come to the resolution at page 48. But this is a resolution by which, my lord, according to my lord, the plaintiff, he was my lord, inducted as a trustee at page 48. This is 21st of February 1993, when
Yes.
3 of the trustees were alive.
তখন সব ট্রাস্টি অ্যালাইভ কিন্তু তিনজন মিলে খেলা করতে হচ্ছে। So if you say, Mr. Mukherjee, that if even after the death of the settler, if none of the trustees died, there is no scope of induction of anybody at all.
Because the settler has said, me as a settler trustee,
Yes.
and 3 of my sons as a trustee, during my lifetime, I can only take trustee. After my death and death of any one of the trustee, they cannot take another trust.
And clause 15 does not come into play at all.
As of now.
As of now.
As of now.
As of now. That pertains to any disagreement, but that has to be within the framework of the trust.
Yes.
14 and all.
So, my lord, my case is that the 14
So his
is, my lord,
appointment was bad.
appointment was bad. And, my lord, your lordship will see, for the second reason is that, my lord, the appointment was, my lord, as a substitution of the settler trustee. This is the second, my lord, limb of my argument will be, my lord, that he could not have been, my lord, done. But
Settler himself retained trusteeship. I mean, he also made himself a trustee. No, settler did not make himself a trustee.
He was a trustee.
He was also a trustee.
Settler trustee and 3 sons were
But
the
the
trustees.
language of clause 14 contemplates settler having after
2 parts.
the other trustees dying after settler.
After the death of the settler, that is
If
qualified.
any
by-
of the said trustees dies.
Yes.
Because 14 is if any one of the all his said trustees.
Said means, my lord, he has named the trustees in the
But does not
trustee.
include the settler. That is what we are saying. The said if the said trustees include the settler trustee also.
No, my lord,
Yes.
your lordship will kindly see, my lord.
Where does the
14,
settler make him?
one of the said trustee shall die, become legally disabled, incapacitated, refuse to act as a trustee, or resign from the trusteeship during the lifetime of the settler. First part.
Settler was also a trustee. Where do we find that?
Yes, my lord, that
Yes,
is,
page
my lord, is
34. 34.
Yes.
Settler hereby declares that no. No, what does settler appoint
Lord,
himself also?
yes, your lordship will kindly see the prelude, my lord, at page, my lord, and at page 32. Starts at page 31.
Yes, yes.
Your lordship will find the names. Thereafter, my lord, the properties that they are talking about, and thereafter, my lord, the settlers' family at page 32.
Family is there, yes. Diverse good causes, etc. Hereby grant unto the trustees all these messages. নিজেকে করেনি because Mr. Mukherjee, page 31 names him as a settler only,
No,
and
there-
only
there-
these 3 as trustees.
No, thereafter, my lord, he has also, my lord, I will just
You can just
try
find
to
out.
Find out, my lord.
We don't find the settler ever made himself a trustee anywhere.
But the Jitendra, Dhirendra, Robindra, and Purnendu. My lord, the second line, one part. Lord,
Page?
Lord, page 31.
Yes, 31, yes.
31.
That
your
is what you are
lordship.
saying.
That
Oh,
is
acha,
Jitendra is the
Jitendra
settler,
acha,
and
acha, acha,
Jitendra is also, my lord, the trustee. And also, my
All
lord, in the
right.
body, he has also given, my lord, that. So, my lord, he was the settler trustee.
So
the
then
Jitendra,
speaking against you, Mr. Mukherjee,
my lord.
why not the second limb of clause 14? Clause 14 is clear. If any one of the said trustees shall die during lifetime of settler.
My lord.
Now, then if any one of the said trustees shall die, become such and such, after the death of the so settler is distinguished from the other trustees
Yes.
by the very language.
Yes. There are 2 parts. During the lifetime of the settler, one thing, the settler only has the
And
right
after
to
the
induct.
death of the settler, the
Then,
trustee.
my lord, the other trustee, if any one of them dies, then, my lord, the question of induction of trustee comes. Therefore, my lord, during the lifetime of the named trustee in the trustee,
After the death of the settler, the surviving trustees also shall have the power to appoint a new trustee in his place and state. So this Tapendra could have been appointed as a trustee in place and state of the settler trustee,
no,
as
Lord,
per the second limb of
that
14.
is, Lord, my reading is, Lord, that if your lordship sees, Lord, the first 4 lines of clause 14.
First 4 lines, yes. During his lifetime,
That
we
settlor
forget
shall
it.
have the power to appoint a new trustee in
If
his
he's
place
alive.
and stead.
If he's alive. Now,
Very well.
that chapter is not
If
invoked.
any one of the said trustee shall die, become legally disabled, become incapacitated, or resign from the trustee after the death of the settler.
Oh. So two are disjunctive. Death of settler is disjunctive from the other trustees. Has to be the other trustee's death.
After the death of the settler, the surviving
All right.
trustee shall have the power to appoint a new trustee in his place and stead. So this is Lord our interpretation of Lord how the clause is working.
Appears to be correct unless they revert.
Lord, that is what Lord we ask.
So yes.
So Lord, the resolution of 1993 was taken when Lord the 3 of the named trustees were alive.
Now they have died. I mean, subsequently they have died.
No, subsequently all 3 have died.
But that point of time they were all alive.
Yes.
All right.
Now, Lord, that was the foundation of the plaintiff, Lord, to lodge a case to say that I was not a signatory nor consenting to the grant of lease, which was Lord of the year 1915. Sorry, 2015.
Second ground, you are taking something.
Now, Lord, the second ground was, Lord, when we come to the resolution, Lord, the resolution speaks of the fact,
yes,
Lord, that Topendra, the plaintiff, who has been inducted by Lord, two of the trustees, Lord, he was Lord appointed as a new trustee in place of late Jitendra Molli.
Yes.
So, Lord, there is no provision for Lord substituting Lord the settler by Lord the induction by Lord 2 of the trustees. The settler was Lord a separate, distinct Lord, and he has kept himself Lord the right to appoint.
Yes. Settler's lifetime, one trustee dies, settler appoints. Settler dies, one of the other trustees dies,
Then
the surviving ones they will appoint. Very well. Right.
So, Lord, this was the basis of Lord on which.
So you say that the appointment of Topendra is vitiated by contravention of this. Yes,
It is
very well.
We filed a written objection, Lord, as against the injunction application.
Now, this suit was filed by Topendra.
Topendra in the year Lord,
only Topendra.
Only Topendra, claiming himself to be the inducted trustee and not he claiming himself to be a trustee.
And declaration to that effect.
Declaration that the lease that was executed by my clients in favor of the defendant number 3 in respect of 7A Kiran Shankar Roy Road, that is bad because he did not consent, not agree to the lease. So it was a declaration for in the nature that the lease deed is bad in.
Respondent 3 is before us.
Yes.
You have not preferred any appeal.
No, my lord, I have not preferred any appeal. I am in fact the one who is affected. And I'm supporting Mr. Mukherjee's arguments. But
all right.
This is the maximum that I can do now.
Yes. You are for Topendra?
No,
you are
my
with
advocate
him.
on record.
Topendra is not before us.
No, but he filed the.
No, caveat. In the morning also we started with that. Yes. Anyway, so then, so what has been then? What?
An injunction was preferred, in connection with that suit where he has sought for a declaration. The injunction was in the initial stage refused. The suit was filed in the year 2016, whereas the registered lease was of the year 2015.
So ad interim was refused.
No, the
injunction dismissed. You said yes.
Because I filed a written objection.
So dismissed. Then
dismissed.
Then what happened?
Then they took
this recalled.
Recalled on a 151 application on the 21st of May.
Now the fresh injunction granted on 22nd of May. That is the impugned order.
Yes, that is the impugned order.
So let us see that.
Impugned order, your lordship will find the observations that had been made by.
That was also you are also heard there. You are heard.
I was present, but my written objection contentions were never considered by the learned judge.
It was revived means the injunction application as it stood originally and the written objection should revive. How does the adoption gain relevance? I mean, what is
it? It doesn't. Because
in the story
himself was the adopted son. In the Mollik Badi, that was
the custom maybe. In so many families, I mean, of your, I mean, previously it used to be the custom in
Yes,
other
because,
communities also.
Now here, my lord, the plaintiff was, my lord, the adopted by one of the brothers, my lord. He was the natural, my lord, the son of.
Yes, he was adopted by Dhirendra. He was the natural son of Purnendra. But that does not make a difference
No,
here.
it doesn't make a difference.
Whoever
But
he
it makes a difference when Purnendra is opposing his induction as a trustee, being his
Yes,
own
obviously,
son.
that makes a difference. Appearance. Plaintiff number 1. There were other co-plaintiffs also.
Not trust. Only the trust.
Oh, achha. No, your contentions were not not adjudicated out.
Not at all.
What was the previous suit dismissed?
But that was, my lord, I challenged. My lord,
The title suit number was very conspicuous. Previous title suit number.
oh, 420. Okay. 420 or 20.
So, but that was dismissed naturally.
Plaintiff has filed it.
Yes, my lord, that was a suit where we challenged, my lord, that particular resolution by which, my lord, the appointment was made.
But that was
suit was
dismissed.
dismissed for default, I am told.
9-9 comes in.
And they have already taken out a 9-9 application. তাই না? সেটা শুনানিটা কবে আছে বললি একটা। They have already taken out an application.
Then no adjudication on merits as on the veracity of that deed.
Yes, and your lordship.
9-9 prevents you from filing another suit. Does not automatically mean that your challenge was turned down on merits to that resolution. 9-9 merely prevents you from filing another suit if you don't have it restored.
Yes.
But does not take away any substantive right.
No. But here I am the defendant, as your lordship has seen.
Yes, exactly. So,
and then, my lord, the learned judge, my lord, comes and says, today also, my lord, that last page of the order before the considering, my lord,
yes.
Since, my lord, it is running ex parte against my client, and my lord, my lawyers were there, no petition for vacating the order of ex parte hearing against the defendant number 1 and 2, and thereafter, my lord, the learned judge, by considering the facts and circumstances, my lord, that is the only reasoning that has been given.
Mr. Mukherjee definitely would admit it would probably inure to your benefit if the caveators were present, actually.
Lordship.
Because staying this would be allowing the appeal. That is a difficulty. We can.
I would rather say, your lordship will kindly, my lord, I can ask, my lord, the learned advocate who has filed the caveat to come and, my lord, have it
that will be
out
better.
here. Lord, all that I am praying before your lordship, it should go back for a rehearing on merits. My written objection contentions, I can take your lordship, but it will
Why
be a
are
wastage
you
of time.
asking for that? Even you can win probably on this, on whatever you have submitted.
Lordship.
Because we can rely on that clause 14 itself.
And these are what I have submitted are there in my written objection.
Who lodged the caveat? Do you have a
না কেভিটি কবে আছে আমরা তো ওকে ডাইরেক্ট দিয়েছি তুই তো কালকেই তো একটা এভিডেন্স সার্ভিস ফাইল করে নামটা জানিস না না আমরা ওকে ডাইরেক্ট দিস ডিটেল 2015 ডিটেল চেঞ্জ মারিশা 2015 এর বললো তো
তাতে ফোন নাম্বার দেওয়া ছিল
2016 এসছি ওই জন্য আমরা আজকে ডাইরেক্ট
suit কি চ্যালেঞ্জ করছে লিস্ট ডিড টাইপ Yes, challenge the lease deed in the suit. Have you got a clue as to who has lodged the caveat?
But I am told, my lord, that he was addressed to, my lord, the party in person.
Then it will be difficult.
কেন দিয়েছিলিস?
মারিশা মাল্লিকের ফোন নাম্বারটা
Party in person lodged the caveat. Do you have a copy of it? Who lodged the caveat? That's what.
Morisha Mullik, she filed the caveat.
Know her? I mean, what she
I don't know, but we tried to call her, but the phone number was not existing.
Not existing.
No, that's why we have submitted to the party.
Office address is here in the old post office street or nearby.
Phone number থাকে তোরে?
Phone number is non-existent. That is what you learn.
This person is appearing in
Maurice Mullik.
Marisha.
But এই নিচে
whether you can serve soon. I mean,
the service is not in the এটা কে সই করেছে? তপন মল্লিক নিজে?
What's the address?
Of the
Caveat's advocate. Office address.
Muktaram Babu Street, 46 Muktaram Babu Street.
Will you be able
Of
to
the
serve?
party in person.
Will direct you to serve directly as well as the advocate and/or.
Very
And/or we are admitting the appeal and keeping the appeal and the application on Monday.
Lordship.
Learned-
এখান থেকে এইটুকুনি দিতে পারবি না?
The present challenge has been preferred against an order whereby an application for temporary injunction filed by the plaintiff stroke respondents in connection with a suit challenging a lease deed grant executed by the defendant numbers 1 and 2 appellants in favor of the defendant number 3 stroke. You are a pro forma respondent here.
No, my lord, I am a named respondent number 3.
Stroke respondent has been challenged and consequential reliefs have been sought. For some next para, the premise of the plaintiff case is that Topendra Mullik, the respondent of plaintiff stroke respondent number 1 was inducted as a trustee in respect of the subject property by dint of a resolution taken by some of the trustees dated February 21, 1993. Push up next para, learned senior counsel appearing for the appellants argues that in terms of clause 14 of the trust deed, Jitendra, the original settler, had the exclusive right to appoint a trustee if one of the other trustees, including the appellant's predecessor, died during the lifetime of the settler. Full stop. As per the said clause, if any one of the said trustees met his demise after the death of the settler, only in such event, the surviving trustees would have the power to appoint a new trustee in place and stead of the said deceased trustee. Full stop. Next para. It is contended that on the date of alleged appointment of Topendra, the plaintiff number 1 as a trustee, all the trustees were still alive, although the settler had met his demise. Thus, the provision under clause 14 of the trust deed empowering the trustees to appoint a new trustee could not be invoked at all, as all the trustees were then surviving. Thus, the very root of the appointment of plaintiff number 1 as a trustee is assailed by the appellants. Next para, learned senior counsel, in his usual fairness, also points out that a previous suit filed by the appellants challenging the resolution dated February 21, 1993 was dismissed for default, although as per his instruction, an application has subsequently filed for restoration of the same, which is still pending. Next para, be that as it may, it is argued that mere dismissal of the suit for default, although debarring the plaintiffs from filing a fresh suit unless the previous one was restored, does not take away the substantive right of the plaintiffs rights of the appellants to assail the veracity of the appointment of plaintiff respondent number 1 as a trustee. Next para. Upon hearing learned counsel for the parties, upon hearing learned senior counsel appearing for the appellant and perusal of the impugned order, it also transpires that the learned trial judge, upon recalling an earlier order dismissing the self-same injunction application, fixed the injunction application for hearing the next day and passed the impugned order granting injunction without adverting to the written objection filed by the appellants in connection therewith. Thus, a strong prima facie arguable case has been made out. Hence, the appeal, FMT 219 of 2026 is admitted, to be heard on the above questions and the other grounds taken in the memorandum of appeal. Next para. In view of the brief ambit of the appeal, this court intends to dispose of the hear out the appeal along with the application. Accordingly, since the caveators choose not to appear, despite service, the learned advocate on record for the appellant shall serve a fresh copies of the application as well as the memorandum of the appeal with a server copy of this order on the plaintiff's stroke respondent numbers 1 and 2, indicating that the matter shall be listed under the heading applications on July 27, 2026. We are giving you 2 weeks time. July 27, 2026, when an affidavit of service to that effect shall be filed by the appellants. First up, such notice shall be deemed to be a notice of the appeal as well. First up, in view of the appearance of the defendant number 3 stroke respondent number 3 through counsel, service of notice of the appeal on the said respondent is dispensed with. First up, the trial court records need not be called for, and the appeal shall be heard on the papers available before the court without preparation of any formal paperbooks. Thank you. এটার মধ্যেই থাক।
Let's serve the advocate as well as
Oh, yes. Serve copies of বললাম যে on the respondent plaintiff stroke respondent numbers 1 and 2 directly and or through their learned advocate and or through the learned advocate who lodged a caveat on their behalf in this court. And or so either of the two will suffice. Thank you.
Same as this.
থাকলে আজকে শেষ হয়ে যাবে দুবার করে
My lord, I am,
For the sum of the private respondent,
my lord, I am praying for not this week.
No, not this. No time. Then it goes out of the list. What is the matter about?
My lord, learned advocate is seriously ill.
Which learned advocate is seriously?
Sharathi Mondal.
Are you sure he is ill?
Yes, my lord.
What happened to him?
My lord, I don't have any instruction.
An adjournment is sought on the ground of illness of the learned advocate on record for the petitioner. Accordingly, let the matter stand adjourned till July 20, 2026.
Not only 29th.
20th July. July 20, 2026.
29th is.
Why 29th? 20th July you are fixing next month. 2026 is the year. Yes. Yes, Mr. Maitri. Yes. What have you challenged, Mr. Maitri?
The order passed by the tribunal.
I mean, what order? What is the order?
Lord, the or kindly see the impugned order direction upon the concerned respondent authority, my lord, to dispose of the proceeding under section 49.
You wanted an early disposal of the same?
I am challenging the proceedings of 49, 42. This is the, my lord, things for a moment. My land has been settled under the Homestead Act. The Homestead Act, my lord, the 49(2) cannot be cancelled. That is their appellate provision. Now the question is, my lord.
Land Reforms Act. Yes.
Only prayer for cancellation of the patra on the grounds the land in question has been settled by a lease for a period of 30 years by the government. This land is a royalty settlement patra in favor of the applicants.
That will be decided in the proceeding.
No, that is not the case. When the clients come to know that the lease agreement has been held, made the application before the ADMLR to cancel the lease deed, as because that I have stated in paragraph 11. That's because that application has not been considered disposed of. My prayer, unless and until that application is disposed of, the proceeding cannot be continued.
Where is the prayer in that application of yours? That was filed prior to this notice.
Prior to notice.
Prior to this notice.
This is the file on, my lord, 23rd September 2019. 91. 19. This is the page 73, annexure P6.
Page 73.
73.
What is the notice? First, let us see the notice, present notice, which you have challenged in that.
This is the notice. I'm doing only one. This is notice on annexure P4, page 58. That's stated.
Notice is prior.
That's true. After
Notice is
receiving the
prior.
notice, after receiving the notice, I made the.
That's true. Your other statement is then false.
I couldn't
That-
understand that.
You couldn't understand. We asked you thrice.
No, my lord, the things for a
And
moment.
she was nodding her head also. But
No,
then
my-
also you said that
For
insisted
submission,
it is
when
prior.
When I received the notice, we come to know that a proceeding I initiated for cancellation
We
of.
did not say that. We asked you whether your challenge was filed prior to the notice. We asked you thrice, you said yes, thrice.
This moment I beg to appeal. If it is so,
That is important because after getting the notice, if you take out an application, why
Yes.
should that be decided first?
that is true, my lord. My responsibility, if your lordship passed through both two different authorities, the AD mailer is the matter is pending. If it is the my lord, the lease deed cancelled, then the proceeding under section 49 goes. If your lordship decided.
So where is your challenge before the ADML? Where is your challenge?
That is annexure P, annexure my lord,
Page.
page 73. Page 73, annexure P6. And paragraph 11, kindly see, my lord, they have stated all the things. The points have been.
But Mr. Maiti, you can take all these points regarding the validity of that lease deed also before this authority in connection, because you are given a right of hearing, right? So on the
hearing.
on
My
the basis,
along with
please, let us just allow. You have challenged because on the basis of a lease deed, this notice has been given to you for cancellation of your patta. You have challenged the veracity of that lease. You can very well appear before the authority and point out the defects in the lease, the illegality in the.
That should be indicated simply put.
That is the only scope of your objection. You will be heard.
No, my lord, my response submission that.
Very well. We can add one line subject to hearing is what's clear that all your points are kept open and you will be able to you will be entitled.
My lord, the authority is separate. 49(2) proceedings, the authority BLRO, SDDLRO, and the my lord, the ADMLR is the cancellation lease. Lease deed granted by the.
So lease deed cancellation you have sought under which provision?
Under the ADMLRO.
Which provision of law?
That is the authority. That is the statutory public obligation.
Which statute? Which provision? We are asking that only.
That provision I have not, my lord, indicated.
Then there is no statutory provision.
Even that, my lord, if it is wrongly.
Lease deed cancellation, lease deed granted in favor of them. Lease deed granted by the state.
Lordship, 1998.
State. And his party is of?
Of your lordship, his party is in 2017-18.
That was of 1988.
1998.
Sorry, 1998. And his is of 2017-18.
17-18, because my lord, you have annexed RS case number. There is a case number 17-18.
Your patta is subsequent.
Yes.
No.
My lord, the one indulge, my lord. This is not only the patta. This is the proceeding. My previous, my lord, the predecessors, my lord, was the Borgadar, recorded Borgadar. Thereafter, my clients, the Borgadar.
Take all those points in the 49(2) proceeding.
But even in 15-1, your lordship, only 15A, your 1.
51A.
My lord, even in that, my lord, only one person is the legal heir.
My lord, my responsible submission to that, along with this order, the application ought to have been disposed of. Since, my lord, why? My lord, kindly see the lease deed issued on 1998 and effect from 1996. How can it be? And apart from that, when the position has been taken, that has not to whisper.
Let all this point be decided before
that
the
is true.
authority concern, your lordship,
I am
because
also
notice
playing
is
that.
prior to that.
I am also
But he
playing
has
that.
challenged the notice itself.
That is before the tribunal, not
Yes,
before.
obviously before the
Okay.
tribunal. এখানে তো
Tribunal
scope
ought
নেই।
to have taken into
See, you have
consideration.
challenged the notice before the tribunal, Mr. Maiti. Notice per se is not illegal.
Yes.
You don't find any
I
illegality.
will not say that.
You
I
are
am
saying
challenging
unless
the-
you say that you cannot challenge the
No,
notice.
my respectful submission. When I
Your
made the
challenge
application
was
before the tribunal, the notice and also the application before the DMLR.
sorry, Mr. Maiti, you are not correct. Again, you are making a wrong statement. Please come to the impugned order once. The present OA is filed challenging the legality, propriety, and correctness of the notice issued by the SDLR, appearing at page such and such. The notice, we don't find any illegality. It's duly issued under section 49(2). Your case is that this proceeding should be heard along with, cannot be heard along with different authorities. This proceeding should wait for your challenge to the lease deed. We don't find any substance in that.
No, that is what annexed in the tribunal. That the tribunal wrongly, my lord, not observed in this case. That is what
Let us see the prayer of your OA, original application. That will reveal everything. Let us see your prayer in the OA. Page 92 is your relief.
Yes. Sir.
A is to forthwith consider and dispose of the application as. Yes.
B, my lord. Relief sought for B.
A is also there to forthwith consider and dispose of the application as annexure F. What is that application?
Application, my lord. That is, my lord, the annexed in the, my lord, the
Page 73. That
73. Page 73.
To forthwith consider and dispose of the application. How can the tribunal dispose of the application?
Not tribunal. Tribunal may be direction given to the.
That is not prayed for here.
No, that is, my lord. My lord, the wrongly, my
Now,
lord.
what is the meaning of B? To pass necessary order from proceeding the cancellation of part-time means?
To pass necessary order from.
You don't understand this construction, Mr. Maiti? To pass the necessary order from proceeding the cancellation of part-time. You understand this?
I do appreciate, well, this is not my drafted. This is my.
Obviously, it is not drafted by. If you can understand, we'll understand.
But from the last portion, till disposal of the application and accept A to this application.
Till disposal of application cannot be a prayer and independent.
This is the meaning of the things, my lord. That is the
If
same.
you can't understand the meaning of your own application, Mr. Maiti, how are we expected? How is the tribunal expected?
By virtue of that, like clients cannot be penalized. My lord, by virtue of that, my lord.
Clients are always penalized due to the acts of advocates. Always, in every matter. Your client will be penalized due to your action. Because you are not being able to explain this.
Apart from that, my meaning, kindly appreciate.
Both the application is annexure F, your lordship. Kindly see. Prayer A, prayer B.
F.
F, if that application is F, then the second prayer also F. Application F. We don't know whether that is F in this application.
We don't know.
No, we don't know.
Supposing that is F.
F, then well, the next one, how can that be F also?
That cannot be the principal prayer.
Yes.
Well, that is, my lord, the page 87, annexure page 87, paragraph 5.9. That is, I mean, explain.
That there you have challenged the there that is not a prayer. There you have made out grounds against the lease deed. In fact, you don't have any locus standard to challenge the lease deed also. We won't decide that here.
I respect submission.
Your right accrued much subsequent to the lease deed. So at that point of time, you are a nobody when the lease deed was granted. Who are you to challenge that?
Since, my lord, my right has been increased.
Post facto, you are affected by that.
Not only that. Not only that. My lord, the predecessor was the recorded Borgadar. After the land is vested, my lord, the land has been settled in our favor.
Anyway, Mr. Mathi, we are not interfering.
Lord, the only things for a moment. Only things for a moment.
Moment has passed.
No, Lord, let the consideration of the application along with this order.
How can it be? It is different authorities which are considering these.
That's why come before lordships. That's why come before lordships.
Come before wrong lordships. No, Mr. Mathi.
Otherwise, my lord.
This would be too much.
Otherwise, my lord, things, my lord, if my lordships kindly appreciate. If I am again come before this honorable court or tribunal to dispose of this application, then what will happen?
That's a serious threat. But if you come, we'll see. We are afraid of that, but if you come, we'll consider it. Then we'll pass again similar orders. Maybe.
No, my lord, this is the two separate.
You come as many times as you like, Mr. Maithri. We love to see you, but in this matter, no.
Lord, apart from that, Lord says only my.
Whatever, whenever you want to pass an order,
I am not.
apart from that, you complete all your arguments. When you start dictating, you won't say a thing. Yes. Apart from that, what?
Lord, apart from that, these legal points of view, not the only, my lord, the consideration of the representation before the authority. If I come before this read application, that consideration can be done. My lord, the things for women, what is the proceedings relating to the started from the a lease deed. A lease deed, fair for lease. They have paid for on the basis of the lease deed. Now we have paid for the cancellation of the lease deed. Things for women. Maybe the separate authority. The ADMLR is the highest authority, and ADMLR can interfere this matter, all the things.
You cannot even say under which provision you went before the ADM and DLR. We don't find any provision for cancellation of deed under the Land Reforms Act. We don't find any provision. We don't know. Our lack of knowledge does not mean there is no provision. But you are the advocate. You tell us under which provision you have challenged. You're not even being able to say that.
Challenging. I'm not challenging. I'm not.
Under which provision did you file this representation? You have challenged the lease deed, yes. The caption of your representation says, মহাশয় কর্তৃক গত such and such তারিখে রেজিস্ট্রিকৃত লিজ দলিল বাতিল করিবার জন্য অত্র দরখাস্ত. This is an application for cancellation of the lease deed. Can you do it before the same authority?
That was also annexed before the tribunal also. Tribunal not interfering, not to pass any observation in this.
We see, Mr. Maithri, we are being very candid. We, between ourselves, don't know of any provision under which you can approach the DLLRO to cancel a lease deed. Show us the provision. Show us the provision. In this act, we don't find anything of that sort. Now, see, section 49, this regime under section 49, that chapter is there. We understand that.
That is to
49 is regarding this part, the principles of distribution of land. All of us know chapter 6 and all. That is on a different footing. That there you have to go to the revenue officer, not the DLRO.
If your lordship kindly appreciate to that things.
If you say lease is also a settlement, a distribution of land, then also you have to go before the PLLRO, not the DLLRO.
No, she's the lease granted by the collector, not by the
collector.
authority.
So show us under which provision it was granted and under which provision.
That's why application made.
Mr. Maithri, please, we don't have infinite time. You tell us the provision under which this representation.
I come back again.
No, don't come back.
Will I come back again?
Come back, definitely. Every day you come back.
No, with the provision, my lord.
Not with the provision.
If I find.
No. We can't search out for provisions after the matter is over.
My lord, the only thing, so that's only the point.
The present challenge has been preferred against an order whereby the West Bengal Land Reforms and Tenancy Tribunal has directed a proceeding under section 49 within bracket 2 of the West Bengal Land Reforms Act 1955 to be taken to its logical conclusion. First of next para, learned counsel for the petitioners argues that the petitioners approached the tribunal with the grievance that a lease deed executed in favor of their private respondents here. Lease deed, the lessees, they are not parties. Lease deed executed in favor of third parties on September.
School.
School can also be a party. Please, on September 7, 1998, on the premise of which the patta granted in favor of the petitioners is being sought to be cancelled, be set aside. First of next para, it is submitted that an application, a representation was filed by the petitioners before the concerned ADM and DL and LRO within bracket collector bracket closed for cancellation of the said lease deed. Full stop. However, the tribunal, without considering such fact and stroke or without directing such representation to be disposed of first, merely observed that the section 49 within bracket 2 notice should be taken to its conclusion. Full stop next para, learned counsel places reliance on the representation annexed as Annexure P6 to the present writ petition and submits that the same ought to be decided first, comma, since it would have a direct bearing on the adjudication under section 49 within bracket 2 initiated by the impugned notice. Full stop. Next para. What is your designation now?
I'm
Counsel for the state.
Counsel for the state.
Very
Only A category.
Learned counsel. A cannot be a designation. Learned counsel for the state, because every matter we don't know the new panel who is who. So,
Only counsel for the state.
Mr. Bhattacharya only we have come to know because he's
He is-
allocated
he is-
allocated him. Learned counsel for the state opposes the contentions and submits that the purported representation dated September 23, 2019, challenging the concerned lease deed was filed after issuance of the impugned notice dated July 3, 2019. Full stop. Next para. As such, comma, it is argued that the said representation cannot be a deterrent for the BL and LRO, for the SDO to conclude the proceeding initiated by the impugned notice. Full stop. Next para. Upon a perusal of the materials before us, comma, we find that the state is justified in submitting that the representation dated September 23, 2019 itself was filed by the writ petitioners subsequent to the issuance of the notice dated July 3, 2019, comma, which was substantially impugned before the tribunal. Full stop. Next para. Thus, comma, pendency of the said representation cannot vitiate the notice itself. Full stop. Even otherwise, comma, the notice dated July 3, 2019 was issued in accordance with law, comma, coming within the purview of section 49 of the 1955 Act, and comma, as such, comma, cannot be faulted on such count. Full stop. Even otherwise, comma, the notice was prima facie justified in view of the existence of a prior lease deed dated September 7, 1998, comma, in the teeth of which the patta was granted in favor of the writ petitioners in the year 2017-2018. Full stop. Hence, comma, we do not find any scope of interference with the impugned order, whereby the learned tribunal merely directed the proceeding under section 49 within bracket 2 to be concluded. Full stop. Even otherwise, comma, on the query of court, comma, the petitioners failed to apprise us as to under what provision the representation dated September 23, 2019 was given to the BL and LRO. Full stop. Next para. Taking into account the above, comma, we are not inclined to interfere with the impugned order. Accordingly, WP LRT 127 of 2026 is dismissed on contest, comma, thereby affirming the impugned order dated March 19, 2026, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA 1464 of 2021. Full stop. No orders to cause urgency. প্রথমেই affidavit size filed. Thank you. Next. শুভকমলের ভাই হবে।
Expedient disposal of the possession. Last order.
Opposite.
Opposite. On a record correction, regarding record correction, I have filed an application.
Right. The innocuous prayer made in the present writ petition is early disposal of OA 1796 of 2024, bracket LRTT. Which of next para, upon hearing learned counsel for the parties, comma, we find substance in the prayer. Full stop. Accordingly, WP LRT 128 of 2026 is disposed of by requesting the first bench, comma, West Bengal Land Reforms and Tenancy Tribunal, comma, to dispose of OA 1796 of 2024 within bracket LRTT, bracket close, pending before it, comma, as expeditiously as possible, comma, preferably within 8 months from the date of communication of this order to the tribunal. Full stop. All concerned shall act on the server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance. No arrest to cost, urgent certificate.
Get,
প্রথমে affidavit size file to be kept.
my lord, get evidence service, I have
Pardon?
Evidence service,
Yes, you have record.
get.
Whoever is, please give your names. Whoever is appearing with you,
I'm sorry.
all your names.
I'm sorry.
25 Lordship, I am for the applicant led by Mr. Somashri Shah, Lordship. He is on a virtual mode, Lordship.
He is
He is on virtual mode.
My lord, I am appearing for the private respondent.
Your Lordship, I am for the petitioner, Your Lordship.
Right. What is the matter?
Yeah, Your Lordship, I have filed this writ petition against an order of WPLRT Tribunal, Your Lordship. The order was passed on 3rd February. Your Lordship, the dispute arises from a walk-off property. The petitioner was a Mutawali and he was removed by a resolution dated September 17, 2019, confirmed on 14/12/2019. Against this resolution, we have filed an appeal before Waqf Tribunal, which is Appeal 1 of 2021, which is pending before the Waqf Tribunal. Now, in the meantime, BLRO has passed a notice in the year 2021, which is at page 18, Your Lordship. Which is at page. Your Lordship, kindly come to page 18.
Page 18.
Your Lordship, 1 second.
Page 24.
24C.
24A, that is annexed.
24, Your Lordship, it's 24C and 24D.
24C, yes, exactly. We thought so.
Yes. This is the BLRO notice, Your Lordship. These two are the BLRO notice. Now, Your Lordship, when the notice was passed, we have made a application before the Waqf Tribunal, where we have prayed for stay of the application and also addition of the party of the BLRO, addition of party as BLRO as a party. Now that application is at page 25. Your Lordship, from 25 onwards, these are the applications.
Addition of party of the BL and LRO.
And challenge and the stay of the notice.
Stay of the
as
notice.
The appeal was
Waqf
stay of the
Tribunal
notice.
Waqf Tribunal has the authority to stay the notice under section 57.
Now, Your Lordship, as the petition, as the appeal was pending over there, that's why we have filed it. Now the petition is also pending over the Waqf Tribunal. It has not been adjudicated.
So what do you want now? Yes.
The main point is the private respondent has also filed an objection over there.
Did you want early hearing of those?
No, Your Lordship, the matter is, Your Lordship, now they have challenged this notices of the BLRO. The notices which is annexed as 24C and 24D before the LRTT tribunal.
Who has challenged?
They have no, the private respondents.
Private respondents have challenged, yes.
They have asked for the action to be taken in accordance with the notice of as annexed in 24C and 24D. But in their application, they have not mentioned any about the appeal is pending, about the application which I have challenged before the Waqf Tribunal. There is nothing mentioned in the application, Your Lordship. They have suppressed the fact fully before the LRTT Tribunal. Now, there is another point, Your Lordship. On the first day of hearing, I have appeared for the petitioner, who is the private respondent in the LRTT Tribunal. But on the second date, due to the incorrect recording of the dates by the clerk, I have missed the date. But on the second date, the order has been passed. Immediately, within a limitation period, I have filed an recalling application. But the tribunal has refused to hear the recalling application.
Ms.
My
Dey, how
main,
are you aggrieved with this order? This only a
I am
direction on
aggrieved
this.
with, I am aggrieved with this order. My main point is, Your Lordship, kindly allow me to file an opposition in the LRTD tribunal to
Opposition
bring
to
the
an
facts
early,
before.
they want only early disposal application, right? They want
Yes.
early disposal, rather early disposal of that proceeding under initiated by that
Yes.
notice. We
But the
understand
appeal,
wait a minute. We understand your contention that your challenge to that notice itself before the tribunal is still pending, which they have
yes,
suppressed. Now,
yes.
who prevents you from moving your challenge before the tribunal, cite before the tribunal the pendency of this proceeding, and you just approach the tribunal, walk of tribunal, and ask for an expeditious disposal of that stay application.
Your Lordship,
Nobody prevents you
that
from do that. Nobody
Your
prevents
Lordship,
you.
but Your Lordship, in accordance to this order, BLRO has already passed a notice. The next date of hearing is on 21st.
You appear on the date of hearing and you can point out always Ms. Day to the BLLRO saying that
We
an
have,
application
Your
challenge you
Lordship.
do that. But we
We
don't
have,
find
but
any illegality per se in this order itself, direction. It's
but
an
Your Lordship,
innocuous direction.
kindly allow me to file an opposition before the LRTT, Your Lordship.
LRTT, there is no scope of any opposition to an early hearing application. Sorry.
Your Lordship, there has to be points to be taken before the LRTT tribunal because
For
this has
early
been
disposal,
passed.
they have asked only for early disposal, no substantive order. There need not be raised any point of objection to that. There is no scope of objection to that. On merits, every question is kept open. You can take in the LRTT hearing as well as before the walk of tribunal, everything is kept open. Whatever arguments you have to make on law, make before those forums. And we'll
Your
make
Lordship,
it clear.
LRTT
We can make
tribunal,
it
the matter has been disposed of.
exactly. There was no scope of filing any objection to an early disposal application. Your objection, if any, can be taken pursuant to that notice in the hearing before the BLL. Take that objection. There also you can point out that it's pending, a challenge is pending before the tribunal, walk of tribunal. And you can also move early disposal of your stay application before the walk of tribunal. We'll make it clear, subject to hearing Mr. Dhol, that this order does not prevent you from expediting your walk of tribunal stay application as well as taking all these points before the at the hearing also. We'll make that clear. Mr. Dhol will do that. Because we cannot enter into the merits at this stage on behalf of either of you. Yes.
Because they have only directed for early hearing of the application pending before the BLL.
You asked for that, but Ms. Dey's point is that you suppressed
They have taken the matter since 2022. They have kept the matter pending before the work of tribunal without moving any applications. This is the
No, we from 2021 we are moving applications. I have the case records, Your Lordship.
Mr. Dhol says from 2022 you have kept pending. You're dealing the matter and you improved that by saying from 2021.
No, Your Lordship, because of their interferences, we have to file several applications. Because of their interferences, Your Lordship.
We are not entering into those things. Yes. Yes.
Your
Yes,
Lordship, kindly
whatever you
record
said,
that
we'll
they
do.
have
Yes.
they have suppressed the facts before.
We'll record your
LRTT tribunal.
submission that they have suppressed the facts. We'll not record that they have suppressed the facts.
We have made the board a party. My lord, I have got the door. It has not been, my lord. My lord, the board has been made a party.
In your
they have
application,
represented.
board was represented.
Yes.
What was the stand of the board, Mr. Dhol?
My lord, they
Private
have
restaurant?
stated. My lord, kindly see 5 and 6 is the board. Walk of board.
No, board is one in your application. Board is one.
My lord, kindly sees.
One is board of.
My lord, learned advocate Ombika Chatterjee.
Oh no,
Anamika Chatterjee appeared for the respondent number 5 and 6.
Yes. What was their stand?
My lord, actually, they are not standing in the way of, my lord, early disposal of the matter. The question of suppression, my lord.
Learned counsel appearing for the writ petitioner submits that by the impugned order, the West Bengal Land Reforms and Tenancy Tribunal directed expeditious disposal of hearing in connection with a notice under Section 57 of the West Bengal Land Reforms Act 1955 issued to the present petitioners. First up, it is argued that the present petitioner was the erstwhile Matwali of the concerned Waqf estate, and by a resolution dated September 17, 2019, confirmed on December 14, 2019, the petitioner was unlawfully removed from the said post, challenging which an appeal has been preferred and is pending before the Waqf Tribunal. Full stop. Next para. Learned counsel contends that suppressing such developments, suppressing such facts, the private respondent herein moved the original application before the Land Reforms and Tenancy Tribunal, seeking expeditious disposal of the hearing on the Section 57, 1955 Act notice. Full stop. It is argued that the present petitioner ought to have been granted an opportunity by the tribunal to file an objection to point out such facts. Full stop. Next para. Learned counsel further submits that before the Waqf tribunal, the petitioner has also taken out two applications, one for impleadment of the concerned revenue officer within bracket block land and land reforms officer bracket closed as a party, and another for stay of proceedings in connection with the notice under Section 57 of the 1955 Act. Full stop. It is argued that without such applications being disposed of, the BL and LRO ought not to have been directed to expedite the disposal of the hearing from the Section 57 notice. Full stop. Next para. Learned counsel appearing for the private respondent controverts the allegations and submits that the appeal has been kept pending before the Waqf tribunal by the writ petitioner for over 5 years, since the year 2021. Full stop. It is contended that mere pendency of the said appeal for an indefinite period cannot be a ground for the hearing on the notice under Section 57 of the 1955 Act to be stayed. Full stop. Next para. Upon hearing learned counsel for the parties, we find that by the impugned order, an innocuous direction has been given to the concerned BL and LRO to dispose of the hearing, the proceeding in connection with the notice under Section 57 of the 1955 Act issued to the petitioner. Full stop. Next para. Nothing in the impugned, apart from the fact that the Waqf tribunal, Board of Waqf tribunal was represented.
Waqf tribunal was no.
Waqf tribunal, Your Lordship.
That the Waqf tribunal was also, apart from the fact that the Waqf tribunal itself was represented before the Land Reforms Tribunal when the impugned order was passed,
Your Lordship, it will be Board of Waqf has been represented before the tribunal.
that is what I asked you. Tribunal could not be.
No.
Tribunal was, the appeal is pending before the tribunal. Board of
No,
Waqf
that
is
is different. That
Board has been represented.
apart from the fact that the Board of Waqf was represented before the Land Reforms Tribunal when the impugned order was passed, nothing in the impugned order precludes the writ petitioner from seeking expeditious hearing of the writ petitioner's application for stay and or addition of party pending before the Waqf tribunal and or from raising all questions, both on law and fact in support of her defense, on the strength of her erstwhile matwaliship, before the BL and LRO in the hearing in connection with the notice under Section 57 of the 1955 Act. Full stop. Next para. As such, there is no scope for interference with the impugned order. Accordingly, WPLRT 129 of 2026 is disposed of on contest without interference with the impugned order dated February 3, 2026, passed by the first bench, West Bengal Land Reforms and Tenancy Tribunal in OA number 1136 of 2025 within bracket LRTT bracket closed, with liberty to all the parties to ventilate their grievances and raise their contentions at the hearing before the BL and LRO, concerned BL and LRO, as well as before the Waqf tribunal in the appeal pending at the behest of the writ petitioner. Full stop. No orders to cause urgency report.
Affidavit service can kept in the record.
Prathame affidavit service filed to be. Thank you. Thank you. All questions kept open.
Grateful, Your Lordship.
Thank you.
My lord, I beg to appeal.
We are on behalf of the private respondent.
Private. State. You. Yes.
My lord, this is unlikely previous matter, but there is some Before the tribunal, we are not made a party to the proceeding. But may I give the factual aspect of the matter? The predecessor of the private respondent filed an application for correction of record of rights in 2006, my lord. That was decided in their favor. Challenging the vendor of the present petitioner filed an appeal. The appellate court set aside an order and directed to restore the Khotiyan. The proceeding pursuant to that, a misproceeding was initiated in 2011, my lord. That was disposed of. The predecessor of the private respondent filed an original application before the tribunal.
Against that appellate order?
No. They went before the tribunal seeking disposal of the proceeding. The matter was taken up in 2012, but somehow or other, due to communication gap, whatever it is, the proceeding was disposed of in 2011. However, the learned tribunal had been pleased to pass an order directing to conclude the proceeding.
But by then it was already
disposed of.
That proceeding was under which provision?
Proceeding for compliance of the order passed by the appellate authority. In 2017, a proceeding afresh was initiated.
Why?
That is not known to me. That was not within my knowledge because we have purchased the property pursuant to the order passed in compliance to the order of the appellate authority. In 2017, a proceeding was decided in their favor, surprisingly.
Decided in their favor. There was already an order of the appellate authority.
Appellate authority decided, set aside the order, and directed to restore the Khotiyan in favor of
your vendor.
In our vendor.
And then a proceeding was initiated to implement that.
That was, no proceeding was disposed of.
Yes, proceeding was disposed of in what manner? Dismissed?
No, proceeding was disposed of restoring, holding that the Khotiyan to be restored.
So virtually implementing the appellate
Implementing in the vendor of the present petitioner.
Then our question is, how could another proceeding be initiated?
That is one aspect.
So what happened to that proceeding?
That proceeding has been decided in their favor. That was not.
In what manner?
Decided in manner, our Khotiyan has been deleted and their name has been directed to be recorded.
Must have been a different proceeding initiated by them.
No, in compliance to the, I'll show, my lord. In compliance to the order passed by the tribunal in the way which was decided in 2012, the actual issue was decided in 2011.
It was already decided. Since tribunal directed, it was taken up afresh and redecided.
No, tribunal, it was tribunal kindly turns to.
Tribunal passed the order that proceeding was already disposed of.
No, tribunal said a report was filed. Tribunal said it is not appearing from the report whether the proceeding has been decided and directed to conclude the proceeding. Nobody bring into the notice of the learned tribunal that the proceeding has decided prior to the taking up of the
matter. That is what we are saying. When the tribunal passed that direction, the proceeding which was directed
by the appellate authority, that was disposed of. But since that was not brought into the notice of the tribunal, tribunal somehow or other directed to conclude the proceeding. In 2017, the issue has been decided in their favor. Challenging that has come to my knowledge after the filing of the writ petition. Challenging that appeal has been carried out by the predecessor vendor. Whether that appeal is pending or not, that is not in my knowledge today itself. I have asked my client. In 2018, the property has been transferred in favor of the present writ petitioner. Thereafter, we filed an application for mutation, and today itself, my lord, that is in our name, my lord. The thing is that since our name has been recorded, the mutation proceeding, that is an appealable order. In 2017, now in 2022, a proceeding once has been initiated for compliance of the order passed in 2017. And they have preferred the application in 2025 for conclusion of that proceeding. My humble submission, since we are not made party to the proceeding before the learned tribunal, we didn't get an opportunity to take all these points.
So you say this should be set aside and you have to, you directly...
Their remedy lies, their remedy lies subject to kind correction,
But
my
we
lord.
can give you a right to be heard by the authority where this is pending.
My lord,
Along with the
advisory,
same-
my lord, right, kindly appreciate one
What
thing.
is the use of your being heard by the tribunal? Tribunal has merely directed a pending proceeding to be disposed of.
Disposer mana how,
Tribunal
my
could
lord, my lord, kindly appreciate
See,
the
tribunal
how.
could not pre-decide
This-
whatever is
my lord,
pending.
actually, all these things we didn't have the opportunity to bring into the notice of the tribunal.
It's
because
their application for early disposal of a particular pending application.
application.
If you nod your head once more, we'll allow his application.
That is why at the outset, Mala said this is unlike a previous one, but there is something different. Mala,
No,
that
no,
is
we
an
are saying-
appealable
we
order.
are
Kindly
saying-
appreciate our
Whatever points you have, please take before in the hearing. We'll direct you to be heard by the authority where that their subsequent application. Point out everything there that these are the prior proceedings. This has happened. Point out everything there. What is the use of adding you and
including
reinitiating the process before the tribunal? That will be only prolixity, only multiplicity of litigation.
I do appreciate, Mala, kindly make that observation,
We'll make that
including
observation, yes,
including
subject
the
to notice.
appeal, pending appeal. Mala, I can give the number of the appeal because I am not in a position to appraise this court whether the appeal is pending, what happened to
No,
the
but if
appeal.
you don't know the number, how
No,
can
no, I know the number. I have got the.
you get yourself implemented there, apply there for being implemented?
My lord, kindly make an observation. The
So we
pending.
cannot give you a blanket charter to
No,
be
I can
implemented
give the number
everywhere.
of the appeal, my lord. I have got the copy of the appeal, my lord. One kindly appreciate this.
Maybe, but
Because one kindly appreciate a order
that is beyond the scope of our this writ petition. This writ petition is challenging only the direction of the tribunal to dispose of a pending proceeding pending at their behest
may I make
for
one humble
implementation of a prior order.
My lord, may I make one sir? The way that I have submitted, subject to kind correction, my lord, kindly record this. Otherwise, well, because I have said that my name has been recorded by following a mutation proceeding. That is an appealable order. But kindly make that observation. Otherwise, that should not be considered before the BLL, my lord.
No, why do you say that? We don't understand this.
My lord,
you can take
we
this
have
point
purchased-
before the authority where their petition for implementation is pending also.
That is in 2022. Our
Whatever.
name has been recorded prior to that, my lord.
You
Today
take this
itself,
point before the
this is an appealable order. That is an appealable order, my lord.
They have not preferred any appeal.
But kindly appreciate one of them. They have not preferred we have purchased the property and got
You
our
have
name.
got yourself mutated.
Yes,
but could you get yourself mutated, sir? Could you get yourself mutated in the teeth of the order of the previous order of the appellate authority?
Yes, my lord. The previous order of the
No,
appellate
not the
authority.
appellate authority. The subsequent order. The
Subsequent order, that
says-
is, my lord, that is why at the outset, my lord, I have said
Then you
my lord,
have
that
to
that
go and
is
challenge. Your vendor did not challenge. You did not challenge.
no, the appeal at the instance of the vendor, my lord.
No, that appeal is long over, past.
But 2018 appeal, no, 2018 appeal. My lord. I have got
First
the number from the. I got a.
You are not
copy of-
letting us speak. How can you expect
Sorry,
an
my
order from the court?
Sorry, my lord.
If
Sorry.
you go on speaking, then you please pass the order.
Sorry, my lord. I tender my unconditional.
Initially, there was a challenge to the recording of their name. They sought a correction in the record of right, which was granted to them. Against that, your vendor preferred an appeal. If you understood you correct,
Yes.
Their predecessor. Vendor preferred an appeal. The vendor got a favorable order in the appeal. Subsequent to that, that order was sought to be implemented by your vendor. That implementation application was pending. Subsequently, it was disposed of also. But in the meantime, an application had been filed, an OA had been filed asking for an early disposal of that. The tribunal, under the mistaken notion that it was still pending, directed it to be disposed of. But by them, it had already been disposed of. However, pursuant to the direction of the tribunal, another proceeding was initiated that went against your vendor.
My lord.
For implementation of that against order, they have preferred an application subsequently. That application is now pending.
Yes, my lord.
That application is now pending.
So that notice we have not received, my lord.
But you said that application they have preferred.
No, I have got from the original application because the original.
Say it, we learn only from you. They have not opened their mouth as yet.
2022 the proceeding initiated.
Forget the dates. The chronology is whatever you said. Now, in the meantime, on the strength of your title deed from your vendor, you have got your name mutated. When will we pass it? Yes, what do you say? We'll permit him to. Will direct him to direct the authority to hear, give him an opportunity of hearing also.
Yes, sir, Lordship, already
Been given.
Sir, the issue inquiry, Lordship. Inquiry was issued.
Which page?
Lordship, kind. 25, Lordship.
No, I have annexed.
These are frivolous applications. Why do you file these applications? You go and contest there. If you lose there, then come up in appeal and then before.
No, I have disclosed anything. The notice.
The notice
directed to conclude the compliance proceeding being
Miss PT case number such and such, appearing in such and such in the
Page
instant
23 is the notice.
hearing all the interested parties.
Already notice is issued.
Then
Page 23, Lordship.
what is your name?
Yes, my lord.
25 is the.
Your name?
Your name.
Client's name?
My name.
Ruhul Amin and others.
Ruhul Amin and others.
Ruhul Amin is not one of the notices.
Serial number 9, OP.
Ruhul Amin. Yes.
Page 23.
Yes, yes. You are one of the notices also.
Yes, my lord. That
But
is
taking
absolutely.
points there. It has only been directed to be disposed of quickly. That proceeding has been directed to be disposed of.
Correct, Lordship.
2022
Why
proceeding
don't
that
give
has
us the
been
entire
released.
story then? You are a notice, you go and point out your facts before that authority, BLL. The present challenge has been preferred.
Page 25
Yes,
is the
yes.
inquiry.
Yes,
Inquiry. Page 25.
The present challenge has been preferred against an order whereby the West Bengal Land Reforms and Tenancy Tribunal has directed a proceeding initiated under Section 57 of the West Bengal Land Reforms Act 1955 to be disposed of expeditiously within 3 months from the date of communication of the order. Full stop. Next parallel, counsel for the petitioner submits that the private respondents herein, the predecessor interest of the private respondents herein initially took out an application for correction of the records of rights, which, being granted, an appeal was preferred by the vendor of the present writ petitioners. Full stop. Such appeal succeeded, thereby setting aside the order obtained by the private respondent's predecessor and directing the names of the vendors of the petitioners to be restored. Full stop. It is submitted that thereafter, an application for implementation of the appellate authority's order was taken out, which was subsequently disposed of as well. Full stop. Next para. Meanwhile, an application was taken out before the West Bengal Land Reforms and Tenancy Tribunal for early disposal of the implementation application. Full stop. Although the implementation application had already been disposed of at the relevant juncture, the tribunal, under the mistaken notion that it was still pending, directed it to be disposed of expeditiously. Full stop. However, pursuant to such direction, a fresh proceeding was initiated, which turned out against the vendor of the writ petitioners and in favor of the private respondents. Full stop. Next para. In the meantime, the present writ petitioners purchased the property from their vendor and had their names mutated in the records of rights. Full stop. Next para. Learned counsel for the petitioner submits that such order of mutation is an appealable one, and no appeal having been preferred against the same to the knowledge of the appellant petitioners, the mutation cannot be negated by the notice under Section 57 of the 1955 Act. Full stop. Next para. Learned counsel appearing for the private respondents as well as learned senior counsel, standing counsel for the state point out that in the impugned order of the tribunal itself, the proceeding initiated by the notice under Section 57, where one of the notices, where the present writ petitioners were also some of the notices, was merely directed to be disposed of. Full stop. Thus, it is argued by the respondents that the writ petitioners can ventilate all their grievances in the said proceeding itself. Full stop. There is substance in the contention of the respondents. Full stop. Next para. By the impugned order, the tribunal merely directed expeditious disposal of the proceeding initiated by the notice under Section 57 of the 1955 Act. Full stop. Thus, it would be premature both for the tribunal and this court to advert to the merits of the contentions raised by either of the parties, which would tantamount to pre-deciding the issues pending before the concerned revenue officer within bracket BL and LRO bracket closed in the proceeding initiated by the Section 57 notice. Full stop. Next para. Thus, we do not find any illegality in the impugned order. Full stop. However, we make it clear that all points urged before us shall be open to be contended by the writ petitioners in the hearing in the proceeding under section 57 of the 1955 Act, full stop. Similarly, comma, the respondents and all interested persons shall, comma, in consonance with the impugned order of the tribunal, comma, shall be at liberty to raise their contentions in connection with the said proceeding as well. Full stop. With the above observations, comma, WP LRT 130 of 2026 is disposed of without interfering with the impugned order dated December 22, 2025, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 1071 of 2025. Should be with LRTT within bracket.
Yeah. Yes, ma'am.
Within bracket LRTT. That has been missed out in the certificate. Within bracket LRTT. No orders to cause urgency. Thank you. All points are open. Next. Give your appearances, please, all of you.
Lordship.
Yes.
My lord, I beg to appear in this matter.
Yes, sorry.
My lord, for the petitioner.
Yes.
My lord, but it has been served. But so for the private respondent party is concerned, my lord, it has not been turned out in the article tracking report.
Then,
my lord, I beseech the lordship, 2 days so that matter can be taken.
next week. Learned counsel per the petitioner submits that the private respondents, that the service on the private respondents is not yet complete. So accordingly, let the matter stand adjourned till July 20, 2026, next Monday.
20?
July 20th. 20th July is next month.
So can
next.
Lord, I appear for the petitioner.
Should Yes. Yes, Mr. Bhagat, what is it?
This is the affidavit of service, my lord. My lord, I have challenged the order.
What happened to you? Medical emergency on the last occasion?
My lord, I
Nothing
had a
serious?
pacemaker
Whose?
in 2016, myself.
Oh, so what happened to that?
In 2016.
That was creating some problem.
No. Validity is expiring in December 2026.
So now you have it changed?
Yes, it is renewed just.
Yes, sir.
Bolo?
23.
28. 28 so. ও আচ্ছা আচ্ছা সরি আপনি আছেন তো আচ্ছা
Yes.
My lord, what happened?
Mr. Bhattacharya is posted in this code now.
Yes.
Three persons are constants in this code. Him and us. Everyone else changes. The air codes change and even court officers, sometimes one of them is absent. Mr. Bhattacharya and all three Bhattacharyas will be.
Constant.
Yes. Yes, Mr. Bhattacharya.
I have challenged, my lord, the order passed by the appellate authority under 54. My lord, that was section 5 application was, my lord, dismissed. On the ground of, that is the inordinate delay. This
Section 5 in connection with the appeal.
Appeal before the DLLR. And whatever that order was challenged before the landed tribunal, LRTT. They have, my lord, also dismissed that application.
What was the delay? Long delay?
What is the merit of the case, my lord?
No, how much was the delay?
Delay is, my lord, too much. 11 years in the sense, my lord, this honorable court passed an order directing us to file a return. We filed it, my lord, in 1994. They took up this matter in 2008, my lord. They took 14 years to consider my return. And what happened, my lord, this delay is not attributed to me because, my lord, that they passed this order without informing, my lord, without issuing notice to us, and also against the dead person. This proceeding was initiated against my father, who died, my lord, long ago.
When was the order passed?
Order
Order
the appellate authorities.
The first order, which was revenue
Yes,
officer.
that is appellate authorities order.
No, the order which you challenged before the appellate authority. When was that?
Yes. My lord, I'm giving the
delay was in challenging that only.
Yes.
So when was that?
Yes, I'm giving.
That order you are saying was passed in the name of a dead person.
That was passed in 2008, 16th May 2008. 16th May 2008.
Your return was considered by that order.
Our return was not considered.
Return form B or what?
7AA. That was filed, but without considering that return, they vested my land.
By this order of 2008?
Yes. We have also made objection to that. They did not consider. Thereafter, we filed an appeal, my lord. That appeal was dismissed on the ground of inordinate delay in filing.
When did you file the objection?
Objection filed, my lord, giving the.
You filed the objection after the vesting.
After the order of vesting was passed by the BLLRO. That is the order authority of first instance.
So you filed an objection after that.
After passing of the order.
Objection with whom? The BLLRO
BLLRO itself, because no notice was given to us. That order.
No notice and dead person.
Yes.
So when did you file that objection, Mr. Bhagat?
Yes, giving.
Meghnad Babu? Meghnad Babu?
Objection at page 47A, 10th May 2018. Page, 10th May 2018.
Why did you wait for 10 years?
My lord, it was not known to me. We came to know after there was whispering that patta will be issued to the landless person. Then we came to know about this order, my lord. We have, my lord, mentioned all these things in our.
So you preferred the. Then what happened after the written objection?
They did not, my lord, consider my objection. Thereafter, we went to, my lord, LRTT, challenging that order.
When was that order? Give us the dates.
Yes, yes, I am giving the date, my lord. 15th November 18, we preferred the way before the LRTT. 15th 11 18.
Why it was not considered at all? Way objection was not considered.
Not considered. For objection was not considered.
On not considered or rejected.
Nothing remain pending.
So way filed in 2018.
Then, my lord, the tribunal directed us to prefer appeal. We preferred appeal.
When did the tribunal direct you?
Tribunal directed on.
So where disposed of?
Yes, were disposed of on 15th 11 18.
Acha, on that day.
On that day. Then, my lord, we prefer appeal on 21st June 2019 after obtaining the certified copy.
Very well.
Along with Section 5 application on the same.
That was rejected against that you preferred.
That challenging that.
So the main delay is between 2008 and 2018.
Yes, yes, sir. That is.
Your ground is that you never knew because no notice was served
upon us.
And it was passed in the name of your father who was deceased by then.
Deceased by that time. I have also stated in the objection. My father died in 13.
How did the tribunal deal with this? Let us see.
Kindly see. That is the last order or the.
Let us see. Start from the start backwards and go backwards.
That is, my lord, certified.
Last order generally considers the previous order.
Yes, yes. My lord, that is the OA 2965 of 2023 and order dated 23rd December 2025. Your lordship got it?
Yes. Certified copy we're looking.
Yes, yes. View of the tribunal is starts from, my lord, page 3, internal page 3 of the order.
Mr. Bhattacharya, the only difficulty is none of their averments in the Section 5 has been adverted to even. Only the general proposition of law, Supreme Court law, that decision, this decision. What about the facts of the case? Because Mr. Bhagat, because just like we asked him, these are the first questions which would arise in your mind, anybody's mind. Nothing is adverted. If the dates were narrated and the tribunal disbelieved, we could have found some ground. Because this will be an illusory remedy now before us, because tribunal did not decide. We are thinking aloud that we should remand it to the tribunal to advert to the facts of the case made out by him, and then to decide.
Before that,
yes, that is, we opened our mind, but you have your say. Yes.
No, my lord, the petitioner or, my lord, the predecessor of the petitioner, they are basically, my lord, a habitual defaulter in performing, my lord, the court's order. First, my lord, the in 1994, a writ petition has been filed, which is bearing number CO/CR number 14766W of 1994.
Page 33.
Wherein this honorable court directed them to file the 7A form within 4 weeks. Now, my lord, this 4 weeks ends on 26th of October 1994, though they have filed on 29th of November 1994, though there is only 1 month delay. Now, my lord, kindly come to the second round of litigation. Now, my lord, in a proceeding which is, my lord, bearing number 190 of 2008, my lord, kindly come to page 44. It is this basic averment that though they have appeared in the first day of the proceeding, but no notice was served upon them. So, my lord, they could not follow the proceeding. I'll show, my lord, the section 5 application also.
Not that it was never served on them.
No, they have appeared. It is their case that they have appeared, but they couldn't, the authority could not inform the next date. That is the reason, my lord, they are departed from the proceedings. Only on the 2018, they came to know that the proceeding has been disposed of.
Years were not impleted. Years
Sir,
of-
I'm the বললেন, আমি তো তখন
Point
কিছু
of-
বলিনি। Now, my lord, kindly come to page 44.
We are there.
Note of action taken on order. My lord, find the signatures.
Page 44.
Yes, page 44, my lord, annexure P5. 10th March order, my lord. 10th March order.
Page 44 is something else in our.
Inner page 3, my lord. I'm on.
No, no. Pagination is different. No, no. 10th March?
10th March 2008.
Oh, it is page 45 in our. Very well. One page different. So next page.
Now, my lord, at the right hand side, my lord.
Yes.
So right hand side column, my lord, find their signature. And my lordship knows very well that this is the usual practice in the proceedings of before the BL and LRO, that instead of serving the formal notices, they used to sign there in the order sheet itself, endorsing that sin. So, my lord, it is the, my lord, specific point taken before the tribunal, and also, my lord, find from the observation of the order of the tribunal that this particular point that has been meticulously considered by the appellate authority. Now, my lord, this case disposed of on 16th of May 2008. Thereafter, my lord, 10 years they remain silent.
This was initiated against. It is their signature only, not their father's signature.
Yes. Yes. Now, my lord, kindly come to page 50. Page 50, order dated 15th of November 2018.
Pages are varying by 1 page, so 51 in our.
51, my lord.
Whatever, yes.
My lord, at the bottom, the applicant are directed to communicate the present order to authority concerned before whom they intend to prefer an appeal within a month from the date of certified copy of this order. So tribunal gave them an opportunity to prefer an appeal. My lord, this 1 month, my lord, it ends. My lord, they obtained a certified copy on 4th of January 2019. So they ought to have filed the appeal within 3rd of February 2019, but they preferred the appeal on 21st of June 2019. Thereafter, my lord, the authority concerned considered all this fact. My lord, kindly come to page 74. this entire conduct of the applicant and the noting in the record that was considered by the appellate authority, and then only appellate authority refused to entertain the appeal.
Where is the appellate authority's order?
Page 74,
Not telling.
75, maybe.
No, not that also. It ends at page 72. Enough.
Annexure P9, Malad.
P9.
P9.
P9, page 63. Where are the missing pages?
Sorry, Malad, it is mispaginated.
Let us come to page 63, yes.
Now, Malad, on 19th of July 2019,
yes,
the appellate authority refused to entertain the Section 5 application. They preferred the application before the tribunal. Next page. On 9th of January 2020, the matter was again remanded back to the appellate authority with a liberty, my lord, to amend the Section 5 application. The next page, my lord, kindly see the amended Section 5 application.
Why amendment? To incorporate what?
It was, my lord,
deficient.
Deficiency explanation was deficient.
As we do here. Similar.
Then, my lord, that opportunity was also given to them. Now, my lord, kindly see the Section 5 application, which is at page 78.
Yes.
My lord, what is the paragraph 2? That your applicant received the notice case number such and such, which was issued in the name of the deceased father and appeared before the respondent number 2 on 10th of March 2008 and prayed for time to submit necessary document and for hearing of the said case. That the respondent number 2 allowed the prayer and adjourned the hearing of the said case for the said date, that is on such and such, but the respondent number 2 did not inform the applicant the next date of hearing.
Who is respondent number 2?
Respondent number 2, my lord, the BL and LR. So, my lord, I shown to your lordship, my lord, this order dated 10th of March, where your lordship find the signature of the applicants.
So they admit that they, although it was in the name of the deceased father, they received it and appeared.
Yes. And from, my lord, since 1996
yes,
to till date, my lord, they are not a diligent, my lord, litigant. And considering all this fact, my lord, find from the impugned order, well, I'm just 2 paragraphs, though there is much more explanations or my lord, the observation of the tribunal, but 2 paragraphs. First paragraph, my lord, the present application is directed against the order dated such and such, whereby appeal preferred by the rejected at the threshold on the ground of limitation, the appellate authority having declined to condone an inordinate delay for more than 11 years. The applicant assails the said order contending inter alia that the original proceeding of 14T3A of the West Bengal Land Reforms Act 1955 was conducted against a deceased riot without substitution of the legal heirs, and therefore the entire proceedings to...
No, the third paragraph of that page 2 is deals with the adverts to that.
And yes, it is not in dispute that also.
That paragraph you read.
So, my lord, since, my lord, the conduct of the applicant, my lord, from since 19...
So this we find even from their own application, it's admitted that.
Yes. And, my lord, I have showed to your lordship, my lord, that in the order before the prescribed authority, they have signed. Now, my lord, they are taking that the proceeding initiated against my against the deceased person. But they appeared, they signed the... So, my lord, my submission, my lord.
Yes, Mr. Bhagat, what do you have to answer this?
My lord, kindly see. Firstly, he pointed out that we, my lord, communicated the order of Honorable Justice N.K. Mitra after expiry of long time. That is not, but my lord, that time took for the obtaining of certified copy, my lord.
Forget it, you admit in that page, the amended section 5.
Yes.
You admit that it was in the name of your deceased father, the notice.
My lord,
but you appeared.
My lord, kindly see the notice at page, my lord.
This is your total explanation is between paragraphs 2 and 4 of that.
My lord, kindly see the notice they issued, which we could not, at page, my lord, 41, annexure P4.
Mr. Bhagat, we are not satisfied with paragraphs 2 to 4 of your amended section 5. Please come to that. Whichever page, your page 78 probably or page 66. Please read paragraphs 2 onwards.
That your appellants received the notice.
Your appellants received the notice which was issued in the name of deceased father and appeared
Yes.
on such and such, which is also evident from your signatures.
What happened? Only
No, let us
pausing for a moment.
and prayed for time to submit necessary documents and for hearing of the case.
Yes, ma'am.
Respondent to allowed the prayer and adjourn the hearing of the said case for the said date. But this respondent number 2 did not inform your appellants the next date of hearing. That your appellants tried the level best to know. For 10 years you could not know. After 10 years you came to know. Is it credible?
And thereafter, my lord, kindly consider this aspect also, that the cost title remained in the name of the deceased person.
Maybe.
Our name was never, my lord, substituted.
You appeared in the proceeding.
No, my lord, there are other years also. My lord, kindly seize the notice.
You cannot take this point, Mr. Bhagat. You appeared there.
Yes, my lord.
You appeared, you signed the order. After that, you are not informed of the next date.
But my lord, what happens, my lord, in the office of BLR, what happens, my lord? My lord, clients are approaching the authority. They never, my lord, informed.
Could have written to the BLR, we could have moved any other authority.
My lord, unless and until we, my lord, get informed of the, my lord, next date, we cannot approach the superior authority, my lord.
You
because
could have, yes, you definitely.
Pending before.
No, Mr. Bhagat, we disagree with you on this.
And my lord,
if the next date was not being informed to you,
yes,
nothing prevented you from making an application before the BLR or giving a representation. Give me the next date. If not given, then you could move the tribunal.
My lord, actually, practice in the office is this, my lord.
Your practice cannot validate your 10 years.
My lord, they will not be prejudiced because, my lord, patta has not been issued. The land is in our position, my lord. What happened, my lord? If this section application,
justice will be prejudiced.
No, nothing will be. My lord, kindly see, they, my lord, they sat over for 14 years after getting.
Forget them. They are not preferring this appeal. You are preferring the appeal. You have to explain.
My lord, what I am saying, my lord, we have furnished the return. They did not consider it till date, my lord. My lord, as such, we are prejudiced because, my lord, we are entitled to retain this land. But they have based
it remains that the order was passed on March 20. The order was passed in 2008.
Yes, my lord.
16th of May 2008. And you are preferring the appeal in 2018.
But, my lord,
2019.
We have, my lord, explained what is the, my lord, delay, my lord, due to our we are suffering from ailments and other brothers are staying elsewhere.
In this application, where is that? Here is we find a section 5 application.
My lord, kindly.
No explanation between 2008 and 2018.
My lord, I am just
only you tried to know, but you are not informed.
My lord, kindly seize our objection. In our objection, we have stated everything.
We are looking only into a section 5 which was considered and rejected. Yes, my lord, brother is correct. Please, if you come to page 46, we don't know what in your page, in your copy what page. Subsequent to this 10th of March, 31st March of 2008,
yes,
notice was directed to be served on all concerned. Next order says notice duly served. Then only it was proceeded with. So presumption of correctness attached to official and judicial records. No, Mr.
But, my lord, kindly seize the notice was issued in the name of dead person. That is admitted fact.
Whatever.
And, my lord, that about they will not be prejudiced because, my lord, the land.
See, notice is not the plaint of a suit, Mr. Bhagat. You have to understand that. And even if the notice was issued in the name of a deceased person, but the heirs appeared and contested the proceeding, then, Mr. Bhagat, we cannot say that that is a nullity.
That's right.
Sorry, this is the notice cannot be constituted to be a plaint of a suit.
That apart, my lord, because, my lord, our land has been declared vested, though we are entitled to retain it. That is the, my lord, kindly
on the merits.
Kindly consider in the merit, my lord.
No, we cannot. Now we cannot. All the more, you know, there are several judgments.
Our valuable land will go to. For
your valuable land went how many years back? 2008. Calculate.
18. That not gone yet to go, my lord, because we are possessing this land.
No.
And on the ground that it is not irrigated, that is the point merit, my lord. Kindly consider the merit of the case, my lord. Only on the point of, my lord, delay and not on the merit, my lord. And they are, my lord, saying what they are.
No, the present challenge has been preferred against an order passed by the West Bengal Land Reforms and Tenancy Tribunal, whereby the tribunal affirmed an order passed by the appellate authority dismissing the appeal of the petitioners on the ground of limitation after consequentially upon dismissal of the connected application for condonation of delay in preferring the appeal. So next paragraph, learned counsel for the petitioner submits that the petitioner's predecessor in interest father filed their return under section 7 capital A double A in 1994. Next para, a proceeding was initiated under section 14T within bracket 3 capital A bracket closed of the West Bengal Land Reforms Act 1955, which culminated in the land of the petitioners being vested by an order dated May 16, 2008. Next para, subsequently a written objection was filed thereto, which was turned down. Next para, thereafter, an original application was filed, was turned down, was not being disposed of. Next para, subsequently an original application was filed before the tribunal, upon which the tribunal, vide order dated November 15, 2018, dispose of the said application by granting leave to the petitioners to prefer an appeal against the original order. Consequent thereto, the appeal was filed bearing RA number 14 of 2019, which in connection with which the condonation application was filed and was dismissed by the appellate authority, giving rise to the present proceeding. So next para, learned counsel submits that the original order of vesting suffers from palpable illegality in view of no notice having been given on the petitioners and the same being passed in the name of a dead and the same being issued in the name of a dead person, that is the petitioner's father. Next para, learned counsel submits that the elaborate grounds set out in the section 5 in the application under section 5 of the Limitation Act was never considered by the tribunal in passing the impugned order. Learned senior standing counsel appearing for the state controverts the submissions of the petitioner and contends that the petitioners have been habitual defaulters, Initially, upon obtaining an order passed in a writ petition in the year 1994, section 7 capital AA form was filed by the writ petitioners only on October 26, 1994, although only on November 29, 2019, although as per the order of the writ court, the same was to be filed by 4 weeks from obtaining the certified copy, which ended within 4 weeks, which ended on October 26, 1994, 2019. Apart from the delay on such count, even subsequently, the matter traveled to the tribunal, when a fresh opportunity was given to the petitioners to prefer an appeal within a month of obtaining the certified copy of the order dated November 15, 2018. Although the certified copy was obtained on January 4, 2019, the appeal was filed only on June 21, 2019, with the application under Section 5 of the Limitation Act. Even thereafter, the matter traveled to the tribunal, whereupon leave was granted to the writ petitioners to file an amended condonation application. Next para, learned senior standing counsel submits that even from the condonation application, it would be evident that the writ petitioners appeared in the proceeding under section 14 capital T within bracket 3 capital A bracket close of the 1955 Act. From the order sheet thereof, it would be evident that the order dated March 10, 2008 was duly signed by the writ petitioners, thereby indicating their knowledge of the said proceedings. Thus, no plausible explanation for the huge delay of about 11 years in preferring the appeal was furnished, comma, due to which both the appellate authority and the tribunal rightly rejected such condonation application. Full stop. Next para, we find from the amended application under section 5 of the Limitation Act filed by the writ petitioners themselves before the appellate authority that admittedly they had appeared before the BL and LRO in the proceeding under section 14T within bracket 3A bracket close on March 10, 2008, comma, which is also borne out by the signatures of the writ petitioners appearing in the order sheet of the said date. Full stop. Next para, even thereafter, comma, from the order dated March 31, 2008, passed in the said proceeding, comma, we find that the BL and LRO directed notice to be served on all concerned, fixing the date, next date of hearing on April 8, 2008 at 11 a.m. Full stop. Next para, vide order number 4 dated April 2, 2008, comma, it is seen that the notice that the BL and LRO recorded that the notice was duly served. Full stop. Subsequently, the matter was taken up for hearing on April 8, 2008. That is the assigned date. And thereafter, the BL and LRO proceeded to decide the matter. Full stop. Next para, hence, comma, even from the materials annexed to the present writ petition, comma, it is crystal clear that the writ petitioners had full-fledged knowledge of the proceeding under section 14T within bracket 3A bracket closed, being case number 190 of 2008, and appeared in the said proceeding. Full stop. The plea that the notice was issued in the name of a dead person, comma, that is the deceased father of the writ petitioners, comma, is specious, SPE, specious, comma, since a notice under the concerned provision cannot be construed to be a plaint, construed on a similar footing as a plaint in a suit. Full stop. A notice is merely intended to inform the interested persons as to the hearing to be undertaken by the revenue officer. Full stop. In the facts of the present case, comma, despite the notice having been issued in the name of the deceased father of the writ petitioners, comma, by appearance in the said proceeding, comma, the writ petitioners participated in the same and cannot be permitted now to do a volte-face and resile from that position, comma, challenging the veracity of the notice itself. Full stop. Next para, even from the subsequent orders passed in the proceeding as narrated above, comma, we find that there is ample evidence that notice of the next date of hearing was duly served on all concerned, comma, including the writ petitioners. Full stop. Next para, the presumption of correctness attached to such officials to judicial records has not been rebutted by the writ petitioners in any manner. Full stop. The meager explanation for the delay given in the amended section 5 application was that the BL and LRO adjourned the hearing of the case but did not inform the writ petitioners the next date of hearing. Full stop. Next para, such contention, comma, however, comma, is belied from the records of the BL and LRO in the said proceeding as indicated above. Full stop. Even otherwise, comma, it was for the writ petitioners, comma, who actively participated in the proceeding at the inception, comma, to take appropriate information of the next date, and not the duty of the BLLRO, comma, at every step, comma, to give fresh notices to the participants therein. Full stop. Next para, in the event the writ petitioners had any grievance regarding the next date not being informed to them, comma, nothing prevented them from writing to the BL and LRO specifically asking for the next date, and, comma, if no reply was received, comma, to approach the tribunal to have their grievance ventilated. Full stop. Instead of doing anything of that sort, comma, the writ petitioners cozily waited, COZILY, cozily waited for a decade before approaching the authorities. Full stop, next para. Even after leave was granted by the tribunal to prefer the appeal, comma, the appeal was not preferred within the period of 1 month from obtaining the certified copy, but about a month thereafter. Full stop, next para. From the materials before us, comma, we find that the writ petitioners were not only lacking in furnishing appropriate explanation for the long delay of 11 years in preferring the appeal, comma, but were negligent at each and every stage of the proceeding. Full stop, next para. Thus, comma, since the tribunal adverted to the arguments of both parties, comma, and as this court agrees with the conclusion arrived at by the tribunal, comma, there is no scope of interference merely on the ground that all the submissions made in the condonation application by the writ petitioners was not specifically enumerated in the impugned order in detail. Full stop. Next para. In such view of the matter, comma, we do not find any illegality in the order of the tribunal or that of the appellate authority in dismissing the condonation application of the writ petitioners and consequentially dismissing their appeal bearing RA number 14 of 2019. Full stop. In such view of the matter, comma, WPLRT 73 of 2026 is dismissed on contest, thereby affirming the order dated December 23, 2025, passed by the second bench, West Bengal Land Reforms and Tenancy Tribunal in OA 2965 of 2023 within bracket LRTT. Full stop. No orders to cause service. Sorry. প্রথমে affidavit of service একটা Yes.
Mr. Banerjee, yeah, my learned friend is appearing for the appellant.
Oh, he's on the appellant. Yes.
My lord, this is a writ petition preferred by the state. My lord,
Yes.
what has happened? My lord, initially, if my lord Bigrat case was initiated and this section 10(2) notice under Estate Acquisition Act was served. My lord, the notices were challenged such notice by preferring a writ petition in the year 1975. My lord, on 29 June 1979, the section 10(2) notice was stayed, and my lord, the Honorable Court was pleased to direct the authority grant liberty to the writ petitioner to make a representation before the authority, and authorities were directed to conclude the proceeding and ascertain as to whether the land which the 10(2) notice claimed to be vested in the state, the such question has to be decided by such proceeding. My lord, such order was, my lord, there is no such stipulation that the such order was complied with. So, my lord, in the year 2011, the petition, my lord, applicants preferred an original application before the tribunal. My lord, on the tribunal, after query, my lord, a report was submitted before the tribunal, which is at page 48. My lord, in that report, it was specifically submitted that the original BR case records could not be found. So, my lord, the direction stipulated in the Honorable High Court's order
West Bengal Estate Acquisition Act. Yes.
in the year 1979, that it seems that it has not been complied with. So, my lord, in the year 2012, that Honorable the Learned Tribunal was pleased to direct the BLLRO to Ramnagar 2 to complete the BR case within 1 month, and with a stipulation, my lord, a failure would attract a penalty for ₹500 per day. My lord, thereafter,
Please repeat the last question before 500. Directed to
complete the BR case within 1 month, and if there is
was directed, the authority.
The PLLR Ramnagar 2 was directed to complete the BR case, and a failure would attract a penalty of ₹500 for each day.
Payable by the BLLR.
Payable by the BLLR.
That was the tribunal's direction.
Yes, ma'am. My lord, thereafter, my lord, the proceeding was initiated, and my lord, on my lord, is Miss Case number 1 of 2013. and 2012, my lord, I stand corrected, my lord. And in that, in this order, which is at page 51, my lord, in the order number 3 on 25th January 2012, which is at page 53.
Yes.
It has been mentioned that the old case records have been found, and on the basis thereof, it was stated that the my lord, in the next page, subsequently in determination made in 5A proceeding number such and such in respect of transfer of such and such, the scheduled total area of retained land was changed to such and such. And accordingly, the retained 3.65 acres of plot number 533 of Mouja such and such remained vested. So total area of 9.13 acres of plot number 533 of Mouja such and such remained vested. My lord, thereafter, what has happened? My lord, again, my lord, in the year 2015, a proceeding was, my lord, the
In
present.
these matters, please prepare a list of dates. It's not very difficult to retain everything in the memory. I mean, you are arguing, we are taking up so many matters throughout the day. Retaining every fact in the memory, you have come prepared, but we cannot prepare ourselves in such.
I found
It's very difficult because you are going on and on. Therefore, there's a long history. Why don't you just prepare a? You should that should be the first reaction of any advocate on this. At least 10 facts you have mentioned. We are not supposed to remember all these things. So, where did this end? I mean, it's come to the end now.
My lord, in 2015, the applicant in original application preferred an application.
Use the microphone.
My lord, the original application was preferred.
Against what?
My lord, praying for supply of the certified copy of the proceeding. My lord,
proceeding, the previous proceeding.
Yes,
or this proceeding.
But this proceeding, my lord, the prayer is at page 33, prayer of the original application. My lord, paragraph 8, relief sought for. Please to pass an order directing such and such to supply the order and certified copy of miss case number 12 of 2012 arising out of such and such. My lord, what has happened then? Your lordship may kindly come
12
to.
of 2012, this is which proceeding? The BR case original?
Yes, my lord, which is at page 51, which I have just referred to.
Right.
This certified copy of that proceeding was prayed. My lord, what has happened? My lord, now my lord may kindly comes to the impugned order.
Miss case number 12 of 2012. This is miss case number 1 of 2012. Page 51 is miss case number 1 of 2012. Not 12. In the prayer portion, they have asked for miss case number 12 of 2012.
That may come back after making a list of dates.
Better.
My lord.
Because he is not posted with all the facts. Yes, sir.
Mr. Shah, it would be better. We'll keep it next Monday because tomorrow, day after, we'll be taking a hearing.
Yes.
You please give a copy of the list of date to him also. So that if he has anything to say, he can, your learned friend can come prepare.
Here your lordship.
No, any other date?
No.
What is his difficulty? He'll have to face the client, not you.
On 20th, my learned friend has some difficulty.
21st?
21st.
No, 20th.
20th is difficulty.
21st, you're giving?
21st.
In view of the long narrative involved, learned counsel for the parties are requested to come with list of dates and exchange the same between themselves prior to the next date of hearing. The matter be posted for hearing under the same heading on July 21, 2026.
Here, in this case, your lordship has to use a thumb rule. Otherwise, this matter cannot be disposed of. But I have gathered, unless a thumb rule is there in law, they are saying record is missing.
Oh.
Reconstruction not possible. I think face hearing has
thumb rule as in thumbs up or thumbs down?
Whatever. I think face hearing should be taken and order may be passed so that I can, if I am
missing,
according to them.
So this arises from your application for that certified copy, which
Yes.
could not be given.
No.
That is the premise. So you start backwards. That will be easier.
Face hearing.
Why place the entire facts then? The grievance is that you applied for certified copy, that was not given, you moved the
In
original.
spite of the tribunal repeated order, there cannot be supplied.
Could not. So last order of the tribunal is to
Said that my land has been vested by the order.
so what is the impugned order here?
You restore it.
Oh, because they could not produce it.
Yes. A face hearing may be done and order may be passed.
Why you retain the order? They should.
May I
return
come
it.
with the facts? Then you'll also see what
You can't produce the records, Mr. Bhattacharya, for over years.
Very fairly, I say, my lord, I am unable to understand why the state preferred this application, my lord. Kindly take it up.
When was it filed?
Pardon, my lord?
When was it filed? Before election or after election?
Before election.
That's why you are not
Otherwise, my lord, I will not never suggest.
Is a list of date necessary? We are just passing the order, right? As very come. We'll entertain ourselves because when we require some relief, we'll go into the details and ultimately pass whatever order we're saying we'll pass. Come back. Yes, 47. Your expression changed, Mr. when you came to move the matter. You are laughing behind. Now you have become nothing in the matter. There is something in the matter.
Well,
Initially,
I have served. Again, I have served. This is the
private respondent. They are appearing. The state
there is no private respondent.
State is appearing.
Okay.
No, you have to get accustomed to the new faces. Yes.
Well, what it happens, your lordships kindly to see determination of sealing under section 14T3. A proceedings being case number 32 of 1984 was initiated. And the said case number 32 of 1984 was dropped initially. By taking reliance upon section 14T3A, a review proceedings was again initiated. And the case number is 29 of 1991. And the authority under the specified act allowed to retain 8.65 acres of land and 3.46 was vested to the state. Challenging the order of these vesting proceedings, I have filed one writ application before constitution of the tribunal. The single bench of this honorable court set aside the entire proceedings by giving reliance upon the Paschim Bongo Bhumijibi Sangho's judgment. Your lordships can look to see the High Court's order at page 59. Entire vesting proceedings quashed.
Everything quashed.
Quashed. Now, challenging this order of this single bench, state preferred a mandamus appeal before this honorable division bench, and the said appeal being MAT number 3472 of 1997 was also dismissed.
The color of this writ petition has undergone a transition from red to green to saffron. Yes.
By order dated 13th November 2003, Division Bench of Calcutta High Court dismissed the appeal of the state.
So this is affirmed.
Affirmed. Now, page 60, we have filed a representation before the concerned block land and land reforms officer for correction of the record of rights because the land still retains in the vested schedule, Khotiya number 1.
Yes.
They have failed to do so. For consideration of these representations, we have preferred this original application before the tribunal. Tribunal ultimately dismissed my application because since the Bhumijibi Sangho's matter is still pending before the Honorable Supreme Court, so we'll have to dismiss it. My humble submission before your lordships is that pendency of SLP is not a bar to follow judgment under reference. On this point, I am relying upon my lordships.
Yes, Mr. Bhattacharya, what is your stand in this matter?
No, my lord. Here is, my lord, the
before going to the,
yes,
we'll give them opportunity after ascertaining your stand.
My lord, what happened, my lord, the order passed by this honorable court, which was affirmed in the mandamus appeal, that order, my lord, solely based on the basis of the judgment of the Bhumijibi Sangho. My lord,
Yes.
this is not an independent order deciding whether the applicant have a land excess ceiling limit or not. Since the Bhumijivi Shangha matters was decided, in view thereof, my lord, that this
But
honorable.
there are judgments of the Supreme Court which your learned friend will also be
Yes.
relying on, which the Supreme Court itself says that mere pendency of an SLP or a proceeding or a reference even cannot be an excuse for the High Court not to decide matters.
But
High Court has to follow the last position of law.
But the core issue of this application.
Core issue will remain ever pending. It's pending before the Supreme Court for decades.
My lord, those points were taken care of in the judgment, in all these points.
What points?
This pendency of the Supreme matter before the Supreme Court.
In several judgments, those were taken care of.
And also, my lord, the implied stay, since there is no specific stay in the matter, but when the main issue pending before the Honorable Supreme Court.
That's a coordinate bench judgment of this court.
No, my lord, the coordinate bench judgment of this court is in favor of my learned friend.
Which bench? Your judgment is of?
No, my lord, the Supreme Court, the tribunal relied on Supreme Court judgment.
Judgment impugned in
That's
this.
the judgment of the Supreme Court which you
Judgment impugned in this application.
Then we'll let him complete and then come. Yes.
Now your lordships can look to see.
Niranjan Mahota?
No.
You have got the judgment.
Your lordships can look to see the.
You have got that also.
I know, my lord, I was 25 years I'm standing that side.
Yes. Your lordships kindly to see internal page 7 of the judgment of the tribunal. Para 5. Next. Applicant's arguments of binding precedent. Applicants argued a judgment remains binding unless set aside.
1 second.
Correct proposition.
1 second.
Internal page 7. Last certificate. May I don't order?
Judgments are passed in this form nowadays.
This is something.
It's the first matter where we are seeing this form. Page 7, yes. Under item 5.
Item 5.
Yes.
Applicants argued a judgment remains binding unless set aside. Correct proposition, but incomplete.
Yes.
And ultimately dismiss this original question with a rider that you will have to approach again when it has been disposed of by the SLP before the Honorable.
Reasoning we don't find any very cryptic. I mean, it's very stylish, but still cryptic.
My lord, your lordships can let to see on this
like
point.
Some of our judgments. I mean, we give
your lordships can let
headings and there are ornaments in the judgment, but no substance.
Now, on this point, my lord, your lordships can let to see 2013 volume 14 SEC 782 para 4.
Yes.
Now, next same proposition 2013 volume 2 SEC.
No, what is the let us see this.
Lordship.
4, para 4.
Para 4. Head note is sufficient.
Right. Yes. Para 4. And the next one, para?
13-2 SCC, page 41.
Page 41.
Page 41, paragraph 24.
Same proposition.
Same proposition.
Right.
And the next is 2004, volume 3 SCC, page 619. Para 13. Para 13.
Yes.
And your lordships, this is the last 1992, volume 3 SCC, page 1, para 10. Even after passing these vesting orders, they never distributes his land. Possession still in mine. I am cultivating this, but land is shown as Khotiyan number 1.
Bhumijivi is pending since when?
1996.
This is the reported decision, 1996, volume 2 CLJ, page 285.
1997, 1416 of 1997.
This is my humble submission.
Could you record an observation in order that It is expected that that should be decided early by the Supreme Court.
No, while
High time we do that.
my lord,
High Court start doing that.
my lord, while Justice Dotto sitting with division bench, Justice Dipankar Dotto, same matter, he has commented strong comments regarding one
Sitting
WPT
there or
matter.
here?
Huh?
Sitting there or here?
Yeah.
Here.
Here.
Yes, yes, we are also intent to
Yeah,
do so.
22 years have lapsed.
Absolutely. Every other day,
You have initiated vesting
Judgments-
proceedings, distributes the land.
judgments are being passed by Honorable
Lots-
Supreme Court against
Your
us.
lordships kindly to do something.
Hey, limited. No, but না অফ করবো কেন আমি তো ওপেনলি বলছি আর কিছু পাবো না মনের মতো রেখে দিন but that is besides the point but we can make that observation all the same but is that germane for this matter Mr. Bhattacharya you cite your judgments for judge you have brought
But,
I
so
think
for
that
example, I will submit a written notes of argument. in
after
this.
preparing mandamus appeal, this
No,
appeal
because
is
what yes he's right he has a point
Absolutely.
why should the adjudication wait for Paschim Bangla Bhumijibhi
Malad,
it has never come
One thing, Malad, there is a basic difference. Some of the matters wherein Malad after this Bhumijibi Shongo case, Malad, the 14th
see it's pending for 3 decades before the Supreme Court. We cannot wait indefinitely for the Supreme Court to decide on this issue. Sorry.
But Malad, Lordship kindly appreciate our predicament, Malad.
What is your predicament? You go by the law, whatever Justice Mitra has held affirmed by this court. You are bound by the division bench judgment. We are bound by a coordinate bench judgment unless we
But Malad,
differ and
the
differ.
judgment delivered by this honorable court, Malad, in
Quashed,
earlier,
everything quashed.
not earlier round of litigation, that was not an independent judgment. That is, kindly see the
If the
judgment.
judgment is independent, it may rely on a proposition laid down in some other matter.
No, Malad,
Justice
when the
Mitra's
main
judgment relied on a proposition of law, Mr. Bhattacharya. It relied on a proposition of law which was settled by some other judgment. That proposition of law still stands. Paschim Bangla Bhumijibhi, is there any blanket stay on Paschim Bangla Bhumijibhi operation?
There is, Malad, there is a Malad,
By the Supreme Court. Let us see that judgment. We are interested in that only. If it is held
Malad,
by the
as
Supreme
Malad,
Court,
kindly come to page inner page 3 of this order, Malad. Inner page 3, where Malad,
yes,
Malad, at the middle portion,
yes.
the Bhumijibi judgment is stayed and tagged before the Honorable Supreme Court. It is submitted that civil appeal number such and such was preferred against AFO. The Supreme Court in IA 3 dated 20th of March 1998 state the operation of the impugned judgment.
Mr.
But that has not been set
that
aside.
order was placed before us because we have dealt with Bhumijibhi and we have also taken the view your learned friend is saying. Categorically, these judgments were not so many judgments were cited before us, but we independently took the same view that we cannot wait indefinitely for the Supreme Court to decide on a matter. If that reference is kept pending, very well. Thank you.
Malad, kindly
very
give me
well.
whatever Malad Lordship desired to
But we are telling you, Mr. Bhattacharya, because this will create a chaos here.
I understand, Malad. Now I tell you, Lordship, Malad, in our High Court, in Niranjan Mahato.
This order was probably placed before us. I'm not sure. But this is a very limited stay in a
Malad,
context.
though my learned friend has not placed, Malad, but in our.
I've got a copy of this order. This just
I
take
will-
out
I
a
will
copy of
collect.
this order.
I will
Collect a
collect.
copy of this
I will
order.
collect.
That was in a limited context.
In
Probably.
Niranjan Mahato case, our High Court in 2008 specifically held that mere grant of stay is so long, Malad, this order has not been set aside. This ratio of
Your
the judge.
admission of SLP does not mean that.
Yes.
That is well settled. No judgment is required.
No, Malad, considering the Bhumijibi case.
Bhumijibi, we are telling you there are several judgments we have dealt with in a division bench. We have dealt with this matter.
Yes.
Bhumijibi, we have decided elaborately on Bhumijibi every facet of the matter.
Hello.
I don't recollect the judgment.
Malad, with utmost respect, Malad, against the Niranjan Saha, SLP has been dismissed.
That was dismissed. I know. আমি বলছি আপনাকে আমি তো অস্বীকার
He's saying in your favor only. Yes.
But this is the situation, Malad. Let me kindly allow me to
You bring these orders because these were the 3
I
orders
will
relied
bring
on.
Malad the order as well as Malad the judgment which was relied on by the tribunal by way of written notes of argument, Malad. Lordship kindly
Did
consider.
not file written notes of arguments. You just if you want, you can file written notes. No difficulty. Then very well. Then exchange copies of the written notes.
Kindly give me this weekend, Malad. I will
Yes.
prepare.
Yes. Learned counsel for the petitioner argues at length by relying on several judgments of the Honorable Supreme Court. Whose of next para, learned senior standing counsel, appearing for the state, seeks to file a short written notes of arguments by annexing the relevant orders stroke reported judgments. Accordingly, on the prayer of the state, the matter is adjourned till July 21, 2026, Fusab, an advanced copy of the written notes of arguments of the state shall be handed over to the learned advocate for the petitioner. Affidavit of service filed today be kept on record as well. Develop. Thanks. Not permission. Should you keep it? You only file the written notes or take 5-10 minutes?
Only file written note.
But 5-10 minutes maximum. So to be mentioned, we are keeping it under to be mentioned. To be mentioned.
21st.
21st to be mentioned.
Regular.
Yes. Mr. Banerjee, you are for the, yes, 6 to 8.
Yes.
6 to 10. Private respondent.
Private respondent.
Yes, Mr. Hodacha.
6 to 10.
6 to 10.
Sheikh Firoz, our client, but there's the agreement for sale in the year 2005. Agreement with regard to the same property.
Agreement to sell the property to you?
Yes. But that was, the landowner was Sukhdev Prasad Gupta and his 3 sons. And they are the party in this petition. And that suit, since he did not come forward to execute that sale deed, Firoz, he filed a suit for passive performance of contract in the year 2005. And that suit, or a preliminary degree, was passed on 29 January 2008. And final degree was passed 27 July 2012. And sale deed was executed through the court.
Preliminary degree in what suit?
Our suit for passive performance of contract.
Acha. The final the deed was executed in execution.
2012. And sale deed obtained on 3rd August 2012.
All right.
The private respondent, number 10, with other 3 others, and against the Sukhdev Prasad Gupta and his 3 sons, was a pro forma defendant. He filed the suit.
For the convenience of the court, normally we prepare the list of dates. One for the convenience, decorated thought statement.
I also want, my lord. I said, I know.
ততক্ষণ দিস নি কেন? ওটাই তো আগে দিবি। এক গাদা fact. Thought.
Thank you. Yes.
আচ্ছা, খুঁজে পাবো।
কিছু করে
There was a filed a suit for partition, declaration title partition and possession. And that suit was filed in the year 2007. That is title suit number 72 of 2007.
Yes.
And that suit was the suit of private respondent that was decreed on compromise. That's a decreed on compromise on 8th April 2008, after preliminary degree was passed. And in that preliminary degree, there's an order of injunction also, and that was passed ex parte. Now, my lord, on the after that 2007, 72 of 2007, that was decreed on compromise, the private respondent filed an application for mutuing their name.
So, but Chair, we will continue with this matter on the next day.
Yes,
We
yes.
have to rise a bit 5 minutes early.
Yes.
Although the matter is taken up for hearing, due to paucity of time, the hearing cannot be concluded today. Accordingly, let the matter stand adjourned for the day.
For the day.
The list of dates filed.
I have also prepared one as next day I shall hand over.
The list of dates filed by learned senior counsel appearing for the respondent number 6 to 10 today be kept on record.
Yes.
Grateful, deeply obliged.
That justifies your presence, sir.
Yes, we have.
That was the specific purpose.
No. I told Mr. Banerjee also.
That was the purpose of the last night. We never record the list of dates. Mr. Mukherjee.
But 42 is mine. And 42, naturally, it has not been taken up. I am told that these branch of matters usually are not taken up on Wednesdays and Thursdays.
No, not taken up because now we are taking up we are trying to touch the appeal hearings on Wednesdays.
Therefore, my matter.
Not before Monday.
Not before.
Not
Monday.
before.
I'm deeply obliged.
Even if it is taken up before Monday, you are not there, we would consider that.
I told my senior also.
No, my lord, know this story. Justice Torun Chatterjee told me, and a পয়সা ফি পেয়েছিস? Yes, I've got it. My solicitor was very kind. আমার দিল না জানিস এত সহায়তা কেন? You didn't open your mouth, বসন্ত মশাই. Obviously, judge says, "I'll take your seat."
But in one matter.
No, it's recorded in the order now.
Ah.
The release of dates.
No, but in one matter, Mr. Banerjee was my senior. It was Justice Torun Chatterjee. And matter was, that order was dictated. He entered.
Doesn't know the original system. All parties to act. So many councils, they are appearing. One council was outside the court. My lord, all parties to act.
Thank you.